Hello, everyone, and welcome to Immigration and Jobs Talk Show. I'm your host, Sam, and before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. All right, after this very important disclaimer, once again, guys, welcome back to Immigration and Jobs Talk Show. And today we are going to talk about post election impact. What does it mean for non immigrant visa processing in 2025? So, guys, after the election, there are so many questions on everyone's mind, especially for non immigrants. What will the visa process look like? Will it speed up or face delays? And will there be some kind of new restrictions on the H1B visas? And will it become harder for students to apply for F1 visa? And especially for the mass deportation that Trump has told, and it's been a hot topic. But guys, the best thing is that we have an expert for this. So please help me in joining and welcoming an immigration attorney, Kimberley Best Robidoux. So, Kimberly, welcome, and it's a pleasure having you on our show. Please go ahead and tell our viewers about yourself.
Yeah, thank you very much. I'm really excited to be here and happy to see everybody. As you can tell, the sun is rising here in San Diego. So I'm an immigration attorney with WR Immigration. I'm based in San Diego, California. And I have been working in the immigration arena since the early 90s, way longer than I really probably want to care to admit. But it's interesting to see changes over time, as well as how some things in immigration have always stayed the same. So I'm excited to talk with you about this topic, especially given that our election, just ended 2 weeks ago. So it's really fresh in everybody's minds.
Right, right, of course. So thank you so much, Kimberly, for joining us, and it's a pleasure having you. And it was lovely also to hear about you, as obviously you are an expert in this. So, Kimberly, were you expecting Trump to be back in the White House?
We were cautiously optimistic that we would not have a Trump 2.0 administration. From an immigration perspective, what we had seen with Trump 1.0 and then Trump 1.0 with COVID-19 pandemic on top of it was really, really difficult, not only for foreign nationals in the United States, but, for the immigration community as well. So it was a difficult time. And one of the things that we have seen with what was happening on the campaign and different things that were coming out of, the campaign and President-elect Trump himself were things that weren't necessarily going to be beneficial from an immigration perspective, which also would and will have a significant impact on the U.S. economy. And, if I can be so bold as to say the global economy as well.
All right. I think that's a pretty good background that you have shared with us. So, Kimberly, also, I would like to know that not only for like non-immigrant thing, but I would also like to know that how the future of US as a whole will be. Will it be a new era under Trump's administration, or will people will be, having a nightmare kind of thing?
Well, based on, everything that we've read with respect to Project 2025, as well as what we've heard from the campaign and what we saw previously, right, with his first administration, um, it's going to be really hard times. There's some discussion that maybe there might be some benefits to employment-based immigration, but overall, there's going to be a lot of hard decisions that will be made by companies, by individuals, and we're expecting that based on actions that will be taken by the administration. As I think everybody has heard, the call for mass deportation beginning on day one, which will be day one is January 20th. That's inauguration day. So it's about 2 months away. And we're helping our clients, both corporate clients and individuals, be prepared for kind of the worst case scenario of what could happen. As you say, Sam, a potential nightmare. I'm hoping that it isn't as bad as that, but we have yet to see. So what we have been doing is working from the perspective of let's prepare for the worst case scenario and hope that it doesn't get to be that bad.
Absolutely. And Kimberly, also you talked about mass deportation. So I don't know whether it's going to happen or not, but if we look practically, then it is also very difficult, to have millions of people deporting just on a day one. So it's going to be very difficult, not only like for working in a political way, but also it will deteriorate the economy of US too, because there are so many companies of US, who are completely relying on H1B workers. So, how do you think that will this mass deportation will happen, or how the immigrants should be cautious about it?
Yeah, so in terms of mass deportation, you're right, Sam. It's not only very difficult from an operational perspective, but it's also incredibly expensive to deport a lot of people in a really fast period of time. So what we were or what we are expecting that could happen is targeted workforce um, actions, meaning that immigration and customs enforcement would more likely than not conduct worksite enforcements at various companies within various industries that might tend to have a higher population of undocumented, or as the administration likes to say, and some people call it illegal immigrants. There also can be, and more likely will be, a focus on individuals who have criminal records and who are already in the immigration system, so to speak, with respect to having been to immigration court and have been in removal proceedings, have stays of action. So individuals who already are in the quote unquote system would be, a primary target, right? Because they're known pretty much where they're located. So immigration and customs enforcement would more likely than not focus on those individuals first. But what can happen with the raids? I mean, they're worksite enforcement activities. There could be raids. It just depends on how the administration is going to pursue their process for deportation. And as you mentioned, Sam, it isn't just an impact on the individuals, right? It's an impact on the organization, because as if a company loses employees, then that disrupts the business operations. It also has that ripple effect within the community, right? So if there aren't employees that are going to a company to work, then businesses within that area can be impacted as well, right? Food trucks, restaurants won't be getting their customers, grocery stores,
Mm-hmm.
clothing, retail facilities are all going to be impacted as well. And then if you have individuals also working at organizations who have some type of work authorized status, such as, where they're sponsored by the employer in TN or H1B or maybe even O1, their positions could potentially be impacted as well if the organization has to have cutbacks because they're unable to fulfill orders or complete projects timely because of loss of certain personnel that may not have had appropriate work authorization in the US. So those are the concerns, that it's not just the individuals who will be deported, but how that will have a ripple effect throughout the economy and then in communities as well. And if I can just do a public service announcement out there for individuals, specifically in California, where I practice law. Individuals who are not U.S. citizens or permanent residents in the United States might want to make sure that if they have children, that they have some type of caregiver agreement in place, which is they create a legal document in California, and what that does is if they are taken by ICE, this caregiver agreement will provide instructions and guidance to say so and so and uncle friend has the permission to be guardian and pick up my child from school, can help out with finances with the children, etc. So that's like even outside of the scope of what I do, but it's something that I think is really important for people to consider. As heartbreaking as that is, it's one of the ways to become proactive and be prepared for anything that might happen.
Absolutely, absolutely. And thank you so much, Kimberly, for sharing such important information with us. And also, Kimberly, you talked about ICE also. And we know that, Tom Homan is going to lead ICE, and he is a very practical man, and that too very blunt. So he doesn't care about family separation. He's also like against DACA and completely against with illegal immigrants. So do you think that we are going to expect some kind of brutality from Tom Homan's side, or will there be some kind of violent attacks, or like yeah, what it will be?
So yeah, as Tom Homan has said, if it means family separation, then that is essentially not his problem. So I have had that question before. Well, how is it that a U.S. citizen could be deported in respect to family separation? Well, it isn't that the U.S. citizen would be deported. So I'm talking about situations where the parents might be undocumented or not have legal status in the U.S. and they're deported and they have U.S. citizen children. What Tom Homan is talking about is if the parents are deported, then essentially, in order to prevent family separation, the children would want to go, with the parents as they leave the United States. So that's, in a way, that is family separation, but the opposite of what we have seen in the past, right? Family separation, everybody thinks in their mind is people who are coming across the border and then they're detained and the
Right.
families are split apart. This is a little bit different. And I think it's more egregious, right? You're disrupting children who are, or potentially disrupting children in the US.
Absolutely, absolutely. And also, Kimberly, I would like to know that, what kind be there some kind of biggest challenges, especially for non-immigrant visa applicants, that we are going to look in 2025?
Oh, so some of the biggest challenges, I'll do high level, and I'm sure we can get into a little more descriptions, but biggest challenges are potential travel bans. So another public service announcement for anybody who is not a US citizen, we highly recommend if you're traveling during the holidays, which are starting very soon, to make sure to return to the US before Inauguration Day on January 20th of 2025, because we don't know if there will be travel bans or restrictions on entering the United States. So we don't want anybody to get stuck abroad. We can also expect an increase in delays in the consular processing of visa applications for people who need that visa stamp to come to the US. We saw that previously, and the consular posts under the State Department still have not been able to increase their staff to limits pre-Trump 1.0. So they're still working at a disadvantage, which has been essentially, in a way, beneficial in that a lot of interviews for the visa applications have been waived. We will likely see the demise of that policy. So we would expect that every visa application would require an interview at the consular post, which would more likely than not result in delays in the processing of the visa stamps. Some of the other things that we can, expect is backlogs at USCIS here in the United States with the processing of applications and petitions. So those would be, H4 applications, H1B petitions, Ls, like the alphabet of immigration, non-immigrant visa categories, as well as more likely than not an increase in requests for evidence. And we had seen that under the prior Trump administration, where there was a significant increase in those RFEs that were at one point over 40% of petitions were being issued RFEs, which resulted in higher costs for employers and individuals to respond to those RFEs, as well as just delay in the processing of those cases, which in some circumstances can mean a gap in employment authorization, which will have a negative impact on the company as well as an individual's financial situation.
Absolutely, absolutely. So, Kimberly, do you also think that the election results is going to impact on the processing of visas for family members of non-immigrant visa holders, and especially such as dependents on H4 or L2 visas?
Yeah, I do. So in January of 2023, there was a settlement that brought back the bundling of processing of the H1B and H4 cases together, as well as L1 and L2. So what had happened in the past is those principal workers had their cases adjudicated, and then the applications that were submitted for their dependent family members were processed at the same time. And then under Trump point one, that bundling was removed, primarily because for all I-539 non-immigrant applications, such as H4, L2, J2, et cetera, those individuals had to have their biometrics taken, which meant appointments at the application service centers, which resulted in delays because those appointments couldn't be scheduled typically within a premium processing period of time. So we expect the biometrics requirement will likely come back, but will be reinstituted by USCIS. And then that settlement that went into effect on January 25th, I think, 2023, has a 2-year validity period. So at the end of January of 2025, that settlement agreement that required the bundling of the principal employees and the dependents cases together will no longer exist. So more likely than not, given that that will now be under the Trump 2.0 administration, we would likely see an unbundling, right, of those cases. So that will have a tremendous impact as well on the processing for dependents.
Right, right. And Kimberly, also, do you think that the rules for getting H1B or L1 visa could change? And if yes, then is there some certain jobs or industries, that will be more affected than others?
Yeah, so with both of those, we're likely to see an increase in the request for evidence. We also had seen in the prior Trump administration an increase in the scrutiny of L1 applications under company blanket petitions at U.S. consular posts. And so that, coupled with a delay in the consular processing, might result in significant delays in individuals being transferred from abroad to the US within their same corporate organization. The RFEs could also, as I said, have a tremendous impact, which, if those RFEs then result in a denial of the petition, that means a loss of the employment authorization, which could trigger, requirement for the individual and family members to leave the US and then wait until maybe there's another petition that's filed in the US, or there's an appeal, or there's a lawsuit before the person can be brought back to the state. So that's like the really ultimate worst case scenario. And then under the Biden administration, there was a modernization act for H1Bs. And part of that modernization act was already implemented that primarily affected the H1B cap process, as we saw last year, where it became more beneficiary centric, as well as, specific requirements that were needed for the registration process. And that was partly to reduce fraud. The Modernization Act pieces of that weren't implemented were changes to the definition of the H-1B specialty occupation, as well as the definition of employer-employee relationship, which becomes really critical when you're dealing with startup organizations in which the founder is someone who needs H-1B classification. Also, the Modernization Act, which has not yet been addressed, is bona fide H-1B employment, which could be increased reviews by the fraud detection unit to make sure that these H-1B petitions are not fraudulent petitions. And then there was also a cap gap protection and an expansion of cap exempt for certain nonprofit industries. So we have yet to see if the remainder of that Modernization Act is going to go into effect before the end of the Biden administration. And so that's one of the things that we're really closely watching. So we'll wait and see what happens with that. But we do, expect some additional changes with the H-1B program, just as the new administration will tighten the requirements for the H-1B petition. They could also, if they're able to get Congress to act, which might be very viable right now, given that Republicans control both our House of Representatives and our Senate, it could result in legislation that would reduce the number of H-1B visas that are available, which we know is already not sufficient for the workforce as needed by employers.
Exactly. And I can see that, the way you are explaining, it's really great. But I don't find that 2025 is going to be very, smoothing season for H1B workers and also for L1 visas too. But All right, I think with guidance and with expert advice, immigrants can definitely make their jobs and industries better. So, Kimberly, you talked about H1B visa and L1 visa too. So now I would like to talk about F1 visa too. So, how might the new administration's policy will impact the international students who are coming to the US on F1 visa?
Yeah, it's a good question with respect to the students. So, unfortunately, again, I have to say that there could be, backlogs with the consular
Yeah.
visa application process. So that could um, result in delays of the individuals getting their F1 visa stamps that they need to come to the United States. So that's an impact that we would likely see. And then individuals who are in the United States who might be changing their status, for instance, from H4 to F1, there could be delays in the processing of those applications, which would impact when they'd be able to commence their studies at the university. There's also as many, of the people who are watching today, and you might know that there's been a lot of attacks over the last several years, by different organizations. One primarily is the Washington Alliance of Technology Workers, that has been trying to essentially eliminate the STEM OPT extension, and to a certain extent OPT as well. Back in October 2023, our US Supreme Court denied the petition for a writ of certiorari, which meant that they upheld the lower court's decision that said that the STEM OPT stands as it has been enacted through regulatory measures by Immigration and Customs Enforcement. So depending on, what pressures are on the administration and what internally we can see through policies with Stephen Miller, STEM OPT could have could be significantly impacted if the administration or decides that we don't want STEM OPT, or we don't want the full 24 months of STEM OPT. So that is definitely something that we are wanting to look at very closely to see if that will be negatively impacted by any of the administration actions that might happen. And that is something to consider, because the incoming administration is what how they're acting, and what they're saying is essentially protecting the American workforce, and they're protecting the American workforce in ways that will actually harm the American workforce, in my belief, and what I've seen within my immigration attorney community. Because if we don't have essential workers, then that has a tremendous impact on the economy. And as a lot of us probably know, we don't have sufficient American or U.S. citizen and permanent resident workers to actually fill a lot of the positions. We need to educate our youth more in STEM degrees, and until then, we really want to continue to attract the best and brightest from around the world, and have an open environment for people to be able to stay in the U.S. So if H1Bs are negatively impacted, or even TNs for Canadians and Mexican citizens, then I could also see a decrease in foreign national students wanting to come to the United States to universities. So that would have an impact on, like, a decrease in the use of the F1 visa classification, not because of a direct administration action to say, no, we're going to deny the visa application, but rather, the loss of individuals who are actually interested in coming to the US for education and might seek education elsewhere.
Absolutely. And Kimberly, thank you so much. I'm really loving the conversation that we are going through. So, but Kimberly, I would also like to ask you that, we also have interviews with different attorneys, and they say right now that as Trump is going to be back in White House, so, most of the immigrants, they are afraid and they are trying their level best to leave US before Trump's rule. So, are you also getting calls? Are you also been into the situation that you are on people's mind, and they're completely coming to you and they're asking for the help, what to do and what not to do? Is it so?
Yeah, there are definitely a lot more questions
Mhm.
from both individuals as well as from companies, right? So a lot of the corporate clients with whom we work are concerned about losing some, really valuable employees through a
Yeah.
scare of, reduction in H1Bs, the removal of, potentially removal of DACA, as well as TPS, which is temporary protected status. So those are, in our workforce, we still have a lot of individuals who don't have sponsorship by an employer and whose status in the United States could be significantly impacted. So we do have, a lot of calls from individuals who are on DACA or TPS to understand, how does this impact them, right? TPS is at the discretion of Department of Homeland Security. And a lot of the TPS work authorization and designations are valid. Some of them will expire in March of 2025. So there's concern right now, is the Biden administration going to extend those? Will the new administration cut them off immediately? What kind of impact does it have to those individuals, and what alternatives do they have to be able to remain in the U.S. if they decide that they want to remain in the U.S.? So yes, Tim, there are a lot of questions that are being, I guess, thrown at us, and in that sense of, hey, I want to understand what's happening, and I think that's really important for people to have an understanding of where they are with respect to their status and how they could potentially be impacted, so that they could, like companies are doing, plan and strategize and have a strategy to the extent possible ready if we have that worst case scenario. So those are really some key things. Like here in California, we plan for earthquakes. We have our go bag, for individuals, plan for the worst case scenario, a denial of an H1B petition, how would that impact their family life? And then for individuals who are undocumented, as I mentioned, having certain plans in place for caregiver agreements or people who can step in and help out with their finances or what happens to their apartments. And those are some things that, are tangential to losing a job, but it's really important. If you have a U.S. worker, U.S. citizen who loses a job, they can stay here. But if a foreign national loses their job, they more likely than not might have to leave under the Trump administration. So those questions are definitely important. And I think it is important for people to have an understanding of how they can be impacted directly and have a strategy in place.
Right, right, absolutely. And Kimberly, one more thing I want to ask you, that we definitely going through about the U.S. situation, what is happening right now. But here's a question that I want to ask: that there are so many undocumented immigrants also who are living and staying in U.S. So till now they didn't get any time to make their documents clear, or what it was, because that has been quite a long time to prepare their documents. But why is it so much fear around the undocumented immigrants? Because they got time. So why is this that they still don't have the documents?
Oh, so why do people still not have authorization or status in the U.S.? It's a good question. And our bottom line, our immigration system is really complex and it has a lot of flaws. So if you don't mind me giving a little bit of history of
Yeah,
what
sure.
happened. Yeah, so in 1996, under President Clinton, who is a Democrat, we had the last major immigration reform, and we refer to it as IRA. Under that provision, or that act that came out, there was a provision that put in place what we call unlawful presence, meaning if someone is admitted into the United States, they're admitted for a certain period of time. If they stay beyond that authorized period of time without having an extension pending or a change of status pending or taking some action, then they become unlawfully present in the U.S. If someone is unlawfully present for up to for 180 days, but less than 365 days, once they leave the United States, they cannot come back for 3 years unless they can obtain some type of non-immigrant waiver. If someone is unlawfully present for 365 days or longer, then when they leave the United States, they are barred from returning to the U.S. for 10 years, unless they can show that they are they can get an extreme hardship waiver. And those are really difficult to obtain based on the criteria. So we created this undocumented class of individuals who were fearful of leaving the United States because once they did, they couldn't come back for 3 years or 10 years. And that was the only mechanism where these waivers or remain outside of the United States for that period of time. We, in Congress, there was an immigration reform bill that was passed by the Senate in 2013. And then it had full support, bipartisan support by the House of Representatives. But the Speaker of the House at the time, John Boehner, refused to bring that bill to the floor in the House of Representatives because he knew that there was strong bipartisan support and that it would be passed. And then it would be signed by President Obama. And Speaker Boehner did not want any type of immigration reform credit to be given to President Obama. So the bill died. And that was a really good reform act in that it alleviated these 3 and 10-year bar triggers. It also provided visas for what we call guest workers. So for individuals who come into the United States who are in jobs that I would say like US citizens don't normally want to do, right? If there's people in landscaping, construction, nannies, like they're really, really tough jobs, agriculture. So we've created, in a sense, an undocumented population by, those 3 and 10-year bars, which have created problems for people to essentially correct their status. So there have been different provisions put in place that have tried to soften that a little bit, but under a Trump 2.0 administration, those are going to be almost impossible to obtain. And just to answer your question in terms of, well, what about people who've been here for more than, 9, 10 years? Because our immigration system is very limited with respect to visa types that people can obtain. If you have someone who falls into this undocumented category and are subject to the 3 or 10-year bars, it's really impossible to get their status corrected. Again, unless they leave the US and are out for a significant period of time. And then also we don't have visa classifications for a lot of individuals who would normally and are, employed in some really key positions in the US. And by key, I mean those jobs that US citizens might not want to do. So the grunt work types of jobs, so to speak.
All right, I think that's great, because these are the questions that most of the people have in their mind, and they are completely, they get confused what it is. But I think, Kimberly, you were absolutely, it was so good to hear about the history, that why it is happening, and, how they can also work on this. So thank you so much, Kimberly, for your outstanding answer. And I'm really loving this, and absolutely, you are a great speaker, as we all know. So I'm really admiring it right now. And Kimberly, why don't we go ahead and take up viewers' question too, because they are also having a quite a long question. So I'm going to take firstly Cynthia's question. So Cynthia is asking that I am planning to apply for an H1B visa in early 2025. Should I be concerned about new regulations or executive orders disrupting the usual process? What can I do to prepare for potential delays or increased scrutiny?
That's a good question. So I'm assuming that this is in reference to the H1B cap, which would we anticipate that registration will occur in March, as it has since, well, forever. But the registration itself, I mean, for H1B cap in the past, for many years, we had to get the cases in by April 1st. Beginning in March of 2020, we went to that electronic registration process, which we were all skeptical of at first, but it has for the most part worked. So that will be in March. At this point in time, it's probably there isn't enough time, is not enough time to implement a new regulation that would change that particular registration process. The registration fee has gone up to $215 this coming 2025. It was $10 last fiscal year, March of 2025. So that was implemented under the Biden administration, along with primarily all the other fee increases that went into effect April 1st. So it's a significant increase for employers to pay the registration fee. And what could happen are these triggers that would say for H1B specialty occupation, there's a more strict definition of what is a specialty occupation. Or there could be that salary requirement, which means that the salaries that are offered have to be higher. What we use in the Department of Labor's wage survey, there's 4 levels. So it's looking what the prior Trump 2.0 wanted to do was make it essentially level 4, which when you're looking at someone in entry level and getting a level 4 wage, that's a significant increase, and that could discourage employers from sponsoring. So what can somebody do? Work with your employer, right? If you know which employers agree to sponsor under the H1B cap registration, talk to your employer about your concerns of, how is this going to impact us? Employers that work with immigration attorneys usually do work really closely with determining who the company wants to put in the registration. And then a lot of times there's an assessment that is completed to look at, is there going to be an issue with the specialty occupation? If so, how do we deal with that up front, right? What kind of research or do we need to do in order to prepare for that? As well as looking at what is the wage survey, what will be the prevailing wage? And then can a company use an alternative wage survey? So those are the nitty-gritty issues that the company would discuss with the employer. But usually information will be passed along to employees. Hey, there's going to be a change in the H1B cap process, or there's going to be a change in the requirements. So I would say be on the lookout for those potential changes, and they should be addressed or broadcast by the attorneys and the company, but they will definitely, be in the news for sure. There's changes with respect to that. And then also, one of the things that we do is we work with our corporate clients and foreign national employees. Are those we consider last chancers, right? So last chancers are those who, if they're not selected in the H1B lottery, then they have no, what is their alternative to be able to remain in the US? So that, in essence, if we're looking at significant changes to the cap process, if they do happen, then in my mind, a lot of people we would be treating as essentially last chancers. So looking at what are alternative strategies to get different types of work authorization in the US, such as an O1, which is for extraordinary ability individuals? Or is this a situation where somebody might need to go work abroad for a year or so and then be transferred back to the US? But that's a really long answer for the question. But I just wanted to think about all the different angles of it and things to consider.
But that's how, we want answers. We want everything to be clear, and that's how you're answering. Thank you so much, Kimberly, and thank you so much, Cynthia, for participating in today's episode. And next up, Kimberly, we are going to take question from Fawad Ali. So he's asking that I'm currently on an F1 visa and considering transitioning to OPT. With the potential for stricter rules post election, should I expedite my application, or is it safe to wait for my planned timeline?
So the university is in charge of granting and issuing the Form I-20 with the OPT recommendation or approval. I do recommend for individuals that have the option to premium process a case at the Immigration Service that be utilized. So I understand that premium processing is expensive. All premium processing now is well over $1,000 for the Immigration Service to process cases, applications, and petitions, quote unquote, faster than normal processing. But I strongly recommend utilizing premium processing if at all possible, unless there's a strategic reason not to. We have that in certain situations. So I'm just thinking with OPT, I don't see any strategic reason not to utilize the premium processing. Again, you just want to address your current specific situation, but that would be one of the ways that I can see, ensuring or trying to get ahead of the processing of an application before Trump 2.0.
All right, all right. And also, Kimberly, I need to ask you something that, mostly we have seen in US companies that they prefer employer sponsored visas rather than individual merit. So, are we going to see any kind of change in how the applicants are being evaluated? Will the individual merits be getting more preferences, or how it's going to be for them?
Oh, so yeah, under Project 2025, there is some discussion about changing our immigration system to be more focused on individual merit,
Yeah.
and potentially going to a point system, but primarily looking at individual merit. At
Mm-hmm.
this point in time, we do not have that in our immigration system, and
Mm-hmm.
most employers essentially when they're interviewing and when they're recruiting for a job, and then when they're interviewing applicants, they're looking at who's the best fit for the company. And in many times, I've actually seen some companies that have never sponsored anybody in the past, and they're willing to do it because they found that unicorn, right? That one person who the hiring manager really, really likes, and the individual who will be a good fit in the organization.
Mm-hmm.
So I would, until there's some change in the regulations or the law, I would expect employers to continue to recruit and interview and offer, extend offers of employment, based on the particular qualities of the individual and if there is a visa option for that individual. So
Mm-hmm.
those are some of the things that we see usually um, with companies that don't want to sponsor. They do have a policy that says they're not going to sponsor for any positions, and sometimes that's from a business operations perspective because it just takes too long to obtain certain visa classifications, or it's more, it's financially burdensome for the organization. So from a business operations perspective, there are some companies that choose not to sponsor individuals, but otherwise, that individual merit based system in our immigration system in the United States has not been implemented. It's been primarily discussed within the Project 2025 document in prior Trump administration.
Mm-hmm. All right, all right. So I think that we can also look for a good change, though, because till now mostly it was preferring the employer-based visas, but now we can also have a hope for individual merit too. So, Kimberly, also one more thing I would like to ask, as you mentioned about Project 2025. We have went through that, and we have seen that how disturbing it is, how extreme it is. Trump himself said that he is not going to implement, not clearly, but some on the other we found in his statement that he's not favoring Project 2025. But the irony is that in Project 2025, we can see 100 times it's mentioning about Trump itself. So, what can you say on this? Do you think that it's kind of tactics that Trump is trying to play in front of people, or what it is?
Oh, that's a loaded question. So by seeing who Trump is appointing to his administration at the cabinet level, some of those individuals, such as Stephen Miller, I think his first name is Kenneth Vogt,
Mhm.
President-elect Trump wants to be in Office of Management and Budget, and a couple other people have been individuals who have been proponents of Project 2025, as well as individuals who have helped to write Project 2025. So by President-elect Trump's actions alone of bringing those individuals into his administration, to me, says I am embracing Project 2025.
Mhm.
Maybe he's not embracing all of Project 2025, but it seems pretty clear to me from the actions
Mhm.
that Project 2025 is, in fact, a big part of, or will be definitely a part of, the administration's policies and systems. So that's how I'm looking at it from that perspective.
Mhm.
Um, for Project 2025. So we are anticipating that some of those proposals will be implemented or will try to be implemented.
Right, right. And I think, by seeing the list of Project 2025, most of the people are scared. But let's see how it does. As you also mentioned, that maybe some of the policies he may implement and some of them it's not. So, all right. Thank you so much, Kimberly, for your answers. And now I would also like to ask some questions from the Facebook group as well. So, here's a situation that I would like to read it out. That is that I have a question to me and my brother and sisters, and my mom came from another country here back in 1988. My mom passed. She had an aneurysm, leaving my brother and my sister without any papers. We came here legally on a plane. I'm worried with the situation has going on with Trump and want to get them help. Do you know what can we do? My sister has a mental breakdown as my brother since my mom's passing, which it makes it even harder to deal with things. I just want to get some help.
I'm really sorry to hear about that. That's really heartbreaking. Um, the my recommendation and the best thing to do is to seek guidance of an experienced immigration attorney who works with individuals within the community that do not have any status in the United States in order to determine what potential areas of relief are available. um, and Sam, we had talked about this a little bit earlier, like why have some people stayed in the US and not corrected their status in all these years? And unfortunately, sometimes there's just no options, or the option has been to leave the United States for 10 years and then come back, which being outside the United States for 10 years can create incredible hardship, especially on family members. We have several situations where a U.S. citizen has married a foreign national who, is, excuse me, is undocumented, and because they had entered without inspection or they had certain violations, they were subject to that 10-year bar and would have to leave the U.S. for 10 years. So that's, that in a way that's a solution, but it's not a good solution for many people, right? Leaving your
Mhm.
home essentially is really difficult. So my recommendation and guidance is to really seek out an experienced attorney in the area in which you live. And one of the things that you can look on for the under the bar associations, they'll have, sometimes they have pro bono lists, so that might be an option to start there, or to reach out to one of the immigration associations like Catholic Charities or the Immigrant Justice Project, just to see if they have recommendations, because I don't want anybody to get in a situation where they're dealing with, an notario or an attorney who doesn't understand that particular area of law. So it's really important to find someone who is experienced and can help out, but with having that consultation.
Absolutely. And I think, guys, we have Kimberly, so I think it will be great to contact attorney Kimberly Best Robidoux. And not only in case of anything about H1B or L1, you can also contact her related to any problems or any, processing of immigration that you're going through. So here's her contact details that I would like to read it out. Her contact number is 619-826-4010. You can also email her at krobidoux at wolfsdorf.com, and you can also visit her website, that is www.wolfsdorf.com. All right, so thank you so much, guys, for being for participating in today's session, and to Kimberly too. Moving ahead, Kimberly, there are some different questions also that I would like to ask. That there are so many participants who keeps on commenting and keeps on texting us. So now I think it's the best time to take up those questions. So yeah, Kimberly, there's another thing that anonymous participant is asking. My husband and I have paid an immigration lawyer $9,000 so far for his case. She has not submitted his packet to USCIS. Today, we received an email asking for more money. Times are getting harder. What would you do?
Well, I don't know the particular circumstances of
Mhm.
the situation, so I can, comment on different types of applications and petitions take different periods of time. Um, so, for instance, if someone, an immigration attorney, is working on an EB1 preference category for extraordinary ability or outstanding researcher, or even EB2 national interest waiver, that can take 3 to 6 months to prepare the petition in detail, to gather the information, help write the employment or the recommendation letters, put the case together. So that is an out of the norm for a case like that to take 3 to 6 months to prepare. For other cases such as marriage to U.S. citizen, where there's an I-130 immediate relative petition concurrently being filed, possibly with an application to adjust status, that can take a couple of months to prepare, and that's after an attorney receives all of the documentation and information necessary to prepare the case.
Mhm.
If there are exigent circumstances and there's a deadline, then an attorney should be made aware of the deadline. And most likely, once they are aware of the deadline, then a case can be rushed in order to, file something so that an individual does not go out of status. So those are some factors to consider. And then I also look at what was in the services contract, or some people call it an engagement letter. So what did that say? Did it say that the attorney was preparing, specifically what is the attorney preparing, and what is the fee for that preparation? And is the attorney asking for additional amount now because those are the filing fees that need to be submitted to USCIS, versus asking for more money to adjudicate or to prepare the case? So those are some things that I would look at. I would definitely look at that agreement that you have between you and the attorney, to understand specifically what it is stated in that agreement for the attorney to be preparing, and what the fees are. Those should be clearly stated in the agreement. And anything outside of that, you definitely need to ask the attorney, for specific information about why they're asking for additional funding or fees. I That's really important.
Absolutely, absolutely. So thank you so much, Kimberly, for your answer. And next up, we have received a question from Shani Tracy. So her question is that my fiance was recently detained by ICE. He is a Wasden refugee here in the US, legally I-94. We need help. He has some misdemeanors which led to them detaining him, located in the DFW area, seeking pro bono assistance.
So that would be Dallas Fort Worth. I would check with, I think there's a Catholic Charities there, or an immigrant justice project of the
Mhm.
American Bar Association. But also, I'm not sure if Texas Bar Association has a list of pro bono attorneys like the California Bar Association has. So that might be an area to focus on. Um, there's also one of the things to look at in the Dallas Fort Worth area is to look at any kind of, one of the other things I have had people do is contact the immigration clinics at various law schools. They might be helpful, or they definitely have the pulse, on their pulse on the community, and can know, or more likely will have the information to make referrals to specific individuals in that area who can address that particular situation. Because with ICE, um, there's a lot of work that goes into sometimes contacting ICE, trying to get to the right ICE officer, just trying to get the right information to find out, where the individual is being detained, and then work through that process. So those are some of the people I would recommend reaching out to right away, in order to get someone who is essentially boots on the ground in that community area, in order to help out with that situation.
All right, all right. Thank you so much, Kimberly, and I'm sure that Shani is definitely going to accept the all the conversation that she's listening right now. And also, we have next question that we have from G Annie, and he's saying that, hi everyone, can someone tell me if I should do anything else after I file the I-130 online? Also, in the form, I put in the address Canada since my parents were visiting my sister during that time. I even put in Canada address for the closest consulate to conduct the interview. I don't know if I did it correctly or not, but now my parents are back in Philippines. Should I do something about it?
All right, so that's a very case specific situation, right? And so after filing an I-130 petition, typically there isn't anything that can be done to make corrections unless there's a request for evidence that's issued, or potentially after an approval of the I-130 petition, it's sent to the National Visa Center. And at that point in time at the National Visa Center, if the National Visa Center says, well, we're scheduling the immigrant visa at the pardon me, at the U.S. consular post in Montreal, um, then there's the ability to say, well, the beneficiaries do not live in Canada; they live in Philippines, and here's proof of their lawful status in the Philippines. And then the National Visa Center, which is part of the State Department, can work to adjust that immigrant visa application process from Montreal in Canada to the Philippines. But if there are specific questions, before then, in terms of anything that may have been that might need to be addressed, I would again speak directly with an immigration attorney who you would retain that
Mhm.
can look over the actual, the full on petition, understand all the particulars, because even though it might seem like nothing or just a really small point, can be a huge
Right.
factor in determining what to do next.
Absolutely. We really have to be very much particular about all the information that we are sharing and we are receiving. All right. So here we have another question from Delgado, and he's asking that can I apply for citizenship if I lost my green card? I am eligible to become citizen, but I don't process my green card. What can I do?
Yeah, so permanent resident status is based on, it gives you the ability to live and work in the United States, and the card is just evidence of that status. You don't typically need a valid card. Like if you let your card expire or you lose your card, it doesn't mean that you lose your permanent resident status, unless if you've been abroad for many, many years or for a significant period of time, or you don't pay or file a U.S. tax return. So those are all other issues that could impact
Yeah.
green card status or permanent resident status. But if it's a matter of somebody has maintained their permanent resident status in the United States and they've let their card expire, you may still be able to apply for naturalization, because naturalization has its own requirements with respect to having been a permanent resident for at least 5 years, unless you're married to a US citizen, which can reduce that time to 3 years. Being physically present in the United States for at least half of that 3 or 5 year period of time. Continuous physical presence in the United States, meaning no more than 6 months in a row outside of the United States, and then having a good moral character, as well as being able to read, write, and understand English and pass the civics test. So those are the criteria over, generally for naturalization. If someone is required to apply for a new permanent resident card and pay the hundreds of dollars for that card while their application for naturalization is pending, is again like something specific with respect to the timing that should be addressed with an attorney based on the particular circumstances of the individual. Because in some circumstances, the person can file their N400 naturalization application without having to apply to get a new permanent resident card. But there are strict
Yeah.
criteria around that, so that would have depend on a case by case situation.
Absolutely, absolutely. Okay, so next up, we are going to take this question. So, I need help. My brother in law came here illegally and has been married to my sister for 3 years, and they have children together, and they don't want to know what steps. No, no, sorry. I'm so sorry. Uh, I'm reading it again. Okay, I think I fumbled in between. So yeah, here it is. Here's a question that I need help. My brother-in-law came here illegally and has been married to my sister for 3 years, and they have children together and they don't what steps to take to get his papers started. They fear what their future may look like. So what should they do to have some form of security in these hard times? Oh god, this is something very, you know, very critical topic. So how do you
Yeah.
say?
So in that situation, if someone has entered without inspection, meaning they crossed the border not at appropriate ports of entry and were not admitted and inspected by an officer at the port of entry, then typically trying to write your status is pretty much impossible unless you obtain a provisional waiver of the extreme. I'm sorry, a provisional extreme hardship waiver, or potentially reside outside the United States for 10 years. So those are the heartbreaking scenarios where we see that there might not be a particular solution, or a solution that is not something that a family wants to go through because it means separation of the family members. So in
Mhm.
this particular, in this circumstance, and then in anyone who has anything similar, my advice again is to seek experienced immigration counsel to discuss the very specifics of the background, the history, current status, looking to see if there are any available options to proceed with obtaining valid status in the US. But also, unfortunately, in these times right now where we're expecting, Trump 2.0 in 60 days, um, working not only with an immigration attorney, but potentially also another attorney or um, professional that can help get everything in order with respect to, as I mentioned, in California, there's a caregiver document. There are similar documents throughout the country in every different state, as well as getting things in place with, picking up, how do I get my last paycheck? How do we pay the rent? What do we do with our property? How do we have like a family tree contact list, so to speak? So, again, preparing for the worst in case there is action taken by ICE for deportation. So that's a piece of it. And then the other piece of it is looking at what options are available. And, some of the things that even looking at now, is it smart, or is it a good idea to actually put someone forth with an application or a petition where you're putting somebody vulnerable into the immigration system, where it can be easier for ICE to find that information? So those are things that really need to be considered and discussed with an attorney.
Absolutely,
Which,
absolutely. So I think that's very important, because now people only think about how the policies are, how the process is, but we don't see that what problems do they really face. So I think this is also very important, Kimberly, to mention, and you mentioned it beautifully. So Kimberly, this is the last question that I would like to take up, and okay, let's take from this question from our viewer.
okay.
That is Madhvi. So Madhvi is asking that my employer is planning to sponsor me for an H1B next year, but we concerned about potential caps or quotas being reduced. Is this likely scenario, and how can employers overcome this risk?
Um, so decreasing the number of H-1B visas would take an act of Congress. It may or may not be possible for Trump 2.0 and the administration to take that up before we have the H-1B cap registration in March. It's definitely something that everybody is going to be watching and looking to see what happens. Um, in terms of how to prepare, the best thing to prepare is to prepare as if the registration is happening, that we'll have the same number of visas for H1Bs, and then look at the alternative strategies if the registration is not selected in the H1B cap. So does the individual have optional practical training or STEM OPT that can get them through another year? So look at those alternatives to the H-1B cap. And then if there are no alternatives, what does that mean in terms of potentially getting prepared to having to leave the US? So those are all good conversations and things to discuss in advance. With respect to the H1B cap lottery, I mean, we've seen the percentage of being selected
Yeah.
getting lower each year. So those who have less than an advanced degree from a U.S. university have had definitely under 30% likelihood of being selected in the lottery. And then those who have an advanced degree from a U.S. university have had slightly greater than 30% chance of being selected. So even without a decrease in the visa numbers, we also already unfortunately have very low selection rates because of the significant demand. Um, but thinking about it, we could have less demand this year, with employers saying, well, the registration fee is $215, so we have to be really careful about who we select to put in their registration. So the selection rate may go up. So I don't know. It's a mixed bag right now, and I hate to say that as an attorney, like it depends, but in this scenario, I think it does depend. And the best thing to do is just prepare for what if I'm not selected in the registration. What does that look, and what are the options?
Absolutely. And this is the same thing that I would also like to suggest to our viewers also, that guys, it's very important to, contact an expert attorney to get the right guidance, so that you don't do something that, you can get into hurdle with. So it's very important to stay updated and to stay informed on everything that is happening. So that is why it's very important to like, share, and subscribe to Immigration and Jobs Talk Show to attend our everyday live shows, that we have with different attorneys with different topics. And you can also get a chance to participate in this conversation by commenting and by replying to us. So it's going to be a great opportunity. And well, Kimberly, we have come across to our almost 1 hour, and it has been wonderful experience from my side. I really enjoyed, and you were outstanding, you were clear, practical, and to the point. And I really enjoyed this session. How was it, like, how did you feel it? How was your experience?
Oh, this has been fantastic. Thank you so much, Sam. It's been, as you can tell, a great topic. Unfortunately, we're having to talk about some really hard issues and tough
Yeah,
topics, and the discussion isn't happy discussion. But I think it's really important that
exactly.
people are getting prepared and are arming themselves with knowledge, right? Knowledge is power. So I think that's really important. And thank you for bringing this to your viewers, so that they have that knowledge and they can, protect themselves or plan for the future. I appreciate it so much.
From our side also, thank you so much, Kimberly, for sharing these insightful information with us. And it has really been a great, great session, and a very insightful session too. So guys, if you would like to contact attorney Kimberly Best Robidoux, then please go ahead and contact her right now on the given details, that is 619-826-4010. You can also email her on krobidoux at wolfsdorf.com, and you can also visit our website, that is www.wolfsdorf.com. All right, guys, so thank you so much to everyone, to each one of you who has participated and who has watched our session till the end. Thank you so much, and keep on like, share, and subscribe to Immigration and Jobs Talk Show. I'm Sam, signing off for now, and thank you so much to attorney Kimberly Best Robidoux. Have a great day.
Thank you, Sam.
Thank you, guys. Hello, everyone, and welcome to Immigration and Jobs Talk Show. I'm your host, Sam, and before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. All right, after this important disclaimer, once again, welcome back everyone to Immigration and Jobs Talk Show. And today our topic is NIW for Indian nationals. A smart move. But is it the best part to a green card? So today we are going to explore all the essential details that you need to know, from the exciting benefits to the challenges you might face along the way. And to help us explore about this topic, provide expert guidance, we have a very special guest joining with us today. Daniel Stephen Larson. Hello, Daniel. How are you?
Hey,
Yeah, hi, Daniel. How are you?
hey, I'm doing very well. It's
Thank you,
yeah,
Daniel. And
greetings
it's
from
a pleasure.
California.
Yeah, it's a pleasure having you, Daniel. So, Daniel, why don't you go ahead and have this moment to introduce yourself and share a bit about your background and experience in immigration law?
Sure. Yeah, my name is Daniel Stephen Larson, and I founded Larson Legal, my law firm that's focused on self-sponsored cases for talented individuals from all over the world. So I primarily handle national interest waivers, EB1As, O1s, some TNs, and other categories that come into play. I've worked in the immigration law space for over 10 years. I was an associate attorney with the law office of Nathan Waxman in New York City. And I helped him work on, prepare the national interest waivers for years and hundreds of cases. Hundreds and hundreds of cases. So I feel very comfortable in this space. It's what I primarily do. And yeah, it's something I find very rewarding. I get to meet individuals from or meet and clients in all sorts of different professions, all sorts of different fields, yeah, a diverse array of talented and extraordinary professionals and all from all over the world. So yeah.
Wow, that's great. That's a great intro, I would say. And Daniel, it's a really pleasure for us having you with us on today's show. And really, I'm really excited for today's episode. So, Daniel, before jumping into our today's topic, I would like to have your point of view, your thoughts about Trump's administration. So, according to you, what do you see? I mean, what will be the future of
Yes.
US?
So, of course, as I mentioned earlier in our introduction, that I am a liberal Democrat, have for my whole life, and of course, I have viewed Trump skeptically, and I remembered his administration the first time. I think that in the area that I practice in, these self-sponsored cases like national interest waivers, EB1A, also O1s. I think that the influence of Trump isn't necessarily going to happen on the in the adjudication of the cases. I don't think that the standards will change. I think that where we will see some issues is backlogs of adjudicating adjustments of status, so that there's probably more likely to be a lot of vetting. That's what happened the last time Trump was in charge. That things like the public charge rule, there's going to be security checks, things like that of that nature. But the actual adjudication of the merits-based portions of these cases, I think, will probably be pretty much the same. I think that Trump is probably more focused on the border, reforming, or his plan for mass deportation, things like that, versus the self-sponsored cases that I work on.
So, Daniel, as also we all are very much aware about mass deportation. So, do you think that it is practically possible for Trump and for anyone, to have this mass deportation? Uh, is it really
Well,
possible?
I'm not an expert on this particular area, but my opinion here in California, I think that I personally think that the American people, when they see these, if there is a real mass deportation movement, that it will disturb the American people, and like when there's pictures of people being rounded up or something like that, that will cause a backlash, and they will stop, or that's my personal opinion about it. But I don't know. I think that it's the appetite that, at least from my perspective, like there is it's unfortunate to me, because like I find that it'd be very troubling if that happened, if there was a true mass
Absolutely. Yeah.
movement. I'm hoping that doesn't happen, but
Well,
we'll see.
yeah, we all are
Yeah.
just looking for it, and we are just hoping for whatever happens for the best. So I don't know
Right.
how Trump is going to have his another Trump 2.0 era. Well, anyways, thank you so much, Daniel, for your answer. And Daniel,
Yeah.
we also
Oh,
said,
and
yeah,
sorry. One point, the thing that I really would like to say about Trump and things. A lot of people, assume that Trump can just change the law automatically, very quickly. That's not the case at all. The regulatory to change the immigration laws as they are set is a very, very complex process
yeah,
of regulatory reform, a regulatory change. And the Trump administration, if you note that, the first time they were in, they had a hard time doing things like they were trying to remove work authorization for H4, with approved I-140s. That never happened because they were too slow and the process was too complex. So I think that they're probably going to have more experienced people now, but the actual process to change the way the law works in the United States is very, very arduous and complex. And, I think people should remember that when they think of Trump. We are still a country of laws, and, yeah. But these executive orders, I think that it does, that's the area where there could be
right, right,
lots of.
all right. Correct. So, Daniel, what can you say for NIW? I mean, obviously, we all know that it's a smart move, that could be best part to a green card. So, do you think that if Trump is going to handle everything and if he is taking everything under his control, so there might be a chance where he would, limit or stop the NIW?
Well, I think as I was discussed, there's been a massive in the last couple of years because of the perm processing times. There's been a massive boom in national interest waiver filings because people want to avoid going with the Department of the DOL, the Department of Labor, and skip a step. With this huge boom in cases, I'm actually very worried that the adjudicators are flooded with inappropriate cases or cases that historically would have never been filed for national interest waiver. Things like a yoga instructor or a teacher or all these professions that we wouldn't normally think of as being nationally important, or and they're now utilizing because of the huge delays in the perm cases. So that's the part that I'm actually concerned about, and it's already happened a little bit, that the way that the cases are adjudicated, in my mind, I've gotten some requests for evidences where there's a lot of focus on like the economic impact of the individual petitioner, and usually that's not what NIW is about. It's not a business visa like an E2 where you have a business plan historically. But things have been changing recently, and so that's I've been seeing more of that.
Exactly,
Yeah.
exactly. So, Daniel, how many clients do you usually get for NIW, especially from here?
I have probably a caseload right now. I have
Mm,
about 30 or 40 NIW cases in the pipeline, like at various stages.
right.
And I have to ask my client, my assistant, the exact count. But the cases, I don't have I don't have an extremely high volume office. I have I would say like a medium volume, and the NIW is a very, very collaborative process with the client. Each case is different. Even though you can, like some of the researchers, you can just present it in a very formulaic way. you really need to understand what's going on with the case and their accomplishments, and to see what's the best angle for NIWs.
Yeah.
The narrative. These cases are very narrative, based on narrative. Like you're telling a story. What is the client's story, and how do they benefit the larger field?
Right, absolutely. So, Daniel, what can you say? Let's begin with our very first question of today's topic. That is, what are the primary benefits of applying for a national interest waiver under the EB2 category, especially for Indian nationals who might face long wait times in other green card categories?
Well, one of the biggest benefits that I can think of for Indian nationals to file for a national interest waiver is a national interest waiver is a self-sponsored petition. You can control that you're not under your employer's thumb, and it's completely your petition. So if you get the national interest waiver approved, you can preserve the priority date, and then at a later date, if you are eligible for EB1A, B, or C, you can apply. You can use that date, that priority date, and you're locked in, and you can hopefully file your adjustment. So that's what's happened for me in several EB1A cases that my clients have had approved I-140s before. So if your employer is wavering on their on whether to sponsor you for a green card, you can just do it yourself, and you can get that. You can lock in that date. That date is tremendously beneficial, and it's so wonderful that you can take that priority date and use it for a subsequent case, so that you're not stuck in
Yeah.
yeah.
Or-
Also, the another thing is like I tend to my Indian clients tend to be married, and their spouse. If you have an approved I-140, the spouse can get work authorization through with the H4. Generally speaking, a lot of my clients are on H1B, and then their spouse maybe has their own, or they might want to consider if they change employment, to go on the H4. There's so those are the big benefits that I see. Besides,
Right.
yeah.
All right. Okay. Thank you so much, Daniel, for your answer. And moving ahead, I would also like to ask, if we talk about the process of applying for NIW. So, how does the process of applying for an NIW differ from the traditional employer-sponsored green card process? And what are the time-saving advantages?
Okay, so here's how the NIW works at least when I handle the cases. I usually ask the clients to fill out questionnaires about, describing their field, and then potential lists of supporters, and trying to isolate the nexus between the supporter and the client. When we file the NIW takes, I would say, from when I'm retained to when it's filed, it takes 1 to 2 months to send out a case, maybe longer, maybe shorter, depending on how interactive and how engaged the client is in this process. Most of the time is spent working on the letters of support. The letters of support usually are 1 to 2 pages long. I usually submit between 4 to 7 letters of support in each case. And then, I gather all of the client's documentation that they have. They show that they've influenced the field in some way. So like if they've published papers, if they have given professional presentations, if they have... if they have relevant work samples that show the complexity and the importance and impact of their work, I will submit those. And then, each one of the wonderful things about national interest waiver, which is completely different, and it's much more liberating than some of the other standards. With EB1A and O1, you have set evidentiary criteria, a list of, things like you have a high compensation. You've made an original significant contribution to your field. You have publications, set evidentiary criteria that they use. But for national interest waiver, there's no such things like that. It's all based on the Donisar case. So I think that like how this differs, it's just much more free. You can take almost any relevant evidence and submit it to show that you've made an impact on your field, to show that you've made an impact in your field. How this differs, this is very, very different than the traditional perm process of, with, getting, the wages and the Department of Labor, and which is a very passive process, where the company and then the advertising of the company with recruitment and advertising, where the client isn't really involved at all. It's usually the HR and the immigration attorney are working through this stuff. And with the NIW, it's very client focused, and it's all about that client. So we're constantly talking to them to see if there's other relevant evidence, if there's somebody else we can get, and stuff like that. Yeah.
Right, absolutely. So, Daniel, as you also mentioned about the evidence. So, my next question would be with what types of evidence are typically required to support an NIW application, such as an expert advisory letters, awards, and publications? How can an applicant strengthen their case with this?
Okay, so it depends on what type of client you're dealing with, but I tend to look for almost any evidence the client has told others about the importance and impact of their work. So if they publish articles about their work, I want to gather that. If they have done professional training, training of others, like they've created training programs, and they've I've had many cases based on that. And so, and if they have, professional presentations at major conferences in their field, I'd like to document that as well. The idea is that like whatever evidence shows that your client is not just impacting his employer, impacting things, that he's impacting the larger field, larger field. That's what drives these cases. So like, you can, depending on the client, you could have a client that has it doesn't have to be publications. They could be TV interviews or YouTube interviews, there's just a million types of evidence that you could use, So I think that like in general, I usually submit, as I said before, I submit 4 to 7 letters of support, but that's not the case in every case. You can submit 2 letters if you have a strong case. You could submit. I think it's redundant after 7 letters to things, but then I gather these publications, whatever evidence they have that shows that they've worked outside of their that they've benefited a larger field, and I try to divorce my clients from. A lot of my clients are employed, and I try to divorce them from their employer. That they could be, they could work in a national interest waiver, completely outside of, like the whoever their employer is right now. That's not, yeah.
All right, that's great. And Daniel, also, I would like to ask that, can you explain the 4 main requirements to qualify for an
Okay.
EB1A?
Yeah, so this is how it works. So when you file a national interest waiver, the first thing that you do is you show whether you are an advanced degree professional, meaning that you have a U.S. master's or foreign equivalent or above, or you have a bachelor's degree and 5 years of progressive work experience. Okay. If you show that that's the first thing. And most of my clients from India tend to have a degree. Usually they have a degree. But you don't have to have a degree. If you don't have a degree, you have to go through the exceptional ability standards, which is a little bit harder to go through. with a degree, either a bachelor's or a master, either a bachelor's and 5 years of progressive experience. It's like checking off a box. You can just submit that information, and then you're good to go. You don't have to do a lot of analysis. Exceptional ability, you need to show, like, for example, you show that, like, they're in distinguished organizations, and it's a pretty arduous test. I haven't done it recently, but yeah, most of my clients meet the advanced degree professional test.
So, Daniel, what about the bachelor's degree? I mean, obviously, we know the master's and the PhD, they will get a good thing. I mean, easily NIW. So, what's about the bachelor's degree? And if they have like significant work experience, then also they are able to qualify for NIW?
Yeah, absolutely. If you have a bachelor's degree in a related field, to what it's things, and you have work experience, that's enough. That's to be an advanced degree professional. It's the same as if you had a U.S. master's or a PhD. One thing I want to stress to a lot of people is that, like, people ask me, like, do you need to have a PhD? Do you need to have, like, a degree awarded? No. It's not all that relevant. It's more documenting. It's a flexible standard, so that, like, we can have people all sorts of talented individuals apply for this. But you need to show that you've impacted the field. That's the key. Yeah, and then you have to go through the 3 Donasar prongs. That's the we do the exceptional ability, advanced degree professional. That's the first part, and then you go the 1, 2, 3 Donasar prongs.
All right.
Yeah.
So, thank you so much, Daniel, for your answers. I think these are very clear and very to the point answers. So, moving ahead, I would also like to ask Daniel that how have recent changes in immigration policies, like availability of premium processing for EB2 and IW applicants,
Yeah.
impacted the application process and timelines?
So the rise of I welcome premium processing in the national interest waiver space. I think right now probably about 80-90% of my clients use premium processing. When I tell, and I just had a couple clients recently who said, who waited for 10 months for a case to be approved, they got the money together and for the premium processing.
Mm-hmm.
I tend to I appreciate that it's available. I don't think these days it's I haven't seen many cases without it, so it's a little bit hard to say if premium processing makes a difference for the actual adjudication of the case. I don't think or if there's a more likelihood of a request for evidence. I don't believe that it does result in more requests for evidence, but that's anecdotal. Like, I don't have firm data either way.
Okay.
But in premium processing, it's what the clients expect and want right now these days.
Right. Okay, so Daniel, as we move ahead with Form I-140, I would also like to ask that what are the steps involved in filing an NIW application from submitting Form I-140 to obtaining a green card? And what are the typical processing times for each?
Okay,
Yeah.
so here's how it works. So, you fill out Form I-140, and then there's an antiquated form called ETA 750B. It's an old Department of Labor form. It's not been updated, but it's mentioned in the regs. So you need to file. You can file that one. It's an easier form than the 9089. And when you submit the national interest waiver, you gather the whole case together. You get your letters of support. You get your evidence that the client has made an original significant contribution to their field, or evidence that they have influenced their field, so publications, citations, presentations, maybe relevant work samples. I usually get also, in addition, I will get a personal statement or a professional plan of their future endeavor that outlines what they're going to be doing. And I like to outline, I like to direct it when appropriate to have my clients say that they're going to continue to do research. That tends to be an easier direction if that's what they truly want to do, versus when the ones that say they want to start a business, that opens a can of worms of it makes it more like an E2, which is a business oriented case. And I just think that it's most of my clients are not actually ready to do that, ready to start a business. They're employed, so I tend to shy away from that and focus more on research when I can. So you send it, you gather all the case together, you send it all in one big package. You use premium processing. What happens? You wait 45 days until, if you use premium processing, you wait 45 days. If you don't use premium processing, you wait maybe 10 months, 11 months. You're either the next step is that you'll either get an approval or a request for additional evidence. The approval, and very, very good cases. I just want to say this, I wish I could just control if you get a request for evidence or not, but we try to avoid it. But it's just part of this practice. It's part of the business that the service just arbitrarily issues requests for evidence, in my opinion. It's just you gotta be ready to respond if you do get a request for evidence. Usually the response entails getting letters of additional letters of support and any media that wasn't mentioned or projects to explain the case. Yeah.
All right, all right. So I can see that Daniel has so much information to deliver it to our viewers. So I think that's great. And Daniel, also we have few of our viewers who has joined today's episode. So
Sure.
thank you, Geeta.
Hello. Uh-oh. Hello.
Yeah, I'm here.
Okay. Cool.
Oh yeah, I'm so sorry. I don't know. Maybe some internet issue might be there, but I think you can hear me now, right?
I
Properly.
can hear you perfectly.
All right. All right. Okay. So, yeah, Daniel, I was saying that, there are so many people who has joined us, Geeta, Amzad, then Santosh, Ansa also I can see. So, okay, let's take our first question from Ansa. So,
Okay.
Ansa is asking that does a master's degree holder need 5 years of experience to be qualified for NIW?
No, a master's degree. If you have a U.S., if it's determined by an eval agent, the agency to be equivalent to a U.S. master's, you can just go from there. You don't need 5 years of work experience.
All right.
You're already an advanced degree professional, and then you can move on to the 3 Donasar prongs. Yeah.
Okay, all right. So, Ansa, also, if you have any follow up or any question, you can please go ahead and post. And I think you have posted one more, so I'm taking this one as well. And Ansa, another question is Daniel that I completed a master's degree in the US in clinical mental health counseling,
Mm-hmm.
completed OBT, and I'm on H1B with the same company. How soon can my company apply for a green card on my behalf?
Well, they could apply for a green card. They don't have to use a national interest waiver. They could, they can apply right now. For you. Actually, that's one of the things that one of the reasons why I get cases for things is that there's a lot of employers that are hesitant to file a perm case because it's expensive, it's time consuming. and maybe they don't even know how to do it. Like that's a huge issue.
Right.
So like, there's so many companies in America that like they have no idea anything about immigration. They don't know nothing, and so or they've never hired an immigrant, and now sometimes they will, and so one of the reasons why I get business is that like often my clients are at an employer that is inexperienced, so they don't know how to do it, or they don't feel confident in their their lawyers that they're working for them. I work on the client's behalf, not on behalf of companies. So it's a different kind of orientation. Yeah.
Exactly. Okay, so thank you, Ansa, for your question. And next up, Daniel, we are going to take Geeta's question. So
Sure.
Geeta is asking that how does the processing time for an NIW compare to a regular EB2 application? Could
Oh,
pursuing both simultaneously improve my chances of getting a green card faster?
excellent question. Yes. Okay. So one of the major questions I get is, can an employer sponsor my green card using the PERM process, the EB2
Yeah.
process? And could I also have an NIW simultaneously? The answer is yes, you can. They're not the petition. The NIW is your personal petition. I actually it doesn't have to be, but I like to make it the personal petition. Whereas the PERM is, initiated by the company. They own that, that petition, and then you are the beneficiary of the petition. I would say that, like, I think, I don't handle that many PERM cases, but my understanding is that it's taking 2 to 3 years these days to get to get things through the process. Whereas an NIW, you can get an I-140 approval, in 6 months or 3 months, like depending on how good of a case you have, and so it gives you that benefit of the things. Now, again, you're still subject to the backlog. Everybody in the world is now, but and Indian nationals have the worst backlog of any group. But it's still like, you get that I-140 approved very quickly, relative to the other methods.
All right. So, Daniel, I just want to ask that what is the average approval rate for EB2 NIW applications?
Okay, so historically, I would say it's been shown. I saw it at the AILA conference. It's a 90+%.
Wow.
For NIWs, it's a great category, and there's one of the reasons why people love it. To use it because it actually works. Now,
Easiest way.
but there's a problem. I would say that, like, right now, there's been so much a flooding of the cases that I was having discussions on LinkedIn with other attorneys, and I think there's been a little bit more. We've seen aggressive requests for evidence,
Yeah.
Where maybe the service wants to see the economic impact of the client, and I think that, like, maybe in the future that high approval rate will not be, with my current batch, I'm not so sure anymore. In the last year, I've been taking cases that I would historically have considered marginal cases. Somebody who has maybe only 1 or 2 publications and a couple citations. Now I'm a little bit uneasy about taking those type of cases. I think I would have to think about it for a little bit to see if it's fits into a good NIW narrative. Yeah. But it's a great. I just want to say it's a great category, and I hope that it will continue to be this way.
Well, we can't say anything if there's Trump's administration. Anything
Yeah.
can happen.
Yeah.
But still, we hope, and I think NIW, it won't be end so soon because
I don't think so either. No.
yeah, it's very important, and it's not that easy, to end any policy just after your administration. That too. Okay.
Right. Like the change in the law, like I still have to stress it, like When I started immigration law, 10 years ago,
Oh,
it was, or when I was a little junior attorney, the people were saying, "Oh, premium processing is going to come in the beginning, and everything is going to be digital,
wow.
and the whole thing will be different."
Yeah.
Didn't happen that way. It's still going on. It's still a thing. The only thing that really happened is that the big boom in Dinosaur came in
Yeah.
in 2016, and then the huge boom in filings in the last couple of years.
Right.
The
Right.
huge changes.
Exactly, exactly. So, okay, Daniel, let's move ahead. And, as you also mentioned that there's 90+% people, who gets NIW approved. So, I need to ask that once an NIW is approved, how does it impact the applicant's ability to change job or start their own business compared to traditional employer-sponsored green?
Well, one of the wonderful things about national interest waiver is, again, it's if you go with me, it's your petition, not your employer. So there's no danger of it being withdrawn or or even threats of that. So like if you lose your job, it's unfortunate. You still most likely, if you're here in the United States and you're on H1B, you still have to abide by to find an employer for yourself, but you have your green card locked in. There is no way that your employer could retaliatorily withdraw the petition or anything like that. So I think it gives a lot of the clients peace of mind to know that they have this, that it's their own case. They don't have to worry about it. The employer's whims or things like that, and it'll follow you wherever you go. So and it often, most of my clients are here in the United States, but like a lot of clients will, I have like international jet setter types that come in and come out, and it's I think it's reassuring to have that that thing in place.
Exactly. So I think we should agree that NIW is a smart move, and I think it's the best part for a green card, right?
Well, I would. Yes. Oh, I love NIWs. I want to promote it as much as I can. But I do. It's still. The backlog. It doesn't get my clients a green card. It gets them in line that they can control it. They get they get a ticket so that they can keep that for priority date for a future event. And who knows? Life happens, and some of my clients, they got their NIW and then they become a huge success. Others, things change. You never know. So I think it just helps to have that in there.
Exactly. Completely agree with your points. And also, Daniel, as you also mentioned about denial. So, for example, if there's an applicant, whose application got denied. So, what are the options for appealing or reapplying? And yeah,
Well, that one of the biggest questions I get is people ask me this: what happens if you get a denial? Not
yeah,
much.
exactly.
I would strongly recommend, unless there's a clear legal error on the part of the service, to refile the case. Make adjustments accordingly. If you think there's something could have been done better, but the appeal process with the AAO, the body that does it, the denials most cases are denied for the appeals. And when the appeal bodies, the AAO gets to review the case de novo, meaning that they get a fresh look at the case. So if the case was denied on a silly reason, they can look at the whole thing again and say, well, actually the service didn't really, maybe they shouldn't have given these points. And they tend to deny the case. I think that it's a much better option to just refile the case. They don't hold it against you at all. Or I haven't had the experience of them holding it against you. I think you obviously have to change, you have to get new evidence. You have to change the presentation. But you can even just be very forthcoming about it, that like, hey, I think I got an examiner, we think that the original case should have been approved. You know, but here's a new case.
Yeah.
Yeah.
And also, Daniel, when might it be advisable to file a new petition rather than appealing? Sorry.
I think that like okay, so where when do you really need to an appeal? I would use the appeal to the only real value that I can see is to preserve that early priority date because the appeal process. I think it's I have to check the filing fee for AAO, but it's about $700. It's about the same price as filing an another I-140. So you know the I haven't done an appeal in years now, in years. When if I get a denial, and denials do happen. I don't want to overstress this. Like it's part of this business that like you will get a denial here and there. If you send in these cases, and usually the answer is refile the NIW from redesign it, refile it.
Absolutely, absolutely. Thank you so much, Daniel, for these
Sure.
questions. And I would like to take one more question from our viewers, and after that, we will shift to another part. That is from Santosh. So he's asking that how does the EB2 NIW compare to other green card options such as EB1A in terms of processing times, eligibility requirements, and benefits, and which option would be most suitable for my specific situation? Given
I
the
don't know.
current
Yeah.
given the current green card wait times exceeding decades for Indians like me under the EB2 category.
Okay, so as I mentioned to you, the differences between so with EB1A, you get an adjudication with use premium processing in 15 days. You either get a request for evidence or thing. National interest waiver, it's 45 business days. So that's one difference. NIW EB1A has set evidentiary criteria, a list of evidence, and so it's very structured. It's very this is my list. I hit 3. You have to hit 3 out of 10 criteria, and you move from there. NIW is not that way. It's very freewheeling. You have to argue under the 3 Donasar prongs. The proposed endeavor has substantial merit and national importance. The applicant is well positioned to advance the proposed endeavor, and it would be in the interest of the United States to waive the job offer and labor certification requirements. So you have to meet those 3 prongs, and you make an argument for that. I usually focus on prong 2, but so like it's more. I would say that the NIW is freewheeling, more narrative focused in general. It's more flexible for. I've had it for peace activists. I've had it for artists. You can use it for almost any conceivable field. Whereas EB1A is a little bit more regimented. And like if you're it's EB1A. India is tough to get approved. It's a harder. They're not easy cases.
Yeah.
I think that like the big benefit though is I tell my client is it's having that I-140 locked in, the date, the priority date, and then it's like a stepping stone that you can build up your profile for a potential EB1A, or maybe more realistically an EB1C. A manager or an executive. That's one of the principal ways that my Indian clients have gotten a green card through employer is through the EB1C mechanism. So I think that it's just it's good to get that date, and then you can move forward with one of the EB1 types of cases if it's applicable.
Right. Okay, so I think Daniel, after this episode, I think there will be so many people who are going to have for NIW
I
because
hope so. Yeah.
there are so many advantages, and it's also very much beneficial too. So I think it's a very great option for anyone. I think it's a great thing, guys. So
Yeah.
any more questions you have, please go ahead and share it with us. And Daniel, here we have a Facebook question that
Yeah.
that I would also like to ask. So let's begin with this. What is the difference between a personal statement and a cover letter? Yeah.
Oh, so the personal statement is a statement by the client saying this is my opinion. Remember, you can assemble these cases in many, many different ways, but I usually try to get some kind of statement from the client that outlines in their own words, they summarizes their career accomplishments, and then outlines their proposed endeavor. So I am coming to the United States to continue my research, just like Donasar. Or I'm coming to the United States to start a consulting company. I'm coming to the United States to, to work with policy makers on a particular issue. I am the owner of a company, and therefore I cannot file. I cannot use the traditional perm process. Therefore, I'm using this national interest waiver to get sponsored, stuff like that. The cover letter is for me, and it just is like an outline of the case. I usually tend to, in today's age, I think that there's so much bloat with the rise of ChatGPT and like free AI services that you get these cases that are hundreds and hundreds of pages long. I don't like to do that. I like to keep it like a cover memo, 10 pages, 15 pages, 10 pages, something like that. And then, keep it real simple, keep it like a succinct package, succinct clarity. That's what you want,
Exactly.
You want them to understand the case very quickly.
And, applicants, they fill so much in their file. They think that, giving extra details will make them understand it better. But I think it should be straightforward, and
it should be straightforward. Yeah. We should take a page from our corporate, the wonderful companies here in the United States, like they do when they do these pitches, when VCs do pitches. It's not a pitch. This is like a pitch. It's like you don't have a 50-page document outlining the whole thing. No, you have like a 2-page summary here. This is what we're doing. This is what we're going to do, and like hopefully the examiner can understand this right there from the get-go, from that page. I just want to I took a tour of the Texas Service Center about 10 years, probably about 8 years ago or so. And on that tour, you get to see what the officers do. And like, they told us that these cases are usually hundreds of pages long. They're about 500 pages each one. But the officer maybe adjudicates the case in 20 minutes or less.
Right.
So you want to come in there with a quick, succinct presentation, just so that like, you know what, we're just going to hit the approval button, we're done, move on.
Exactly.
Yeah.
And I think 15 pages are more than enough, right?
Oh yeah, for sure.
Right. Okay, thank you so much, Daniel, for the explanation. Moving ahead, I would also like to take a few more questions.
Sure.
Yeah, like this one. So, when writing a proposed endeavor, should I target a broader audience or a specific state? The state which has the highest number of cancer patients. My proposed endeavor is liver cancer and regenerative therapeutics.
Well, I think that I would I would say that I can't think of any time where I've targeted a specific state. Hey, I am going, but you could have a case where I'm going into disadvantaged areas, and I'm going to help with cancer patients, or rural communities or something like that. Yeah, I mean, I think if I had a case like this, if it depends on, you talk to the client, but like if the client says, like, look, the state of Louisiana, the state of Utah has a special program to help things, and I am actively doing it, and this is a model for other states, I would definitely focus on that state if that's what you're truly doing. But, I think that it's like the concept that you have to lock into one might not necessarily be true. I think you should, just tell them the truth. Like, this is what I'm doing.
Exactly. That is how it should be.
Yes.
Oh, okay, great. So, Daniel, let's take one, I think, few more questions we take.
Sure.
So, yeah, this is the question.
Okay.
This is quite long. So, should we take it? Are you okay with it?
Yeah, I can take it. That's fine with me.
Okay, great. So, he's asking that I'm writing outside the USA. I
Hmm.
recently completed the documentarily qualified stage with my wife in my NIW process. Now
Hmm.
I'm waiting for immigrant visa processing, and I have
Right.
had a newborn baby since
Hmm.
then.
Hmm.
I have
Yeah.
submitted a request through the public inquiry form to add my baby along with the required documents. I have a couple of questions. So, firstly, am I on the right track with submitting the request via the public inquiry form to add my newborn?
I think so. I don't actually, the consular processing. I don't have all that much experience with it, but this is what I do. Is usually, I when I have a NIW abroad. By the way, you can file for an NIW anywhere in the world. You don't have to be here in the United States. Most of my clients are here in the United States,
Mm-hmm.
but I take international cases all the time. I think that you contact the consulate and let them know that you have a newborn baby and that to release the DS-260 for the new kid, and then you just follow their directions. I think you submit the birth certificate and stuff. It's pretty. You just follow whatever they're saying. You say I need to do this, and they'll tell you how to do it.
Absolutely. And
Yeah.
Daniel, there's also a second question that how long does it take typically for the NVC to review and respond to such updates?
Well, I had this is actually a pretty standard scenario that like the client, um, the client. I've had a lot of cases in China with that they have a kid after the NIW is approved, or yeah. So it usually doesn't take too long. It takes like maybe several weeks. You get a email and then you provide them the copy of the relevant documents, whatever they need.
Oh,
Yeah,
wow. Great. Okay, and the last one is that which NVC email did they respond my query? Has anyone gone
I don't
through?
know.
Yeah,
I don't know. I don't know.
exactly.
Yeah,
Okay.
again, the consular processing is highly specific to the post.
Mm-hmm.
Of course, there's general patterns and how you do this stuff. But in general, like I have most of my clients are here in the United States. I do have some abroad, but so I have a lot of consular experience with China, Guangzhou, and things, but not so much on the on Indian clients for NIW. Yeah,
Okay, okay. All right.
yeah.
So let's take up, I think, okay, let me take another one. Yeah, this one we can take. That I got EB2 NIW approval as
Yeah.
priority date moving slowly. Do you suggest to file EB1A with PP for fast processing?
Well, that's a good question. Okay, in the scale of cases, all right. I think the national interest waiver is, a little. It's much easier than an EB1A, much easier,
Yeah.
and it's even. I think that the national interest waiver historically is easier than an O1 case. So if I have a client who has, getting the NIW approved, it's this wonderful avenue and all this stuff. But in the scale of things, like I think that, like, well, if you have a O1 approved, that's a pretty good sign that you might be eligible for EB1A. Whereas an NIW, I'm not so sure. You have to look at each case
Right.
as in an individual level. And I think it's very important to be frank with the clients. The demand is so high for EB1A, because of rightfully so, because of the priority dates, that, so many clients want to build up their profile
Mm.
for EB1A. And, does it work? Yes, but it's a lot of people have ambition, but it's not, to actually apply that to get it done it's challenging to get to that level.
A lot.
Yeah, yeah.
Course, of
Yeah,
course. And
yeah.
also, Daniel, there's a continuation with this question that then immigration demanding 2,500 to 3,100 USD fee plus 1015 petition fee and PP 2,800 USD. Is there any other reliable US firm with less rates? Is it true EB1A has more chances of RFE?
EB1A definitely has more chances of RFE. The 1015 is just the filing fees. That you can't do anything about that. And petition 2800 is also the things. I don't know that price seems. I don't like to talk too much about price, but that's tends to be that seems like a pretty low fee to me. For NIW for things in general. I think that I charge anywhere. It's going to be $5,000 to $6,000 usually for these cases. But it depends on the client. I don't know. Yeah, EB1A definitely has a higher chance for RFE. No question about it.
All right. Okay. So we are definitely going to, share these information. And Daniel, here we have one more question that my EBNIW case approved from USCIS and my PD is 18th March 2024, while I have received first notice of information from NVC and they mentioned my PD 18th May 2024. For
Mm-hmm.
correction in PD, I sent two times inquiry to NVC. They replied the correspondence submitted is currently under review, and appropriate action will be taken once this review is completed. So her question is that I want to ask how much time I should wait for the correction. Is there any other way to contact NVC, or should I inform USCIS also that my PD is wrongly delivered?
I think that it sounds to me that on the I-140 receipt notice, the original submission, I'm assuming that the correct date was there. The 18th of March. For the PD issues, I think that what they did for the review sounds reasonable. Letting them know that there's a problem, and just showing them the receipt notice from the original one and then the approved case with the number should be enough. One of the things, if you use premium it's hard for me to say how you do it on state side, with consular processing. But if you have a problem with this if you have premium processing, one of the wonderful things that you can do is you can call the premium processing phone number, and you can speak to an officer and just say, hey, my date's wrong. Can you correct that for me? This is a clear error. And usually they're okay with it, making these kind of minor things, they note it and move on. Yeah.
Absolutely. So I think, Daniel, let's take one more last question.
Yeah,
And I think let me take,
sure.
yeah, this one. So, Daniel, yeah, is it mandatory or recommend to use USA address in I-140 and especially which section, EB2 and IW?
Oh, this is a very good question. Actually, okay, so national interest waiver is not based. You should put a U.S. address where you intend to work or things. So you pick a state. I am if you're abroad. And you say, I intend to work in New York City. I intend to work in Texas. I intend to work things. A lot of clients ask me, the way that they adjudicate these cases, it's done, geographically. If you live in one, the Nebraska Service Center will handle it, or the Texas Service Center will handle the national interest waiver. And people ask me about form shopping, should I move? Should I have my address so that the Nebraska Center is adjudicating my case versus the Texas Center? I tend to say no. You shouldn't do that. You should just have a true where you intend to work in the United States, or where you think, or the most likely address. It is important. So if you have the mailing address that you put on that I-140, try to make that a stable address, because I've had over the years, one of the most annoying things is that sometimes I have, the green card will go to the original address that was, submitted on either the 45 or the I-140, and the client has subsequently moved without telling me, and then, it's like a mess. Once I had a client had to go from New Mexico to Indiana to pick up his green card.
Oh my God.
It was at the post office, and it's like, if it gets messed up, it's really expensive and hard to get them to correct this stuff.
Absolutely.
So be careful of those addresses. Yeah.
All right. So I think we are done with our Facebook questions, and we are almost come across for 1 hour too. So,
Okay.
Daniel, yeah, I think it's time for us to wrap up the session as we have already covered 1 hour. So, Daniel, first of all, you tell me, how was your experience to Immigration and Jobs Talk Show?
Oh, this is great. I love talking to an international audience and talking live. It's a lot of fun. I hope to spread the word of the wonderful benefits of using the self-sponsored cases like a national interest waiver. I do handle other self-sponsored cases too, like EB1A and things. But it's always a pleasure to talk about this stuff and then talk about the cases and where things are going.
No, and that too, we can also see you were so energetic and full of information. So I think not only we, our audience also loved your insightful session, and it was so great to have you. So, Daniel, any last message that you would like to give to our audience?
Well, I would like to, one of the things that I'd like to do is to encourage people to have confidence in themselves and confidence in their abilities, and that these cases are possible, that it isn't something that you are beholden to, an individual employer, that you can take control of your own situation. Now, I know I am fully aware of the backlog and all the hardship that has caused, and, the things. But I still think taking ownership of your status is a wonderful thing, and it's empowering. It's great, and I hope that clients take advantage of this and use an expansive view of these things.
Correct.
So,
and I think that's a very positive message. So thank you so much, Daniel. It was great. And to our audience also, guys, if you want to ask anything, any question related to NIW or anything about immigration, so feel free to reach out to Attorney Daniel Stephen Larson on the given details. That is 415-520-1474. You can also
yes.
email him at contact@larsonlegal.com, and surely visit his website, that is www.larsonlegal.com. So, all right, guys, thank you so much. And thank you, Daniel, to you too. It was a pleasure having you, and it was great, to host with
Yeah,
you.
it was a tremendous honor and pleasure to be on your show.
Me
The
too,
show.
me too.
Yeah.
Same here. Okay, guys. So, thank you so much, everyone, for joining us today, to all our lovely viewers, and to Attorney Daniel Stephen Larson. Don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. I'm Sam, signing off for now.
Thank you so much. Take care.
Happy to be back here. And thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and also Twitter. And I'm happy to tell you that you can also participate in this webinar with us. But before we move ahead, I have this very important disclaimer, and that is By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, once again, thank you so much for joining us today. And we've got a great session lined up for you. And today we are diving into a topic that's vital for many businesses and workers across the United States, the H2 visa program. And so, whether you are a business owner seeking to sponsor seasonal or temporary workers, or a worker instead in learning more about your options, this webinar will be invaluable. And I'm really thrilled to be welcoming our guest for the first time on Immigration and Jobs Talk Show, none other than Meagan Kirchner, who is the founder of Kirchner Law PLLC. With nearly a decade of experience in immigration law, Meagan has become an expert in H2A and H2B immigration matters, and she'll be walking us through everything today you need to know about, legally sponsoring workers and also exploring the processes of working as a seasonal temporary worker in the United States. So, yes, I think you can go grab a pen or paper if you're still the old school, or maybe even note down some pointers in your tab or your phone or your, iPad. Thank you so much for joining us, and let's get ready to really learn some key highlights today and these insights that Meagan is going to, share with us. So, Meagan, thank you so much for joining us today. Really happy to have you here.
Hi, great to be here. Thanks for having me.
Yes, Meagan. I don't know if the introduction was enough, but we would love to know you much better. Please tell us about yourself and how busy you are these days.
Sure, like many immigration practitioners, it's a hot time. There's with unemployment where it is, everybody is just looking for people to fill empty slots. The H2B and H2A realm is just extremely busy. I service employers all around the U.S. In both H2A, which is agricultural, and H2B, which is non-agricultural workers in the seasonal temporary visa process. Been doing immigration for over 10 years now, and it is a hot segment right now, and we're all on pins and needles with the U.S. political climate, and just hoping we stay busy.
We are. I already feel it is, and especially with the elections just over just some time back, and everything
Yes.
changing right now. And in the next coming months, we're going to see a lot more
Mhm.
changes. I think there's a lot
Yeah,
on our plates, on everyone's plate. So,
very much so. A whole another segment for that.
for sure, Megan, for sure. And today's topic. So, what can folks out there expect from today's webinar from us?
Sure. So today's focus is really going to be on the H2B side of the seasonal worker program. The agricultural H2A side, it would have to be a whole nother show. But what you should learn, how an employer would get involved in the program, whether or not they would qualify, how the process looks, what the risks are. What compliance components they need to be aware of, what workers should know and what they should know their rights are in the process so that they are not taken advantage of. So really just trying to focus on giving a little background knowledge from start to end, on the employer side, and touch on the, employer rights side as much as we can.
We will. And I'm sure folks out there are very excited as well. So happy to tell you that you can participate wherever you're watching us. And if you have any questions, especially regarding the topic, please feel free to drop them in the comments. And Megan is definitely going to be very happy to take them up later in the show. So I'm excited too, Megan. Thank you so much for doing this today. And
Sure,
without
happy
further
to.
ado, I have a few questions lined up. So let's go ahead with the first one.
Sure.
So, what are the key steps an employer must take to obtain a temporary labor certification from the Department of Labor for H2B workers, and what documentation is required?
So, just as a little bit more background, the H2B is a full-time temporary non-immigrant visa. It is seasonal. So unlike many other visa types, it's something you have to apply for every year. unless you're doing a one-time need. That's a separate category for like a nanny or a caregiver. That would be for up to 3 years. The rest of the visas, the bulk of the H2B process, for your hospitality, landscaping, seafood industries, construction industries, those are seasonal or peak load, meaning it's an annual application. It involves 3 separate government agencies. That's Department of Labor first. We'll get into what that entails in a minute. The USCIS, U.S. Immigration Services, is the second agency, and the third would be Department of State. That's the consular processing. So that's where the worker would come in, and that's at the point that they would go get their visa. The first step in the process is critical. One of the key compliance components of this program is that all workers are paid at least a prevailing wage, which is mandated by the government. It's to ensure that they're receiving a fair wage based on the type of position they're working in, and the location and experience required for that position. So, it just really ensures that the program maintains its integrity and no one's being paid something that's too low for what they're working on. That's the first step in the process. All of these steps in this process can be time intensive. So it is very much sensitive to what part of the year you're applying for, what your dates of need are. So this prevailing wage step takes up to 60 days sometimes. So you really have, for all parts of this process, you need to allocate at least 6 months. You need to know at least 6 months ahead of time in order to ensure you have enough time to file with each agency. The way the program is set up is that there's 2 halves of the fiscal year. So that if you're based on your start date of need. So if your start date of need is in October, you'd really start prevailing wages more than likely in April, so that you can file in July. You file your H2B application, which is an ETA 9142B. That's the second step in the process. Once you have prevailing wage, you can start that process. And again, if you're at April 1st start date or later in the second half of the year, it goes by the government fiscal year, which starts in October. My apologies. You will need to start that process probably in August of the preceding year. If you're looking for instance, starting an H2B worker April 1st, 2025, you're going to need to have already started that process. It may be too late at this point to get a prevailing wage back in time to start the process for next spring. That being said, once you've gotten that prevailing wage and you file the second step in the process also with Department of Labor, that actual H2B temporary labor certification, that would require you to set forth with the government whether you're filing for one-time needs, seasonal, or peak load. So that would entail documentation if you're a new filer, a new employer, establishing your seasonality, establishing your season and your need for the number of workers you're requesting. Typical documentation would be a statement of need, which again explains your business, your season, your industry. Taxes for the company, could be revenue charts, payroll showing when you have workers. Those are very common documents, as well as contracts. Really what you're showing at this stage is that your business operates either seasonally, meaning you only operate during the season, the times that you're telling the government you operate, or that you're peak load, meaning you operate year round, but there's a peak, there's an objective increase in your business or revenue during particular months of the year. That would be your season. So all of those kinds of business documents can prove that seasonality, prove that temporary need. Now, that application gets lodged with the government on one of 2 time periods, depending again on your start date of need. It's either July 3rd for October 1st filings or January 1st for April 1st filings. There's technically a 3-day filing window that you have at the beginning, but it starts on January 1st and July 3rd, unless it's a leap year. So that's when you file that application. The next step after you actually lodge the application with your supporting documentation is your company will be, this is what they talk about when they talk about the H2B lottery. All of the employers are put into a pot in a computer and randomized. Your company will be assigned a group letter, A, B, C, D, and so on and so forth. And while that letter or that group doesn't truly dictate whether or not you get workers, it's more nuanced than that. It does impact the timelines, and more so for the spring visa half than the winter. That letter will determine whether you beat the cap from in all cases for the most part for the spring. It's there's enough employers or applications for the number of workers in Group A, for instance, in the spring to encompass the entire cap. So if you don't get it, that's not to say that if you don't get Group A, you're not going to get workers. We'll get into it later in the program over what the cap is, if there's other ways to get in under the cap or other mechanisms to file with supplemental visas. We'll talk about that in a little bit. But assuming you get in and there are still visas available to file the next step is filing with Immigration Services. You take your certification from Department of Labor and you file it with the USCIS. If you're approved, then you can move on to Department of State and file for the actual visas. There are more steps, such as recruitment, involved in the Department of Labor step before you get your certification, but we'll kind of delve into that a little bit later when we talk about recruitment and things like that. So there are a few more steps involved with Department of Labor before you get to USCIS, but that's kind of in a nutshell, the general steps.
Thank you so much, Meagan. Those are really good points to keep in mind. And thank you so much for highlighting, especially the documents required. So thank you so much. Folks out there, I know you are excited as well. Thank you so much for joining us. I'll quickly say hello to Tanya and Nishtha, who have commented with their questions. Please stay with us. We are going to take them up a little later. So right now, another question I have for you, Meagan, and that is, how does an employer demonstrate that there are not enough US workers who are able or willing or qualified and available to perform the temporary work as required by the H2B program?
Sure. So that is what I alluded to a little bit ago with the
Yes.
additional steps that are really happen between filing your temporary labor certification application with Department of Labor before you get certified. There's something called recruitment. At this point, the recruitment, every employer, once they get their notice of acceptance, they will, meaning that the government hasn't asked for any additional documentation, the government could issue what's called a notice of deficiency asking for more information. But if they don't do that, you get a notice of acceptance and then starts recruitment. The recruitment process is how the government essentially asks each employer to test the U.S. labor market to ensure there are no qualified U.S. applicants who can fill these roles. The recruitment period lasts 15 business days for most of these steps. However, every employer still beyond this recruitment period, at the close of which, at the end of the 15 calendar days, the employer will file a recruitment report which details every U.S. applicant, how they applied, whether or not they were hired, the outcome of that interview, if there was one, if they're able to reach them. Based on that recruitment report, the government will then certify the employer for either the full complement of H2B workers requested, or they will reduce that number based on how many U.S. hires they make. So if you're asking for 10 H2B workers and you are able to hire 2 U.S. workers, then you've proven to the government that there are 2 qualified U.S. workers. So your true need is only 8 workers. But in order to get to that process, there are a number of recruitment steps that every employer must take. The first of which is an internal posting notice in their job at the job site. So whether that is a break room or an HR office or a primary office, at least 2 spots at the place of employment must post this H2B job order. So that would have the terms and conditions of the H2B position, any job description, title, location, deductions, benefits, all of that information is required in this job order that gets posted at the work site. Now, in addition, that same posting, the same content at least, is posted on the state workforce agency. Every state has a different process for posting jobs that are available to local candidates. Think of it as like Indeed, but it's run by a state. So these postings get put online with the state workforce agency, and every employer must field applicants that are interested in the position. Another required recruitment step is, which again protects U.S. workers, is every prior U.S. worker that employer has had in the past year must get a copy of that job order so that they know they're hiring for that position again. The only exclusion would be workers that were terminated for cause or workers that quit or abandoned the job. So those workers would not get a letter, but other U.S. workers that may have worked seasonally in the past year would be entitled to know that this job is open again. Another item that could be by phone or certified mail is the best way, so the employer is protected and you can prove you've sent it to them, the last known address. Another less common recruitment step is if the employer participates in a collective bargaining agreement, they must publish that job with the CBA representative so that it's advertised across the organization. If the employer has a website or somewhere else internally, an intranet, they normally post jobs, that would also be somewhere that would need to have the job posted. If they have one. If they don't have one, it's not something that they need to create for the purposes of H2B. It's only if it's normal course of business for them to post jobs in that manner. The last part of recruitment is performed by Department of Labor. Department of Labor will post the job order on seasonaljobs.gov and make it available nationally so that anybody who's looking for H2B jobs or anybody that's looking for a job it'll come up on a search. So if someone searched landscaping in Richmond, Virginia, it may come up. It would be available on that website. So the last component that is important for U.S. workers is to know is that this job rec, even once that 15 calendar or business days have passed, while it won't impact the number of workers the employer is able to get with H2B, they do need to continue to accept U.S.-based applicants up until 21 days before the start date. So it's not going to impact their H2B worker count, but they do still need to field U.S. applicants. They are obligated to do so. Again, the purpose of that is just to ensure that there's no additional opportunity afforded to foreign workers over U.S. workers.
All right. Thank you so much, Meagan, for for the detailed explanation and helping us with the answer for that. Thank you so much. I have this next question for you.
Mhm.
So, what is the current cap on H-2B visas for fiscal year 2025, and how can an employer access the additional supplemental visas announced by DHS?
Sure. The annual quota for H2B has been 66,000 since the 90s. And it's divided into two halves. The first half of the government fiscal year on October 1st, is allotted 33,000. The second half of the government fiscal year, which opens on April 1st, is also allotted 33,000. The demand far outpaces supply for those initial visas year over year and has for a decade. So in 2017, they started issuing what are called supplemental visas. They are not in the regulations. They're not guaranteed, but the government does have the ability to issue additional visas if they elect to do so, if they can agree to do so. This year, they did announce that they will issue almost 65,000 additional visas for this fiscal year. However, the text is not yet available for the 2025 fiscal year, but if we assume it's the same as the past two fiscal years, which it has been largely the same as far as eligibility and compliance, then we can expect it to be broken down such that a portion of those additional visas will be allocated to the first half of the fiscal year and what they call returning workers. So if you've never had an H-2B, you're not going to qualify for the supplemental visas under returning worker exemption. Those are workers that have had an H2B at least one time with any employer in the past 3 government fiscal years. So if you had worked for anybody, you would be eligible if your employer wants to file for supplemental visas. So again, that is just a little bit of a security net for employers that miss the initial cap, that they have a second opportunity to try and take advantage of the H2B visas for this year. There's also an allotment similar to that for the spring. In other words, if you miss the cap for April 1st in the spring, again, if you have workers or know of workers that have had an H2B at least once in the past 3 years, they would qualify as returning workers. And there will be visas in the spring as well in that same category. Additionally, the spring has another category of returning workers. Typically, that is reserved for late season H2B employers. So if your start date of need is not April 1st, if it's May 15th or later in the year, there's a separate carve out for supplemental visas in that for returning workers for those dates for those employers. The last option for supplemental visas is what used to be called Northern Triangle. Now it's called country specific allocation. It is open to workers from a specific set of countries that have never held an H2B visa, but employers, there's a brand new cap from these supplementals. So if the employer will take recruits from this subset of countries, then there's a whole extra 20,000 visas available to employers who will recruit from these separate countries. Those are Haiti, Honduras, El Salvador, Guatemala. They just added Costa Rica, Ecuador, and Colombia last year. And so I think I might have missed one. Honduras, I think I'm not sure I've said that already, but those countries are a great option for employers who don't have returning workers and have missed the cap. Because the nice thing about that part of the supplemental visas is in the years that they've been offering those, that cap has not been hit to date. As there's first year for everything, but those are a more reliable and a little less risky pool of visas to pull from because they have been more open.
All right. So, yes, thank you so much, Megan, for saying that for us also and for the detailed explanation. Well, maybe you could highlight also, how the H2B is different from the other employment visas,
Oh, sure.
for folks out there who want to know where can they categorize themselves.
Right. So, as we know, there's an alphabet soup of non-immigrant visas available. All of them have their own eligibility requirements and stipulations. H2A, those who are going to qualify for H2B probably will qualify for H2A from the worker standpoint. Employer standpoint, that's reserved for agricultural companies, employers that work in the agriculture section. It may be farms that do produce. It just depends. There's a lot of agricultural employers that take advantage of H2A. There are other visas, so H2A and H2E generally don't require degrees. That's not necessarily true across the board, but it is the only category that's going to have people, without any required specific training. There may be experience or training requirements employer to employer, but as overall, if you're from a country that's on the eligible country list, which you can find online, there will be ways for you to get seasonal employment if you don't have a degree. Those are what H2A and H2B are really good for, as far from a worker standpoint or from a prospective visa holder standpoint. There's TN visas if you have a degree that, if you're from Canada or Mexico, there's a whole list of occupations and there's no cap for TN. So if you have a degree and you're from one of those countries, or if you're, an employer looking for a particular occupation that falls on the TN list, that's a great way to, have workers come in that way. TN, there can be some crossover for some of the occupations that are very similar to the kinds of roles that you may want for H2B. For instance, a landscape architect would fall under a TN or veterinarian or an animal breeder or something like that that's related to farms, but maybe you need someone with more skills, more training.
All right.
So something like that. And there's a whole host of other visas I could go over. I don't know how many of them you'd like me to talk about.
But yes, thank you so much. Thank you so much for highlighting those differences of the H2B and other employment visas. Thank you, Meagan. And Meagan, we have a viewer who has joined us. So nice of him. This is George from Nigeria. We're really happy that you have joined us. So we would love to take a couple of questions from George if he has any. So Control, if you could just let him in. Yeah, please ask your question. George, are you there?
Yeah, can you hear me?
Yes.
Yes, we can hear you now. Great.
Okay. Um, the question I was gonna ask had to do with um, you loosening up a little bit regarding your policies. Um, like I said yesterday, everyone does not have to come to America. Okay.
Mhm.
If you if the government actually loosen up a little bit, let's say, just like what you're talking about, they have quarters they're giving for H2B visas. So if you have search for remote, you tell the companies, look, you can get anyone outside of this country. They don't have to come to America, but they're going to be working on the remote basis, right? And
Mhm.
before you have to pay their salaries, then do what they call tax deduction from the salaries before you pay out, right? So I think if that would be looked at, it will be a very good idea, because one of the reasons why you have the Americans coming up with several immigration policies is because you have a lot of people
Can you hear it? I can't hear.
I think, yeah.
papers or documents are being expired, and then they also want to continue the work. Can you still hear me?
I
Yes.
missed that middle part.
Yeah.
I heard that if their documents are expired, but I missed a part
Hi,
of
can you
that.
hear me?
Yes, we can hear you. Could you just repeat the part where just some time back you were saying? George, are you there?
Yeah, I'm
I think
here.
I think
So
okay.
did you get what I said?
No, we didn't hear the question part. I'm sorry.
Could you just repeat your question, please? The question you just asked some time back. George, if you're still there.
Yeah, I'm here.
Uh, so sorry, we couldn't get your question. Could you just tell us what your question was?
Okay, the question is, can American government look at, loosening up a little bit and allowing companies, independent companies, actually employ people from other countries without they coming to America and, the American government providing some sort of tax identification number for remote workers. I think if you encourage that, that would actually strengthen the job quality you have over there, and also
The government here in the U.S. has been very apprehensive about changing policy. I mean, like I said, just in my experience with H2B, the quotas have not changed since the 90s. So while there may be many ideas that would be beneficial to both the U.S. economy and workers abroad, I would not expect there to be any meaningful change or positive additions to immigration, particularly with the upcoming administration change. I would not expect that to happen right now. That's not to say it would never happen, but I wouldn't expect a tremendous amount of change, at this point. There are many other countries that allow, such as things like digital nomad visas, where they can come work remotely from their home country in the U.S. and do things like that. We don't have anything like that here. Our immigration categories have been fairly static for quite a long time. We have not had comprehensive immigration reform since the 90s. And with the polarization of this topic overall, from an employment and family-based side, I just would not expect there to be any change. There may be many great ideas that people could bring to the table, but adoption or passage of that would be very difficult in this climate.
Thank you so much for taking that up. And George, do you have any other questions? George, are you still there? All right. Thank you so much, Megan, for taking that up for George. I think there might be some network issue, but I hope George got the answer he was looking for.
Sure.
And if he has any further questions, I'm sure George will drop them in the comments or maybe rejoin us soon.
Sure.
Meanwhile, I think let's take up Tanya's question. I run a small landscaping business and want to hire workers for our busiest season. How do I start the process of sponsoring workers under the H2B visa? And are there specific forms or steps I need to prioritize? I think we touched on this earlier already, but if you could just
Yes.
highlight, yeah, anything.
Yes. If it's landscaping, I would assume your busiest season would fall in the spring. So at this point, the first step is starting to file a prevailing wage application with Department of Labor. That's the very first step required, no matter where you're filing, what position you're filing. So you just need to know what position you're filing for and get that application lodged with the government. You can't move on to any other step if you don't do that first. So you should find someone that can file that for you. I have a great number of landscaping clients. So I'm very familiar with that process from start to finish. At this point being mid to late November, it would be very tight to try and get that filed for next spring. Unfortunately, it's not impossible, but timing would really have to work out in your favor. That's the first thing you need to prioritize. And if the only other thing I can say that is if you have workers you want from a particular country, make sure they're on the country list. I get a lot of questions that say they know somebody from X country and that country is not eligible for H2B at all. So if you're wedded to one particular person, make sure that they qualify before you bother starting the process.
Great. Thank you so much for taking that up for Tanya, Megan. Thank you so much, Tanya, for participating with your question. And I have more questions lined up, but let's take up Nishta's question first. I've worked under an H2A visa before. Can I apply for H2B visa next, or do I need to wait for a certain period of time before reapplying? Uh, and how soon can I reapply for an H2 visa after my current one expires? Is there a limit or on how many times I can apply?
Mm-hmm. Okay. So the answer is it depends. For part of that. So if you have been on an H2A visa, whether or not you can apply for the H2B visa, it just depends on how long you were here on the H2A visa. So one of the eligibility requirements for H2 workers, whether that's H2B or A, you have up to 3 years of H eligibility, at which point if you enter, say, January 1st, 2020, then your H authorization would have expired in January 2023. So you have 3 full years of eligibility. You can reset that by, if you've been outside the US for 3 consecutive months, then you reset your H time and you get another 3 years. So there's no limit to the number of times you can be on an H2 visa, A or B, but there are time limits for each stay. So if you were to come in, like I said, say April 1st, and you change employers, so you're never out of the country for more than 3 months, then you're going to be limited to 3 years. And at some point during that 3 years, you need to reset. You need to be outside of the US for 3 months to get more H time. And that, you can certainly have an H2A visa, go home, get an H-2B visa, and come back. That's fine. You can do both. There's nothing to preclude you from participating in both programs. You just need to make sure you're aware of what your limit is and make sure that you've been out to reset that clock at least for 3 months if you're here for that long.
Okay. Okay. Thank you so much for taking that up for Nishtha and for the detailed explanation, Meagan. And now we have Samuel. Samuel is on YouTube. He also has a question asking administrative processing in H1B visa for 9 months. What can be the cause?
There is not very much transparency for administrative processing. For instance, if I, as the attorney, email the consulate and ask, why is this an administrative processing? What do you need from me? What do you need for the worker? They will give me a canned response that just says it's an administrative processing and we'll contact you if we need anything. There could be a whole host of reasons why you might be in administrative processing. Your name, it could be something as simple as your name is similar to someone who has some overstay issues or a travel issue or is on a list somewhere, flagged in the system. It could be that you've overstayed. It could be that they're unsure of your intent to return home. That's called, immigrant intent. They could be questioning whether or not you will stay permanently if you're issued the visa. There's a whole number of reasons that we'll probably never know the answer to, unfortunately. For instance, I just had someone try to process in South Korea, and she has no red flags. She's no criminal history, one prior U.S. visit. There's nothing on paper that should have precluded her from being issued a visa, but she was put in administrative processing briefly, and then, certainly not 9 months. But the reason they gave ultimately for being refused was that they questioned whether or not she would return to her home country at the end of the visa. There's the consular officers are given a great bit of discretion to review the applications, and they don't give us a lot of transparency. I said South Korea for that process. So, there can be and this would come up from any country, anybody from any country on the eligible list. And sometimes there's a surprise like that. For instance, that client, it was a surprise to have that happen. There were no indications prior to going to that interview that there would be any issues. So I wish there was some way to find out why you're in administrative processing.
Right.
But there's not very many good ways to do it.
All right. Thank you so much. Thank you so much for taking that up for Samuel. Samuel, if you have any further questions, you can keep commenting and we'll be addressing them very, very soon. Thank you. And now let's take up Mukesh's question. This is also on YouTube. He asks, if our company hires an H2 worker who doesn't show up, what are our obligations and potential liabilities? And what happens if an H2 worker gets injured on the job? Are we liable?
So I'll take up the first part of the question first. So if you have H2 workers and someone disappears, they abscond. That's typically if they haven't reported to work for 5 days, they have been non-responsive, they're AWOL, they've been absent without leave for at least 5 days. You can report them as an abscondment. So, and you are required to report them if you know they're not coming back. For instance, if they've quit or left in some way and they're not coming back and you haven't given them permission to leave. People leave all the time, but your obligation as an employer is within 2 days of knowing that they're not coming back. So they told you they weren't coming back, or it's been 5 or more days and they haven't reported to work. No one knows where they are. You can assume that they've absconded. You have to report the departure to the government. You have to report it to Department of Labor, and you have to report it to Immigration Services. That will insulate the company from being on the hook for the 3/4 guarantee when the worker's not there. So that's one of the compliance requirements. We didn't get a chance to get into those today. But on the employer side, one of the requirements is the 3/4 guarantee, meaning that it's a full-time position, 35 hours or more. Mm-hmm. You have to, as an employer, offer them at least 3/4 of those hours offered, whether you say it's 35 hours or 40 hours. If you have to report them as missing or absconded, or if you fire them, you still have to report them as an early departure. It's one of the compliance requirements is to report a missing worker. As far as workplace injury, that falls outside of the scope of immigration, and it's going to be based on your state law, whatever your state workman's comp is. You would be liable in the same fashion as you would a U.S. worker. So if would be liable for workman's comp for a U.S. worker, it's going to apply for an H2 worker. Now, on the worker side of that, if they're injured on the job and need surgery and can't travel and the end of their visa is coming, they need to look at changing it from an H2 visa to a B visa, a visitor visa, and do a change of status so that they're not here unlawfully on the H2 because they're no longer working. So it comes up in rare cases, but yes, if someone's injured, they need to make sure, and they can't travel home for treatment, we have to be able to make sure they stay in status.
Right. Thank you so much, Meagan, for highlighting and for giving us such important points today. And thank you for also taking up Mukesh's questions at the same time. Thank you, Mukesh, and you can keep commenting if you have more questions. Now, coming back to our questions, Meagan, I have another question, and that is, what are the robust protections in place for both American and foreign workers, under the H-2B program, and how must employers ensure that these protections are met?
Right. So there's many protections for both U.S. and foreign workers. On the U.S. side, there's it boils down to making sure that a possible U.S. worker is not treated in any less fairly or afforded any fewer opportunities or no more requirements than would be required of a U.S. worker. For instance, if you're filing a landscaping position, a corresponding worker couldn't be required in the U.S. to have 5 years experience when you require 0 experience for a foreign worker. So, each business, when they file the application with the Department of Labor, has to sign an attestation with all these compliance requirements listed, noting that they understand what those requirements are and that they will abide by them while they're participating in the program. Now, workers, to start out with, for corresponding workers or foreign workers, they should get before they start, or if they're a corresponding worker and they may already be working, because that could be a worker that's worked for a year or less with the same employer. So again, corresponding worker means it's a U.S. worker either present, already working, or one that you hire during the recruitment process that performs substantially similar duties, same job. That would not be your secretary or your landscape manager if you're coming in as a groundskeeper. If you're just doing a landscape laborer job, corresponding workers on the U.S. side would be the same position, not something that's unrelated. So again, the employer can't impose any requirements or obligations they wouldn't impose on the H-2B worker, and they also, have to pay them at least the same as they're paying the H-2 worker. Now, anyone in the H-2B process, which is going to apply to corresponding workers as well as H-2B, because if you have H-2B, then you have corresponding workers more than likely. A big component is prevailing wage. That prevailing wage is the first step. I talked about the employer process, but it's important for the workers because when you get the terms and conditions of employment before you start, which tells you what kind of job you're applying for, where it is, who you're working for, what the wages are, whether or not there's overtime, what benefits are included, all of that is given to you. So you can track it. You can make sure you're being paid what you should be. And that includes the prevailing wage. Every position is set by the government, and you have to at least make the H-2B prevailing wage. So you get that protection. Also, in H-2B, you're going to need to be paid at least every 2 weeks. They can't pay you once a month. There has to be regular paychecks. It's another requirement. On that same note, every employer is required to provide you with a pay stub, which provides you with the hours offered and the hours worked, the pay rate, overtime rate for every pay period. So that should be something that you get. Also, deductions. Unlike H-2A, which does not have to have with tax withholdings on it, H-2B, does have tax withholding. So your federal taxes and Social Security withholdings are withheld from your paycheck as required by law. But any other deduction aside from those lawful, required deductions, the employer has to have your approval to deduct it. So if you, one difference between H2A and H2B is that H2A housing is provided, H2B, the worker is responsible for their own housing. That being said, some employers will give workers the option to stay in employer housing, which means you pay fair market rent and utilities. If you are opting into that as a worker, you have to either pay the employer directly, or you can have it withheld from your paycheck. So things like that, health insurance, rent, utilities. Let's see, what's another common one? Loans, things like that could be a deduction on your paycheck need to be approved by you. And they need to be on your pay stub so that you can see what the deduction is. So, you just need to know what's coming out of your check, and you're entitled to know that. I talked a little bit earlier about the 3-quarter guarantee on the employer side. It's another thing for employees is that H2B is a full-time role. If you are offered 35 hours on your contract, you are entitled to at least 3/4 of those. If you're offered 40 hours, you need to be offered at least 32 hours, so you've got some minimum protections to make sure you're not doing nothing. You're getting paid for the work that you expected to be here to perform. And if they don't have enough work, they're still required to pay you for it. If it's rained, and it goes for every 12-week period. So there's a calculation for that you can look up. The employer should be aware of, that's an important guarantee to make sure you're paid as the contract says. Another important item that comes up is tools and equipment. There's no reason you should be charged for tools and equipment. That the employer provides all tools and equipment to perform the job. So that should not be something that happens. Another important note for protection for workers is visa fees. There's under no circumstance should the worker be paying for visa fees. You may pay them at the consulate. Some employers will do that, but you have to be reimbursed the first work week when you get here. Inbound travel, also something that is covered by the employer as part of the H2B program. That one is most employers will prepay it for you. Some may pay it when you get here. The regulatory requirement is that as long as you stay, you have to stay for half the employment contract to get the inbound transportation. But with federal wage requirements, a lot of times they just pay that with your visa fees up front because they can't take you below the federally mandated minimum wage by virtue of withholding that, by not having you reimbursing that travel. So the bulk of you will have your travel reimbursed when you get here, if not prepaid. Same thing, if you complete your contract, you do not leave early, you're not terminated, you're entitled to have the employer cover your return transportation. So you finish the work contract at the end of the season, your employer is responsible for sending you back to your point of origin. So that wherever country you came from, you get travel reimbursement back to your home. Very important. Same thing if you're terminated, you still get return transportation. The only time you don't get return transportation is if you quit early, or if you transfer to another H2 employer, then that new employer is responsible for paying your travel to the new employment site. So those are very important. Another very important thing that workers should know, and this comes up not in the employer context, it is an employer compliance requirement. Employers should sign something if they're using a recruiter, the employer should have something signed that the recruiter says that they're not going to charge workers a fee. No H2B worker should pay an employer or a recruiter a fee to be referred to H2B. Very important. It's not something that you should be responsible for. And violations for this, there are audits from Department of Labor, there are site visits, inspections. Employers are required to maintain an audit file with all of this documentation, copies of your pay stubs, copies of reimbursements. The employer should have copies of all of this. And workers also, there should be an H2B rights poster that the employer posts in the work site. That also will have details on how you can whistleblow, how you can report it. There's anti-retaliation components as well, so that the employer can't retaliate if you report wrongdoing or mistreatment.
Wow. Those are, I mean, a great number of protection rights and laws and rules and regulations you highlighted. And thank you so much, Megan. I think once you have the passion to work and you have the right documents and you're on the right path, I think nothing can stop you.
Right.
So thank you, Megan. And we have Samuel who's back with another question. I think we should take that up. He's asking, can my spouse, who is my dependent on an H1B visa that is in administrative processing, apply for a visiting visa?
There's nothing to preclude her from doing so.
Okay.
But again, there's very little transparency into that application process. So, it's possible for a spouse to also be put in administrative processing for anybody can be put in administrative processing for any visa, for them to review it. But there's nothing, just because you have a visa pending, that also doesn't mean she couldn't apply for her own H1B, her own visitor visa. There's nothing to preclude, again, assuming she's eligible or can qualify. Your being in administrative processing isn't going to prevent her from doing something else. Even if she's on an H4, she could still theoretically apply for a visitor visa.
Mm-hmm.
Whether or not it's approved, is anybody's guess.
That's cool. Thank you so much for taking that up. And Samuel, I hope you've got your answer. Thank you for participating. I have another question, Megan, and that is, how does the H2B program ensure that foreign workers are not exploited by the employers?
Right. So that a lot of the same things will apply from the compliance requirements. All of those compliance requirements are in place so that workers are not exploited. You have a prevailing wage to ensure the worker is not paid too little. There's, again, reporting opportunities with Department of Labor to report employers that are, misusing the program, so that your protections remain in place. There's also, depending on your state, there may be nonprofit or volunteer groups that can also provide services to help if you are, being subject to mistreatment. So, all of these protections and compliance requirements that you should be entitled to, they can be enforced in the same way. Though you can report them and they can be subject to penalties for that. And I don't know if we'll get to the penalty question or whether I should cover that here, but there are penalties that the employer can suffer based on that, depending on what the violation is. Again, the anti-retaliation requirements are important for that. Workers can file a complaint with the Wage and Hour Division with Department of Labor for any of those violations, for being charged a fee, not making your hours, not being paid the correct wage, being denied. Again, another thing that it doesn't come up often, but when there's severe negligence or mistreatment of workers, another thing you should report absolutely is if your employer is holding your passport. Your employer should not have your passport or visa. You should have free autonomy to leave at any time. Be aware of as a worker, the terms and conditions of your visa, and make sure you're not, by leaving, having an issue with your status because you're no longer at the employer. So, there are things to consider for that, but it shouldn't deter you from reporting mistreatment.
Right.
I don't know if you want to jump ahead to the repercussions for employers. I know that's another question, or if I should just get to that later.
Yes, we could get to that a little later, or maybe in our next episode as well, because there's so much to talk about H2B. But I would also like to tell our folks out there, that it's always best to consult an attorney and be guided with your case, because every case is different and needs proper attention. And I would say, why not contact attorney Meagan Kirchner in her number, and her number is 434-226-0586. You can note it down. You can also email Meagan. Her email address is meagan@kircherimmigration.com. You can check out the spelling on the screen and go visit www.kircherimmigration.com to get to know more about Meagan. Thank you so much, Meagan. It was really great. But of course, so much to talk about this. I think we should. definitely do another episode on H2A and H2B visas again.
Sure. Be happy to.
Yeah. But before we go, what do you have to say about Trump and, starting 2025? What can we expect, maybe, or what do you think the immigration scene is going to look like?
I was just at a conference in DC with other immigration attorneys on Friday, and we're all just ready to buckle up for the ride. H2 in particular was a little more insulated from some of the trials and tribulations that came from the administration last time. A lot of the other employment visas, family-based visas, are going to have much tighter scrutiny. Requirements may change. It's going to be more difficult. If, again, I know you mentioned a lot of people file on their own, but particularly with this administration change, having an attorney navigate the process will be more important than ever, because it's going to change, and it will change quickly, and more than likely not in any way that makes it easier.
I know everybody is so anxious, and I really hope that things fall in place as soon as possible, or at least folks out there get to know what can happen or what may happen with their case. So thank you so
Right.
much, Meagan, once again. It was great having you, and I really hope to see you in the coming week.
Nice to be here, and thank you for having me, and best of luck to everyone watching, and reach out if they have any questions.
Yes, absolutely. Thank you so much. And also Samuel, and then we had George who had joined us. Unfortunately, the line was a little disturbing, but I still hope that, George, if you have any further questions, you can comment, because after the stream has ended, this is going to be published, and it'll be really nice to have you comment with your question. And I'm sure, Meagan, you can address that. I will put that up to you.
Yeah.
You too.
Sure.
Yeah. Anything else you want to say to the folks out there with regard to the topic before we leave them? Because I feel like we're just ending it so abruptly right now.
Yes, where this is just the tip of the iceberg for the H2 world. I wasn't really able to dive in at a really granular level as far as what employers need to do, how long it takes.
Yes.
So I really just want everybody to know that it can be a long process, but with the right help, and starting at the right time, it doesn't have to be a painful process, as long as you start. But their timelines are critical for this program.
Right, right. Thank you so much for that hopeful note and an end note. Thank you, Meagan. And you have a splendid week ahead, and I'll see you soon.
You as well. Thank you.
Thank you. And folks out there, thank you so much for joining us on YouTube, LinkedIn, Facebook, and Twitter. It was really nice having you, and especially with your questions in the comments. So feel free to like, share, and also subscribe to our channel. Hit that bell icon so that whenever we have discussions like these, you are notified. And really, I'm also looking forward for Meagan to join us again in the coming week, because there's so much to discuss about H2 visa, and I'm sure you too have a lot more questions. So thank you so much for doing this today, and don't go anywhere, because we have more webinars and discussions lined up on Immigration and Jobs Talk Show.
Hi everyone, welcome back to Immigration and Jobs Talk Show. And before I move ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this important disclaimer, welcome back everyone to Immigration and Jobs Talk Show. And today we have an absolute treat for you. Joining us is the incredible immigration attorney Ralph Antonioli, and we are diving into a topic that can be a game changer for many. We will be discussing about mastering the O1 visa, a comprehensive approach to securing success for extraordinary achievers. Now, before we jump in, let's take a moment to appreciate the remarkable journey of our guest. Ralph Antonioli is not just any immigration attorney. He is a veteran with nearly 30 years of experience, specializing in business immigration, sports law, and innovative immigration solutions. As the founder of Antonioli and Associates, a respected firm based in Washington, D.C., Ralph has built a reputation for crafting legal strategies that are tailored as they are effective, meeting even the most complex regulatory requirements with ease. His expertise in O1 visas and other employment based categories is nothing sort of phenomenal. With an impressive 99.9% approval rate, a clear testament to his strategic and meticulous approach, but Ralph's story is so much more than just his professional achievements. His journey as an immigrant to the United States has given him a unique perspective and a deep commitment to helping others navigate the often complex and daunting immigration process. He's worked with firms of all sizes, from small startups to giants like Sidley Austin, one of the most prominent firms in the world, where he honed his skills and gained invaluable insights into the global immigration systems. Now, here's where Ralph's story takes a truly inspiring turn. In 2010, his life changed dramatically when he suffered from the rupture of three brain aneurysms, followed by 6 weeks in a coma and a battle against multiple life-threatening conditions. Given less than 1% chance of survival and told he would never walk, talk, or practice law again, Ralph defied every odd. He relearned how to walk, how to talk, and with unwavering perseverance, he passed the bar exam in Washington, D.C., an achievement his doctors thought was impossible. This near death experience profoundly shaped Ralph's priorities, inspiring a lifelong dedication to disability rights for advocacy within the legal profession. He's committed to increasing representation for disabled professionals, a group he passionately advocates for through the American Bar Association's Commission on Disability Rights, fluent in 5 languages and holding 3 nationalities. Ralph brings a global perspective and cultural sensitivity to every case. As an immigrant and as an attorney, he understands the challenges his clients face and is passionate about helping them achieve their dreams. Today, Ralph will share his invaluable insights on how creativity, meticulous case preparation, and thorough regulatory analysis can unlock opportunities through O1 visas. He'll guide us on how these visas can help extraordinary achievers from all fields access the US market and pursue their professional and personal ambitions. So now, without any further ado, let's welcome Ralph on Immigration and Jobs Talk Show. Hi, Ralph. Welcome to Immigration and Jobs Talk Show. It's such an honor having you on the platform. Thank you so much, firstly, for sharing that beautiful bio and beautiful journey of yours with us so that, I can read it out to our audiences. Thank you so much for that. And yes, welcome. And how are you?
Thank you so much, Rashni. I appreciate that introduction, and I'm really happy to be here. Try to hopefully navigate something that may be intimidating for some, but my job is for your audience to learn that this type of visa is not just for the superstars. It could be for anybody. So I hope your audience can take advantage of this and yes, and learn how how to put together a good O1 petition that may otherwise they think they may not qualify for. So I'm looking forward to this. Thank you.
Thank you so much for gracing our platform, Ralph. It's an honor having you on our show, like I said. And yes, and today we are going to talk about, mastering the O1 visas. So, Ralph, in your introduction, I told our audiences that you hold 3 nationalities, right? But you know in and out about US immigration, and you have helped the audiences with 99% of, that's the success rate that you have had, right? So I would like to know from you. I mean, you must be very much familiar with the US politics because you handle US immigration and you're an expert in that. So, Ralph, I would like to know from you that recently President Trump he got elected, and he's going to be in the office for his second term with his administration, which is under a lot of controversies these days. So, as an attorney, what are your views, and where do you stand? I mean, do you think it is going to be good for the immigrants? Because these days, the immigrants have a lot to think about, to talk about. There's a lot of chaos also going on, not just in the illegal immigrants' mind, but also on the legal immigrants' minds. So, as an attorney, what would you like to say?
Well, yes, I was going to raise this, I'll call it the elephant in the room, but I guess we're going to tuck this head on. So, yes, President Trump was elected for a second term. There is a lot of noise out there about what's going to happen and what's not. My job as an immigration attorney is to reassure people that any particular case requires, at the end of the day, that you meet what the statute says. Sure, are there going to be changes? Probably. Are things going to get more difficult to get approval? Possibly, but again, what I want your audience to understand is that although change is probably going to happen, this is not going to happen overnight. It takes time for a particular policy to be changed, and even more importantly, for the law to change. That requires congressional action. Just because candidate Trump was promising this and that, that's a lot of it is rhetoric. And I'm going to start by saying that this is also a point where having good legal advice is critical. Like I said, at the end of the day, you have to prove what the regulations say. I was going to discuss this later in our conversation, but since you brought it up, I recently participated in a meeting with people from USCIS and the Department of State, and they spoke about what was like under Trump 1.0, his first, and they said that it was challenging, and I want your audience to understand that you have to be realistic, that it's probably going to be tougher, but that only emphasizes the need to have a good lawyer with you. For example, just to give your audience an example, one of the things that, well, at least in the first term of President Trump, and I don't see why this is not going to happen again. They had this approach called Buy American, Hire American, and that plays a big part in the visa process, because I'm going to give you an example of what someone who used to work for a U.S. consulate told us yesterday. He basically said that they're really looking with a fine-tooth comb on, can an American do this? You know what I mean? So that's why it's important to be very meticulous, very careful in how you prepare your cases. And as you alluded to earlier, this has always been, regardless of who's the president, this has always been my approach. And that's why we've been extremely successful in approving cases. At the same time, on the other side of the coin, you have President Trump saying that he's willing to give everyone who's got a STEM degree from a U.S. university a green card right away. Again, that would be great. But I mean, whether that's actually going to happen, we're going to have to wait and see. The, my recommendation for everyone will be, and what I tell my every client is, whatever you see or whatever you read, don't believe it. Reach out to me first, and
Absolutely.
because 9 out of 10, the person who's writing knows nothing about immigration law, and they just write whatever they think they understand, and more often than not, unfortunately, that creates more panic than anything else. So what I always tell people is, uh, before you believe anything you read, shoot me an email or give me a call, and we'll discuss it. So yes, this is a real, I don't want to call it concern, because to me it's not a concern. I'm here to help my clients and to make sure I work to the best of my abilities to give them everything I've got. What I always tell people when I meet with them is like, unfortunately, I can't guarantee a result because that's outside of my hands. But what I can guarantee you is that I'm going to give everything I got to get your case approved. So, yeah. So I mean, what's happening after January 20th, when
Yeah.
President Trump takes the oath of office again. It's hard to know, but I don't really like to speculate. But I think we have to be ready for everything. Like I told some colleagues yesterday, we know what the minimum they're going to do because they did it in their first term. And that shouldn't scare us because we're also ready because we know. You know what I mean?
Yeah.
So I just want to stress the need to, have competent lawyer with you. Talk to a lawyer. I was gonna talk about this in the O1, and since we go in, like I said at the beginning, the O1 category is not just for superstars. The O1 category is for, all you would. I mean, you would need is a good story. And
Yeah.
to put together your good story, you will need a good lawyer. So the O1 category is a category that is heavily on the criterias. We're going to talk about those probably a little bit later. But yeah, the O1 category is defined in the statute, and that's exactly what USCIS has to follow. They can't go outside of what the law says. So that's why it's critical to have good representation, and because I've seen people try to do them themselves, and that's just not a good idea. I mean, especially not with what's coming in the new administration and everything. It's critical to have someone to sort of work with you on this journey. So
No, absolutely. I think, especially around this time, you should be under some guidance, somebody who can help you with your cases, because the scrutiny is definitely going to be stricter, and things are going to be definitely strict. Because first, we have heard that from a lot of attorneys that it was not exactly a very good time, especially for the immigrants. But Ralph, also, if we talk about this Trump 2.0, or this administration that he has right now, there are a lot of immigrants in his team. And let me just start with his wife. His wife, Melania, she herself is an immigrant, right? And then if I talk about Elon Musk, Elon is an immigrant. And then Vivek Ramaswamy, he's an Indian American. So we can call, I mean, he is an Indian American, but he definitely has those immigrant. I mean, his parents are immigrants. So there are a lot of in his administration itself. There are a lot of immigrants. So do you think that that is going to be favorable for the immigrants? And because if we listen to Trump and his speeches, he mostly talks about going against illegal immigrants or undocumented immigrants is what he says, right? So, but do you think it is also going to affect the legal immigrants?
that is an excellent point, and I'm glad you brought it up. I think so. the fact, for example, I mean, Elon Musk, he is, I mean, don't quote me, although this is live, but I think I think he's going to be the president. So, uh,
But he wasn't
um,
born in America, right? I think he was born in Africa, if I'm not wrong.
well,
So I think he's
he's
eligible.
from South Africa, yes.
Yeah, yeah.
So I'm glad you brought that up because certainly I don't think realistically, but again, you should not take this you should take this with a grain of salt,
Mm,
meaning I don't think it's smart for them to go after business immigration
mm-hmm,
because yes, for example, Elon Musk depends a lot on H1Bs, for example. So I don't think, I mean, if they go after legal immigration or business immigration, I think they're going to be shooting themselves in the foot.
mm-hmm.
Um, I don't necessarily think the fact that Trump's married to someone from another country plays
Yeah,
anything because I don't think, that's a different conversation for another talk for another session maybe.
I understand.
But no, but I think the fact that um, he had someone in his administration, is Stephen Miller, who's going to be the guy putting together policy.
Mm-hmm.
And I'm going to be brutally honest. I mean, if it was up to him, he was going to deport everybody. But I don't think that's realistic.
Mm-hmm.
Um, like you said in your question, and I think this is what people need to take into consideration, is the fact that the political points are, like you said, is with people who are here illegally. Um,
Right.
I don't like to use the word illegal, but um, but it's someone who doesn't have that is a very big word because when people say the word illegal, and again I don't like to use that word, they're
Mm-hmm.
usually referring to people who cross the border without a visa. But
Yeah.
you also have to take in consideration that there are a lot of people who came in on a visa and they overstayed. So that's it's again, like I said in response to your previous question, I don't think you have to step back a little bit um, and look at this realistically. Okay, they're saying there is about 20 million uh, people without legal status in the United States. I
Mm-hmm.
mean, how are you going to do that overnight? You know what I mean?
Yeah,
Like
yeah.
logistically, it's impossible. I mean, and I don't know if there are any Trump supporters in this call. I hope not, but if they are, um, they have been known to be very undisciplined. So, um, I mean, who knows? Maybe for this second time around, they're more organized. I don't know.
Mm-hmm.
Um, but I think um, business immigration, I can't say for certain it's safe. It's
Mm-hmm.
probably gonna, there's probably gonna be more RFEs. There's
Yeah.
probably gonna more, you're gonna have to present more evidence. You're gonna have to be more detailed. But I don't think it's a good idea for them to mess with business immigration because, um, they're sort of advocating for people to follow the law. And I think business immigration is exactly that. You know what I mean?
Yeah, yeah.
So, um, and the fact that the reason I brought up this guy is Stephen Miller is because he's probably very aggressive, but like you said, he's going to have Elon Musk in there. And I'm sorry, I don't remember the name of Vivek, right? Vivek?
Mm-hmm.
Um, they are probably going to be like, look, I believe he's in IT too, right?
Yeah. Yeah, he has been an entrepreneur. Yeah, that's right.
So, I mean, the business immigration is how the United States stays competitive. That's the truth.
Mm-hmm.
Um, and if you're going to, start implementing things that turn talented people away, then I don't think that's a very smart idea because people are just going to be looking to other countries.
No, absolutely.
And it's like, but again, it's going to be like a balancing act.
Yeah.
On the one side, they're going to be like Buy American, Hire American, but on the other side, it's like we don't want to lose this talent to other countries. So it's going to be, it's going to be. I think it's going to be case by case. It's going to be a fight that's going to be happen case by case. So that's what I believe. And again, I want to emphasize that I don't want your audience or anyone to to just panic. Call me, call me before you do. So
Yeah, absolutely. Guys, if you're confused at all, please directly give Ralph a call. Maybe he's going to help you with a detailed consultation. He might definitely going to help you. He will definitely going to be helping you with your cases and with your questions. Here are his details. If you want to give him a call, you can give him a call on this number, 240-898-2288. I would again like to repeat it, 240-898-2288. You can also email him. His email ID is ralph at Antonioli lawfirm.com, and you can also visit his website, which is www.antoniolilawfirm.com. All right. So now, Ralph, we already have started getting questions. I see
yes,
people posting their questions. Let me quickly say hi to them. Hi, Kavita, Arjun. Then we have one question from LinkedIn. The name is not mentioned. It says LinkedIn user. And then we have from Bhavin. So guys, okay, again, the LinkedIn user has posted a lot of questions. We are definitely going to take them, but let me quickly start with my questions. Ralph, also, if you can please tell about what are the key differences between O1A and O1B visa categories, and how do the eligibility criteria vary between them?
yes, absolutely. Yeah. So before I explain the difference between O1A and O1B, I want to give your audience a little bit of history. So the O1 category was created by the United States Congress in 1990. This was in response to a high volume of cases where people had, for lack of a better word, or for this particular purpose, extraordinary abilities in particular areas. Before the O1 category was created, most of these people came to the United States, or most of these professionals came to the United States on H1B visas. But as we're going to discuss, in this in our time together, the H1B has a lot of limitations that the O1 visa does not. So, this was created so that people can have more flexibility in working in the US and, potentially be here without a time limit. Because as you know, the H1B category only allows for someone to be in the United States for 6 years. So in direct response to your question, the O1 category is divided into two separate subcategories, if you will. The O1A, this category applies for individuals that have extraordinary abilities in the sciences, education, business, or athletics. On the other hand, O1Bs are for people who have extraordinary ability or have achieved an extraordinary achievement level in the arts, motion pictures, or the television industry. Both are similar; they're not the same, but that's basically the difference between the O1A and O1B. So O1B is for what I call the SEBA categories, which is science, education, business, and athletics. O1B is mostly for the entertainment industry. So it's for artists, which we're going to talk about what art is a little bit later. And then people in the motion picture and television industries. So yes, those are the main categories. Again, like I explained a little bit at the beginning, the O1 category is basically a criterion by criterion type of visa. So depending on whether you are pursuing a visa based on science, education, business, arts, or uh, athletics, or arts, motion picture, or television industry, then you basically the first step is to determine what field you fall into. So let's say for someone in the IT industry, and I see one of the questions in the chat here asking about IT. IT would typically fall under sciences. So that would be an O1A. Okay. We can, and if someone works, for example, in TV production, that will be an O1B. So yeah, that's basically the difference between the two. I mean, both are O1 visas, but it's this when for filing purposes is when you sort of focus on whether it's an O1A or an O1B, but for general purposes, it's just an O1. So I hope that answers that question.
Yeah, it does. Thank you so much for clarifying and answering the
Excuse me.
question, Ralph. I think just so they can simplify the fields and they can make they can differentiate between the fields, so they made these categories O1A and O1B, right?
That is correct.
Right.
So basically, based on the field, based on the endeavor of the person or the field that the person works, is when it is determined if the person is an O1A or an O1B. But again, this only comes into play when you put together your petition. Then once the case is approved, as I recall, sometimes the visa only says O1. So this only comes into play when you are actually filing your petition with USCIS.
But is the process also the same, or does the process also varies? I mean, for O1A and O1B.
What do you mean by process? Well, I mean, the criteria for an O1A and an O1B are very similar. They're not identical. They're similar.
Okay.
But when it comes to processing, when filing, that's
Yeah.
identical. That's identical. I mean,
Okay.
so usually how it works is, you put together a pretty decent O1 petition package. You file that with USCIS. Once, one of two things happen. The case is either approved or USCIS issues a request for evidence, asking the petitioner in this case to provide additional information to, usually because they're not satisfied with certain criteria that we explain or basically spell out in the petition. I say two options because sometimes people think, well, is it going to be denied on the get-go? That's pretty rare. I mean, unless it's a really bad case, cases don't usually get denied outright. I mean, usually it's either on straight approval or an RFE. And but I mean, filing with USCIS is identical for both.
All right. Thank you so much, Ralph, for clearing that. And thank you so much for the answer. And Ralph, as you can also see, there are a lot of questions here from our viewers, and people are also, having a conversation and chatting while listening to you on YouTube and also on LinkedIn. So yes, I think we can also share the screen so that Ralph can also see what's going on the social media. But if you allow, I would like to take the questions from the viewers, if that's fine for you.
Absolutely.
Perfect. Let me start with Lynn, because I think this LinkedIn user who posted its comment is Lynn. And Lynn wants to know, can you explain what the O1 visa is? I think, yes, if you can see that.
Yeah. So like I explained at the beginning, but I'm happy to, the O1 visa is a visa that is designed for people who have, and this is a word of art, extraordinary abilities, or achievements in specific fields. So like we just spoke, the O1A is those for those individuals in the sciences, education, business, and athletics. And the O1B is for individuals in the arts, motion picture, or television industry. So I
Right.
think to better answer that question, I will probably give you an overview of what people need to show so that you are qualified for an extraordinary ability. And this goes to my earlier comment that you don't have to be a superstar. You basically need a good story and a good lawyer. So, for example, let's start with the O1A. For the O1A, you have to show that the person is a extraordinary abilities in either the sciences, education, business, and athletics. Okay, so how you do this? The easiest way to do this is if someone has a international recognized award. So, for example, let's say somebody won a Nobel Prize. Okay, this is all they have to show. That's it.
Mm.
An internationally recognized award. I mean, this again, as you can imagine, this is usually not the norm. So, for those people who have not earned a Nobel Prize or an internationally recognized award like a Nobel Prize, we move into the second way, which is the most common way to show that someone is considered an extraordinary ability in either the sciences, education, business, and athletics. So you have to. There is 8 criteria that you can possibly use to meet the O1 in the O1A. So you can either show, again, I'm gonna give you 8 criteria. All the person needs to meet is 3 of them. Okay. The first one is receipt of a national or internationally recognized prize or award for excellence. This is any other award that doesn't fall into the category of a Nobel Prize or something of that stature. So you can argue that you receive an award, a local award, and then you argue that your contributions were critical for this award to be issued, and again, you can show this. The second way you can show that you're an extraordinary ability is membership in associations requiring outstanding achievements. These are pretty mouthful, but basically it's associations that sometimes the most common one is like a fellowship. So if you're a fellow in an institute, all you have to show is that for you to become a fellow, you had to meet certain criteria in that organization. It's not just, it's you have to contrast that with, for example, what they call here a pay to play. So like you pay and you become a member. That probably is not going to fly. It has to be some type of organization where you became a member because of what you did. The third category is referred to as published materials about the individual in professional or major trade publications. This is, interviews, articles in magazines in the person's field that, speak about the person being extraordinary, being, above and beyond the common ground. Then the fourth is participation as a judge in the work of others in the same or similar field. So in this case, if you were invited to judge a competition in your field, let's say in robotics, for example, and if you were invited because of who you are or because of your credentials, that's probably going to meet the then this is the next criterion is probably a favorite in the IT industry, which is original contributions of major significance in the field. As you can imagine, this is pretty broad. And again, this goes back to what I said earlier about you telling your story. what I always often tell clients when I first meet with them is, okay, tell me why you're better than everybody else. And that starts the conversation. Excuse me. So the original contributions could be, this is pretty broad. So we can, you tell me why you're good, and then we work from that. Excuse me. The next category is authorship in scholarly articles in professional journals or other major media. This is, for example, things that the person has worked on. For example, if you go to the easiest way to prove this is go to Google Scholar, and put your name in there. And let's say you've written 10 articles, and again, it's criterion by criterion. So you start by saying, yes, I've written certain articles, and then you start sort of breaking out by article, saying, okay, I wrote this article. This article was cited 100 times. This is then the seventh, and this is usually used by a lot of people who, for example, are self-employed. We're going to talk about how you need a employer petitioner to file for you to secure an O1 and the workarounds. But this particular criteria is defined as employment in critical or essential capacity for organization with a distinguished reputation. So basically this, you just show that you work with organizations that have, a great reputation. So for example, if you work for someone like Apple, or if you work for someone like Tesla, or if you work for someone like Microsoft, excuse me, that's how you would show this. And then the eighth one is pretty straightforward. It says you show that you are a person of extraordinary ability by showing that you commanded a high salary or other remuneration for your services. So this is basically you show that you received a really high salary based on, a high salary for what you did, and that would qualify you for an O1. Again, I read 8 criteria. You have to show that you meet at least 3 of them to be qualified for an O1. And the 8 category that I read are for O1A, which is for, again, it's for sciences, which would include IT and anything related to, for example, AI or robotics or things of that nature. For the O1B, which is for arts, motion picture, and television industry, the initial criteria is the same. For example, if the person received like an Oscar or an Emmy award or a Grammy, that's enough for the person to meet the O1B. Again, this is not always the case. So again, you go into the regulations provide 6. It's not 8 like O1A. It's only 6 for O1B. So again, that you have to meet 3 out of 6. So you have to perform in a lead or starting participant in productions or event with distinguished reputations. Basically, you have to have been a critical part of a production or, a television show. Then you have to receive national or international recognition for your performances, or work has been published about you regarding your performances. You can also show that, the productions or, movie or series, now that streaming services are really popular, you have to show that, it was successful. So, you will present press articles or critics reviews and things like that. And then you will also show recognitions from other organizations saying, yeah, this guy was out of this world and he was amazing in what he did. And And then again, you have the high salary, which, if again, this is case by case basis. So I hope what I do want to highlight though is that for extraordinary abilities in science, education, business, and athletics means a level of expertise. And I'm reading from the regulations because this is, like I said at the beginning, a lot of these are works of art. So if you basically put together a good story and work with a competent lawyer, you're going to be able to meet these criteria. So for science, education, business, and athletics, which is an O1A, as we discussed, you have to show that the person is in a small percentage who have risen to the very top of the field of endeavor. So this is, creativity comes into play here. You have to show, and I'm going to talk about this, when we address the best practices and best approaches on how to meet these criteria. We're going to talk about that, but basically, when it comes to science, education, business, or athletics, you have to show that the person is, I don't know, I would say in the top 5%, top 1% of what they do. This shouldn't be intimidating for people because, as I'm going to speak about it later, the key is to narrow down the field as much as we can, because the more narrow a particular field is, the less people that are probably going to be in the top level. You know what I mean? So what I mean by that is we have to narrow down. If we say he is an extraordinary ability in the field of IT, you can imagine there's going to be thousands, if not millions, of people who are going to be extraordinary. But if we say he's an extraordinary ability in IT, particularly X, Y, and Z, then the field becomes extremely small. So again, this is a case-by-case basis. You have to show that you're on top of your endeavor, whatever that may be. And again, a lot of these regulatory schemes may seem maybe intimidating, but again, I want to emphasize that working with competent lawyer and doing your homework goes a long way. Putting together a good story and supporting documents with as much as you can, basically present a story to the person so they look and they are. I always say that the first 10 minutes of the person looking at your case are the more critical. If you can convince that person in 10 minutes that you are on top of what you do, you have won your case. So yeah, that's basically, it's kind of a long answer, but it's very case by case basis. My job here today is to basically give your audience a sort of like a 10,000 feet picture of what the O1 category is like, and that it's just not for the top, just for superstars. If you present a really good story, you can definitely meet the O1 criteria.
Great. Thank you so much, Ralph, for that detailed answer. Thank you so much. And I'm sure it did help Lynn. I think it must have helped him a lot. But he also has a follow up. He has posted another question and he says, did Elon Musk use the O1 visa initially? Can you give some examples of someone who used O1 visa? How does it apply to tech workers, artists, athletes? How about the spouses and children's? I think then because you were talking about people working in the entertainment field and these sports athletes, then I think majorly anybody who is, because now I think Lynn is asking examples. So anybody and any artist who's traveling abroad for any project or any movie or any film, I think they must be using the O1B visa, right, Ralph? And if you have some examples and if you can answer
Yeah, I
some.
mean, I think this is a two-part question, or maybe a three-part question. First off, I don't know if Elon Musk ever used the O1. I do know that Albert Einstein was in O1 at some point, even though I'm gonna go back because the O1 didn't exist until 1990. He did an EB1, which is we're going to talk about that later, which is where the O1 sort of got its. I've done about, I would say, 100 plus O1s. Most of the O1s that I've done were for business people. So in the case of business people, what you focus a lot on the reference letters, which is how you show that the person, has influenced the field. Like I said, you show that the person um, had original contributions of, I also work with artists, particularly in the television industry. I work with photographers that worked in the television industry. I work with educators. So I mean, and I've also done P1 visas, which is not part of this conversation, but those are for athletes. You can also meet the you can either for athletes you can do O1s or P1s, but I mean, since we're just focusing on O1s here, tech workers usually, like I said, like I alluded to earlier, they would meet the in the sciences. So again, this is I see a lot of questions here saying, well, I'm a researcher, for example, or I don't know if my resume would um, will be enough to meet the O1. Like I said, every case must be looked at with a microscope, if you will. Just by looking at a resume is probably not even 10% of what I need to determine whether the person would qualify for an O1. But yeah, I mean, it's a case by case situation. I mean, there are other categories, but the O1 is something that is out there and that has its advantages. But what I would recommend someone wanting to explore the O1 is to get in touch with me, and because I don't think we don't have enough time to go case by case. All I can say is that unless you have one of those internationally recognized awards, you start looking at the 8 or 6 other criteria and see how you can meet them. Creativity comes into work. Basically, what you do is you sell yourself to USCIS, and that's where advocacy comes in. So, I mean, that's really what I can offer. I mean, unfortunately, I don't know if Elon Musk was ever an O1. Maybe, I don't know. But now, when it comes to, like I said, tech workers, the O1, I'm going to be honest, the O1 is not a favorite category. It's out there, and I encourage people to explore that, especially because the H1B and L1 category are going to be heavily scrutinized. So, but again, it's a case by case situation. Just because you think your resume is weak is not an impediment for you to, I mean, schedule an appointment. Let's talk about how we can strengthen your. For example, if something in your field requires you to be a fellow, how long does it take to be a fellow? Do your research, do your homework. one of the criteria is to be a part of an organization that requires excellence. All right. How do you, for example, there is a society of X. How do you join that X? How much time? I mean, think about it. You know, there's, I mean, for lack of a better word, there's a lot of ways to skin a cat. So, um, I mean, there is no one silver bullet. The O1 is one of those categories that lend itself to a lot of creativity. I have done an O1 for someone, this was probably the most challenging O1 that I've ever done. It was for someone in the educational field. The first thing when you Google this person's name was that he was expelled from a university for plagiarizing. And I was like, okay, good. So the USCIS officer is going to put this guy's name in Google, and that's the first thing that's going to come up. So, we got on pretty big RFE, but at the end of the day, I was able to meet the statutory requirements and take the attention away from what's out there to what actually is required. So again, this goes back to don't worry too much about whether you're a superstar or not. Worry more on how you can meet at least 3 out of the 8 or 6 criteria. The other part of the question refers to spouses and children. So spouses and children of O1 petitions, of the O1 visas qualify for what's called the O3. They are eligible to come to the United States for the same amount of time as the principal O1 can. Unfortunately, as it happens with H1B spouses, O1 spouses cannot be employed. They can go to school, and that can eventually open another avenue. They can they can secure an H1B, or that. This is a different topic for another conversation, but unfortunately, the O3 category doesn't allow for employment. Again, it allows for going to school, like if they want to pursue a master's or another degree, but unfortunately, it doesn't allow for employment, like the H4 does in certain circumstances.
Right. I think O1 itself is such a vast topic that it won't be possible for us to complete everything in this episode, right, Ralph? It will take
That
us a
is
couple of
correct.
episodes to finish talking about O1.
Yeah, I just realized we're almost at the top of the hour here, and I don't think we even scratched. I don't think we even spoke like 1% of what the O1 is all about. So
It's important because we have to start from the basics, and then we are going to dive deep into
if
what O1 has. So we are definitely going to do more episodes, but for now, thank you so much for answering this question for Len. And he now has actually one more follow-up. So
okay.
if you have some time, I would like to, continue because I think in 5 minutes we'll be completing an hour. But if you have some more time, I would like to take more questions from the
Yes,
viewers.
absolutely. Yeah, absolutely. The one thing I do want to, if there's one thing I want people to take away from today's conversation, and I hope we're going to continue because there's so much to explore in the O1, and there's always, I also want to be a resource for people who, let's be honest. I'm a very straightforward lawyer. I'm going to tell if I think your case is not going to work, I'm going to tell you. I'm not going to be here and tell you, yes, I'm going to make it happen. I'm not going to I don't like to waste people's time, and I don't like when people waste my time. So I'm going to be pretty straight, but I
No
also
beating
want
around the
people
bush, right onto the face, whether you did that.
exactly, because I want people to know that I'm a resource, especially as we're about to embark on a very potentially rocky 4 years. Okay.
Mhm.
Um, I want people to take away that the O1 category is probably the least category to be scrutinized because of the nature of it. And I want people to know that, business immigration although it may have some pushback, is not. I don't think it's in the interest of those who are in power or who will be in power to mess with business immigration, because they ran on a business platform. And again, you have Elon Musk there that, like it or not, money moves the world, right? So he's going to have a lot of influence. And I mean, if he goes after business, which I highly doubt, he's going to be shooting himself in the foot. And I mean, what I do want people to drill this into their, memory is do your homework, consider hiring a lawyer. Don't go at this alone, especially after January 20th. Keep in mind that we have to convince USCIS. This is not like any other. This is not like most other, like a lot of other business visas where you go to the consulate and they can deny you because they don't think your case is true. If you convince USCIS, you're 90% there, unless there is some other huge issue. Once we convince USCIS, the hardest part is done. So I want people to know that every case is an opportunity to tell a story, and rely on a competent lawyer, hopefully me, to tell that story. And, just don't be bogged down by whatever you may hear out there. 9 out of 10 is probably exaggerated or written by someone who doesn't know anything about immigration. So keep that in mind.
That's a great advice. Thank you so much for that, Ralph. Now, again, there are two more questions actually posted by Lynn, so I would like to take them too. So he says there are many companies that are being pressured to invest and open R&D factories in the US. Question is whether the workers hired are going to be on business visa from abroad, and or foreign students switching from student visas to working visas. Then the second part of the question is also how many this will be affected. And then the second part of this question says also regarding for foreign investors looking to open franchise businesses in the US, and then also immigrate to manage the business in the US, what should they be looking for? Let's take one by one. Maybe this one first.
Okay. Yeah. So I think since this is an O1 conversation, companies, the current administration has put a lot of input in STEM fields. This is what I mentioned earlier, that President Trump, soon to be again President Trump, said that he's going to give a green card to everyone who's got a STEM degree. He's going to give a green card to anyone who basically staple a green card to their diploma. I don't know if that's going to happen, but most people who just graduated from U.S. university, and I'm not sure if this goes into the second question, but I believe most, again, realistically speaking, most people who just finished their degree, they're probably not going to qualify for an O1. They're likely going to be more, they're probably going to be the criteria of an H1B or, probably H1B is going to be the best way to go. Then from an investor standpoint, and again, this is probably a topic for another conversation, but when investors want to put some money in the United States, and again, this is I hardly believe that the next administration is going to try to prevent investment from happening in the United States, mainly because they're going to have Elon Musk in there. The E2 category is probably the best category for investors. This is also a heavily scrutinized category because it requires a lot of documents, a lot of granularity in offering, trying to get an approval from an E2. An E2, the main characteristic of an E2 is to make sure that there is a treaty between the United States and that person's country of birth or country of nationality, so that there can be some sort of an investment in the United States based on that treaty. Again, this is something for a topic for a different day, but I don't think the O1 category is going to be a favorite one for students. Those students who are in OPT or STEM OPT, they're likely going to go into the H1B lottery. So again, which yet another topic for another time. What was the second question? If you remind me, reminding me of the second question.
Right. He said that also regarding foreign investors looking to open franchise businesses in the US and then also immigrate to manage the business in the US, what should they be looking for?
Yes. So this is, again, this goes back to what I just said at the end of my last answer. For this type of scenario, an E2 is probably going to be the best way to go.
Okay.
In the case of a franchise, you're not really starting a new business. Well, because what you're doing is you're basically growing a brand that already exists, right? So you're buying the franchise. So all you're going to have to show is that you put some, when it comes to investment, you have to show that you put some money at risk, that you invested. Again, this is a E2 conversation. This has nothing to do with O1, but for a franchisee, I think the E2 category is probably the best way to go. Again, this is, like I said, we didn't even start talking about a lot of details in the O1. So if I start talking about another category, it's just going to confuse people. So, yeah, for franchisees, I would think the E2 category is the I don't want to say easiest, but it's the best way to go about, trying to invest. And the E2 category allows the main investors to hire people of their own nationality to work with them. So that's a big advantage of the E2. But again, this is an O1 conversation, so I don't want to spend too much time on the E2. I hope that answers the question.
Right, it does. And I hope so that, Lynn, you have got your answer. Thank you so much. If you have another follow-up, please continue posting them in the comments. Even if we don't have time to take them up in this session, we are going to do another session with Ralph very soon. So maybe we can take them in another episode, or maybe we can directly reach out to Ralph and ask for an answer, or maybe you can directly reach out to Ralph. If you want a direct consultation or are looking for an answer. And here are his details. You can give him a call on this number, which is 240-898-2288. I would like to repeat it, 240-898-2288. You can also email him. His email ID is ralph@antoniolilawfirm.com. And also you can also visit his website, which is www.antoniolilawfirm.com. Thank you so much for that. And Ralph, I would like to take one more question. This question is actually posted by Madhvi in the comment section on YouTube. And she says, I am a researcher with a few published papers, but I haven't still received a lot of media attention or publication or public recognition. Am I eligible for O1 visa?
Well, yeah, that's a great question. And I think it goes back to what I said earlier. You have, if you're a researcher and you've published, if we can show that that's just one criterion. We have to show at least three. So if you don't, if you haven't, if you haven't received a lot of press attention, then we're going to have to look at the other criteria. So for example, you can get letters of recommendations from people saying that you have provided significant contributions to the field. That's how you meet that criteria. You can show, again, you have eight criteria to choose from. and we can explore each one. For example, membership in association. Maybe you're a member of like a sorority or a fraternity or some type of organization that requires you to be to be somewhat an accomplished professional. I mean, that may qualify. If I mean, again, do your homework, and maybe once you appeared as a judge in a competition. It doesn't have to be a judge for something that was televised. It can be anything, and then like I said earlier, there are many ways to approach this. So just because you only have one thing doesn't mean you're not going to meet it. I mean, we have 8 other options or 7 other options, if you will, to look at that we can meet. So this is the great thing about the O1. It lends itself to creativity. So, and like I said earlier, I said, our job and my job as a lawyer is to tell the USCIS officer to look at the case, and in 10 minutes of looking at what we presented, the guy can say, I'm going to approve this. So at the end of the day, it's case by case basis. I encourage people to reach out to me, and I'm more than happy to speak with them about whether they think they could meet. If again, I encourage people to either reach out to me or I think that's probably the best way to go. I mean, if we're going to be talking about everyone's individual case, we're going to be here for 2 weeks, right? So I think it's just because you have one thing, don't get bogged down on that. I mean, there are other options. There are 7 other criteria, and each one is at play. Anything goes. I mean, yeah. So I think, and if you're a researcher, there's also other options. There is something called a J1 researcher that you can apply for. The company, I'm gonna just do this briefly because again, this is a J1 visa, but it's a J1 visa that is not usually utilized, but it's for a researcher. People believe that the company has to be a research company, and that's not true. It can be any company as long as they create a research type job. So yeah, I mean, that's another wrinkle to this. So yeah, I mean, and ultimately, I think I mean, the bottom line is it's a case by case situation. You don't want to I mean, don't convince yourself that you don't have it before you talk to a lawyer. So
That's
so
true. Don't come to a conclusion until you seek.
exactly. And I think what they say here, don't sell yourself short. I mean, I'm sure if you look this is going to sound maybe a little weird, but it's like a beauty contest. You have to convince the judges, right? So
Right.
so I mean, look at it that way. I mean, it's it's kind of maybe an odd concept, but that's what it is, and my
You
job
never know
is
what
to.
might work for you, right?
I'm sorry.
You might not know. You never know what might work for you.
No, and at the same time, exactly, and at the same time, this is such a subjective
Right.
process that you may get a guy who's got like a cousin who does what you do. You never know. And hey, this guy, we're human after all. I mean,
Yeah, absolutely. So it'll be better, Madhvi, if you directly get in touch with the right attorney, and why not directly get in touch with Ralph if you're looking for an attorney. And then Ralph, also I would like to take one more question. This is actually from Kavita, and Kavita says, I have heard a lot about O1 visa being people being for people with extraordinary ability, but I'm not sure what that really means. Could you explain in more detail how USCIS defines extraordinary ability? I think we already have talked about this, and you already have explained.
Yeah, I'm happy to give a quick overview again so they understand.
Please.
Yeah, so like I said, well, USCIS doesn't really define extraordinary ability, the regulations do. All we have to do is show to USCIS that you actually meet the definition. So, for example, if you are in the field of arts, you have to show that your extraordinary ability means distinction. What does that mean? Distinction means a high level of achievement in the field evidenced by a degree of skill and recognition substantially above what's ordinarily encountered in the field. What does that mean again? It means that you have to narrow your endeavor so much that when you explain it to them, I am an IT expert who specializes in A, B, and C. And there are only like 3 people in the world who do A, B, and 3. And I'm one of them. You know what I mean? That's how you do it. If you say I'm a expert in IT, how many people are experts in IT? Millions, right?
Right.
So, but if you, the secret, I mean, not a secret, but you have to narrow down what you do. So, for example, in the case of, like my photographer, for example, that I work with, he was a photographer for Apple, and he would take pictures, all those pictures that would go on billboards. So we narrowed down. He's like, okay, I have an expertise in photography. If you just stop there, you're going to have millions of people who are photographers, right? But if you say I'm specializing in taking, in products that have to do with cell phone technology, or that narrows down the field. So at the end of the day is what I tell people is tell me what your superpower is, and then we're going to expand on that. So don't tell me I'm good at IT, because there's 10 million people who are good at IT too. We have to start with, we start with IT, and then we start going down the list and see, okay, what type of IT do you do that not everybody else does? So I think that's the right approach. If you're looking at sciences, the regulation says, and I think I touched upon this earlier, and this applies specifically to people in the sciences, education, business, and athletics, where IT will fall in. And this is, you have to show a level of expertise that you are on a small percentage that have risen to the top of that field. So again, that basically encapsulates what I just said about, narrowing down as much as you can what you do. Don't tell me I'm great in IT, because that's a loser argument. Tell me I'm great in IT at doing ABC, because there's only like 5 people who do that, and I'm one of them. You know what I mean? That's the position you want to be in. So
Right.
that's what they look at. And when UCIS uses a very broad definition of the word endeavor, which is basically what you do. Okay. So like your field, you can basically, if you can articulate something that makes a little bit of sense, that's it. You go with that. It doesn't have to be something that is widely recognized. No, you do you. You know what I mean? So, and you tell me what you do, and then we're going to craft your field based on that. Of course, we're going to start with a science, and then we expand So that's basically what they look at when they try to see if a person meets extraordinary ability definition. That's what it is.
Right. Thank you so much again for your answer, for that detailed answer, I should say. Ralph and Kavita, thank you so much for posting your question in the comments below. I hope you have got the answer. In case you're looking for anything else, and if you're looking to get an answer to maybe another follow up of yours, please continue posting them in the comment section, and we'll be more than happy to take them. And yeah, I think that's it. We still have one more question from Arjun. If that's okay for you, Ralph, I would like to take this as
Yes,
well.
absolutely. I was looking, if you don't mind.
Uh-huh.
This person kind of caught my attention. I think it's Bhavin in the chat.
Okay, let's take Bhavin's question, right?
I
How
can
long?
tackle that pretty quickly because it says how long I can stay in the United States on an O1 visa, and can my family members accompany on an O1 visa? The second part I already addressed, but I'm happy to do it again. One of the great pros of the O1 visa is that there is no time limit, meaning the first period of employment is usually 3 years. So your first I guess period, you can stay in the United States for 3 years on your initial entry. Then you can extend that in 1 year increments indefinitely. This is definitely an advantage when comparing to an H1B, for example, where the H1B you are limited to 6 years. And the O1, you can extend your O1 status indefinitely. Of course, you have to show, every time you extend this, you have to show that you continue to be a person of extraordinary abilities. But but there is no limit as to how long you can stay in the United States, as long as you continue to demonstrate that you meet the criteria for an O1 petition. And when it comes to family members, like I said earlier, yes, they also benefit from the same period of stay as the principal O1. The visa for family members is the O3. Like I said earlier, they are allowed to go to schools, university in this category. Unfortunately, these categories is not allowed for employment though. But if we're going to go really granular about this, if you pursue some kind of degree in the United States, you can potentially qualify for other categories like an H1B or. So I mean, again, this is a very large topic, and I think I just wanted to address that because I wanted your audience to see how how advantageous will be to pursue an O1 as opposed to an H1. Because, for example, and another big difference will be you can do an O1 at any time, whereas the H1B you are subject to the lottery, right? So, yeah.
Right.
Yeah.
Okay, Bhavin, I hope you have got the answer. Thank you so much for your question. And I think, okay, that's it then. Thank you so much, Ralph, for those amazing answers, for those insightful, detailed answer. It was lovely having you on the show. And, I don't think so. We had so many questions actually prepared for this show. But then I was only able to take, I think, one or two. And then mostly all of them were from the viewers. So I most definitely think we need to have an episode 2 of the same topic so that we can get into more questions and we can cover more details about O1 visa. And like I said, I think it is a very vast topic and we will need to have more and more episodes to talk about this, right? So that people can know better and know in detail what exactly O1 visa stands for and how it actually helps, especially the extraordinary people. right? So thank you so much for being here. And guys, if you want to get in touch with Ralph, I would again like to repeat the details which are displayed on screen. You can give him a call on his number, which is 240-898-2288. His email is ralph@antoniolilawfirm.com. And then his website, you can also visit his website, which is www.antoniolilawfirm.com. Thank you so much, Ralph, again for being here. I hope you enjoyed the first episode with us.
Yes, absolutely. And I'm really looking forward to doing another one, especially we were going to talk about, and I want your audience to stay tuned. We're going to talk about IPOs and things things of that nature that may be of interest to people, and how to avoid, rejections, and how to put together a very strong O1 petition. So looking forward to
Right. I
how.
think this was just the tip of the iceberg, right?
Yes.
So we have a lot to cover. So we definitely will be doing the shows with you on a regular basis now that, you have been here for the first episode. So thank you so much. Thank you so much, Ralph.
Thank you. I really appreciate it, and I appreciate the time.
Yes, I'm definitely going to come back to you and check your availability for the second episode. And thank you so much for being here for the first one. And guys, please make sure that whatever questions that you have regarding O1 visa, to drop them in the comments below, so that when Ralph will be back for his second episode, we are going to take these questions and we are going to get an answer from him. But for now, we'll have to take your leave. Thank you so much. Stay tuned with us. Our daily immigration dose is going to is going to come at 4 p.m. Eastern time. So make sure that you also are live, and you're also tuning in while the program goes on. But for now, thank you so much for participating in this webinar, and also for posting your comments. For now, I will have to take your leave, and I think so will Ralph. So we'll see you very soon. Thank you so much. You guys take care, and
Thank you.
Right, and don't forget to subscribe to Immigration and Jobs Talk Show. I'm Rajni Bharara. You take care and have a happy day ahead. Hi, everyone. Welcome to Immigration and Jobs Talk Show. I'm Rajni Bharara, your host. And before I move ahead, let me very quickly read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very important disclaimer, welcome back everyone to Immigration and Jobs Talk Show. I'm your host Rajni Bharara, and today we are diving into a timely and relevant topic, especially as we are on the cusp of a pivotal US presidential election. The upcoming election could dramatically reshape US immigration policies, making it more crucial than ever for startup founders, entrepreneurs, and tech innovators to understand their visa options. For many, the H1B has been the traditional route, but as we know, that path can be limited. So today we are exploring alternatives and uncovering solutions that might be better suited for startup founders looking to build their vision here in the United States. I'm thrilled to introduce our guest, Alyssa Hussain, who brings a wealth of expertise and insight to our discussion. Alyssa is a business and employment-based immigration attorney who represents companies and individuals seeking temporary or permanent legal status in the US through employment, trade, or investment. Her background is impressive. She has experience working with multinational technology companies, growing firms, and innovative startups. Alyssa's approach is all about strategizing with clients, guiding them through each stage. See, I'm so excited to introduce you that I've started fumbling. So I'm really sorry about that. So Alyssa's approach is all about strategizing with clients, guiding them through each stage of their immigration journey with dedication and passion. She earned her honors Bachelor's of Arts from the University of Toronto, majoring in gender studies, political science, and history, and holds Juris Doctor degrees from both the University of Windsor's Faculty of Law and Detroit Mercy School of Law. Licensed in Michigan and Ontario, Alyssa has handled complex immigration cases across Canada, the US, the Middle East, and Asia. Her work has spanned roles on the US immigration team at Deloitte with boutique firms specializing in startups, and now she's leading her own practice focusing on TNs, H1Bs, O1s, EB1s, and NIWs, which is national interest waivers. So without any further ado, let me not fumble anymore and welcome Alyssa Hussain on Immigration and Jobs Talk Show. So Alyssa, very warm welcome to Immigration and Jobs Talk Show. This is your first time. How are you feeling?
I'm feeling good. Thank you for the very warm welcome. I'm excited to be here and excited to kind of share as much knowledge as I can.
Right. And, Alyssa, this topic is pretty unique and a little different than what we usually do. So what do you think? What can people, what would you like to say? What can people expect from today's episode?
Yeah, I think there's, a common perception that in order to work in the US, to gain permanent residence in the US, that you need to have an employer who's willing to hire you and sponsor you. And the purpose of today's presentation is to focus on kind of taking control of your own immigration journey, and especially for those who want to be entrepreneurs and run their own companies, and also take control of their immigration journey into their own hands instead of being tied to employers, which for many immigrants, especially born in certain countries, including India, those wait times, those like dependence on your employer can be very challenging in terms of making life decisions. And so, yeah, I hope that this information is helpful in the sense of being able to recognize that there are other alternatives available, and kind of taking control of your own immigration journey.
Right. So, being an entrepreneur in your own country is so difficult because being an entrepreneur and starting your own startup, it's a difficult path than usually opting for a job because that's the most conventional way, right? And this is a little different than what usually people do. But if then trying to make it in a different country, in a foreign land, it must be so much more difficult than the normal path, right? So, what kind of cases have you handled? Let me just start with that. And how difficult is it for people to actually make it into a foreign land and build a successful business or a startup?
Yeah. I actually think that, I'm obviously biased, but I think that my foreign founder clients are, because they have so much more to navigate in terms of not only are they starting a company in the US, which is already challenging to begin with, they are, the odds are set against them in having to additionally handle US immigration, which has a further impact, right? When you're dealing with, fundraising and talking to potential investors, you also need to be able to explain to them that you're not an additional risk, when they're doing their due diligence. So if anything, I think that foreign founders are the most equipped to handle, growing successful businesses in the US because they're just already faced with so much adversity in additionally having to navigate the US immigration side of things. In terms of the types of clientele I work with, it really ranges. I have people in tech. I have clients who have started retail companies. It really is so industry wide. It ultimately, which I think really allows for a lot of opportunity and really is focused on people's plans and career goals and what their long-term plans are. So I think that in some way it is, U.S. immigration is very limiting, but on the other side of things, I actually think that it is also, there's like the world is your oyster in terms of what you want to pursue and how you want to pursue it. I think top advice I give to all my clients is, as soon as you want to start your own company, I would say try and understand the US immigration side of things simultaneously while you're kind of thinking of your long-term strategies for your company, for yourself, and your long-term plans, because there is a way to align those. You just need to think strategically about it sooner than later.
Right, right. I mean, that's a great advice. But also, is it easy for a particular startups or a particular type of companies to make it, and in comparison to other kind of businesses, like maybe like you mentioned, tech companies? Is it easy for them in comparison to the ones who are making, maybe getting into a restaurant business, or
Yeah.
different businesses basically?
Yeah, I would say, there's no one route that's easier than the other. It again is very case specific. But in terms of for professionals, those who are kind of pursuing a tech company for the most part, there is an easier sell in the sense of it's less of an investment, right? You don't need to make as much purchases in physical premises, in inventory. So in terms of like the cost perspective that you would need to demonstrate to the US government that this is a real and operating company and that it will be, you need to show that you have put enough into it to demonstrate that it'll get there. And that's harder on the more brick and mortar side of things. But that doesn't mean it's not impossible. There's other routes. E2 visas are generally more recommended for restaurants and for more of the brick and mortar companies versus like an O1, but that doesn't mean it's not doable. It's just more challenging, but I think that answers your question.
Right. It does. Thank you so much for getting into it and answering the question. Now let me quickly, get into my questions that I've prepared for you. So my very first question to you is, so what key trends do you see in US startup visa programs compared to those offered by other countries?
Yeah. So I obviously focus on US immigration, and most of my clientele are startups. I'm also licensed in Canada and am involved in some Canadian cases as well. I think the current climate of immigration, at least for the past 6 months, probably because of upcoming elections, because of economic, in terms of economies kind of struggling right now, there seems to be a tightening of immigration, at least, when it comes to the US, when it comes to Canada. But that doesn't mean that, you can time the system and necessarily wait it out, because I think there's no way to really kind of figure out when is the best time to pursue US immigration, and even international immigration for that matter, when it comes to investments, because, when you start your own company, everything's not going to align at once. I think it's really about paying attention to your company, what your goals are, and then using that to inform your decision about strategizing on the immigration front of things. So in terms of key trends, within the US, there's been, I think people are fearful of what's going to happen with the new administration and how matters are going to be adjudicated. And so there's been an influx in filing of cases. And so with that means that there have been more requests for more evidence. In terms of denial rates, I think I haven't in my own practice seen an increase. It still seems very, standard, based off of what I've seen. But again, that's my sample size. But I do see immigration on the Canadian side of things where there are changes constantly happening, and it does seem like they are limiting immigration because there was in the past few years there's been an influx, and so they're trying to limit that. They also have an upcoming election as well, so these are considerations in terms of kind of how these programs are adjudicated or available. But on the US side of things, these programs don't really close down, right? Like the legal framework of temporary work visas and the green card routes are like have been available since the 90s. What changes is USCIS's guidance on how they're adjudicated, the reality of how they're adjudicated, and the types of evidence that can be used. So, particularly, I mean, we'll dive into this later in the section too, but in terms of for startups, USCIS has kind of broadened what, H1B founders and O1 founders can do to demonstrate that they meet the requirements so that they can sponsor themselves as a beneficiary through a company that they own. And their framework has allowed for this. However, that can change because of the political landscape or because of a change in administration. So these trends are, I think, always moving, but for the most part on the US immigration side of things have stayed fairly consistent. It's just how we need to document the eligibility that kind of has changed.
Right, right. So, but do you think, have you noticed that maybe the recent US policy changes has influenced, the attractiveness of the startup visa for international founders?
I don't know if it's just an increase also of people starting their own companies. I think there was some statistic, and I don't quote me on who published it or where it was from, but I think it was post-pandemic where people really did start to take control of their own, just like their own employment overall, and did start to pursue, entrepreneurship. And I think that with that also means that immigrants are part of that conversation. And as there is, an increase in investment, the US obviously wants that investment to be inside the US. And so as they kind of open up these programs, and guidance on how they define the eligibility criteria, I think that has allowed for more startups to kind of pursue these routes with a little less challenge than they were met with before, because there was less clarity in the law. But that doesn't mean it wasn't happening. I think that USCIS has kind of moved with how the adjudications were going and provided clarity on this is permissible, to kind of make it more clear to founders that it is doable and that they likely will, so long as they meet the requirements and can demonstrate such that they will approve those applications.
Right, right. But then, also I would like to know, Alyssa, that do you think that there are specific sectors? I asked this question, but still I would like to know that. Do you think there are specific sectors like maybe tech, biotech, where other countries are outspacing the US and attracting founders through their visa program? Because we recently had an attorney from Portugal, and we spoke with her regarding golden visa, and then we also have golden visa in I guess Dubey, right?
Dubey,
so yeah. So do you think that is also happening?
I think that the US market is very unique. There's always, everyone's going to always want to enter the US market, even if these other countries are available. I think that for periods of time, the availability in these other countries may be, based off of people's life situations and their choices, that those may be options that they choose over going to the US. But I think that, it's one of America's, everyone just, not everyone, but there is always going to be this market of wanting to grow your company in the United States, to be able to kind of grow to that next level. So I say that to say that even while international countries are kind of opening up in their investment visas and even in their nomadic visas for freelancers, as we've seen an increase in, especially since the pandemic, as people are moving abroad and wanting to live internationally and work remotely. I think that there is and will continue to be a US market for startups. And I don't know if the opening of those programs has necessarily impacted the US immigration side of things. but that's, again, just my opinion, right? Like that, yeah.
No, of course. I mean, people can choose whatever countries, but they're always attracted to US. That's absolutely true. And
Yeah.
but then, could you provide like an example of a particular country that you feel that you must have noticed, notable success with startup visa program that you would want US to learn from?
That's a good question. I actually think that I'm not too well versed in the other programs, but it seems like for the most part, if you have sufficient funds, you can, they're kind of framed in that way that if you have sufficient funds, you're going to put that money at risk and purchase either a property or a business in these respective countries that is leading to a side of permanent residence or just residence in general in those countries. And I think that there's also been some pushback from what I understand, again, not licensed abroad. But I think that the EU overall has been kind of looking into these programs specifically because there's some countries like Portugal that have opened up investment because of the nature of their economy and wanting to increase more international movement into their country. But then the rest of the EU isn't so open to those, everyone having access to those open borders. So I think that in some ways it's been working, but I feel like they're also kind of narrowing it down now in a way that is a little limiting. Whereas the US has just been fairly consistent. And if anything has made it a little bit more difficult, right? I don't handle too many EB5s, but obviously like that pathway to an investment green card essentially is a very high threshold. It requires a large investment financially. But for the most part, most of the clientele that I'm dealing with are eligible for other work visas and even green card routes that don't require a huge financial investment. Those who can do it and generally and are eligible and have the funds available to do a 1.5 million plus investment, they will, right? That's the route that they're going to take. But I think that there are opportunities in the US based off of the current current work visas and green card routes that allow for little to no investment, but still a clear trajectory and plan of what that company and investment will be in the US, which is in some way an opportunity, but it is also very limiting because you need to meet certain eligibility criteria, right? Like for an O1 visa, it's great, but only if you can show that you're of what the USCIS defines as extraordinary ability. And sometimes that doesn't make sense in certain industries, right? Someone who is maybe pursuing retail or is pursuing a restaurant business may not have these particular awards and have earned this, a certain salary or have scholarly articles. Like it's very academic focused in terms of how it's been framed. So I think for those in tech or who come from a professional background, it does seem easier and that there are more routes available. Purely investment routes do require a little bit more of a financial commitment to have that opportunity in the US as well. But I do think, right, that if the US kind of lowers that requirement of what kind of investment is needed, it will open opportunity for more investment into the US. I just don't know if they're going to be open to that.
Okay. I would also like to tell you, thank you so much for answering the question. A lot of people have also joined us and they are constantly posting their questions. If you can see, let me quickly say hi to them. Dharmesh is here, Ishani is here, and I'm also getting questions on WhatsApp. So hi guys, a big hi and a hello to you. And thank you so much for your question. We'll be taking them in a bit. But before I take your questions, I would again like to tell you that we are live not just on YouTube, but also on LinkedIn, Facebook, Twitter. So make sure you subscribe to us. The handle is Immigration Talk Show. And yes, you can also, post your questions on these platforms too with, of course, YouTube. So we'll be taking your questions in a bit, but before that, let me again discuss a few questions with Alyssa. So Alyssa, you mentioned different visas. So now let's discuss those visas which are for startup founders. So what are the key differences between O1A visa, EB2 NIW, and EB1A visa for startup founders? And which one would you recommend for someone just starting their business in the US?
Yeah, I really like this question because I think it allows me to also clarify something where I think sometimes people have a common misconception is that green card routes are very different from temporary work visa opportunities. And so from the three that you listed, right, there's O1, which is a temporary work visa, and then EB2 NIW, which is the national interest waiver, and EB1A, for those of extraordinary ability, is an eligibility criteria for a green card. So when assessing which one to pursue, I think it depends again on the circumstances of the founder's situation, but ultimately the EB2 NIW and EB1A are more long-term plans. They don't provide any work authorization in the US. So if you are abroad and you're not inside the US and you've already started your own company, but you know you eventually want to grow into the US and you don't have so much of a quick timeline on your hand, like an immediate rush to go to the US, then pursuing an EB2 NIW or an EB1A, depending on, you know, your eligibility and demonstrating that, which we can kind of dive into, is a good idea, especially for people who are born in India, because wait times are very long for green cards for Indian-born nationals. And it's based off of country of birth, unfortunately, not on citizenship. So even if you did become a Canadian citizen, that won't really open any opportunity for a shorter queue for the green card. So what you do by kind of getting to this sooner than later is you are locking in what's referred to as a priority date. And your priority date is what determines when you can eventually apply for your green card. So locking this in sooner than later shortens your wait time for eventually securing a green card. I say that to say that if you are, you know, if you have a quicker, if you need to be in the US immediately and you want to start working on your US based company, then you need to secure underlying work authorization, which includes an O1 visa. There are other work visas that are options as well, which can be H1Bs, L1s, E2s. I think these are the four main ones that my startup clients will pursue in terms of underlying work authorization, while simultaneously either building up their profile to be eligible for an EB2 NIW or an EB1A, or pursuing that and submitting that application while they're growing their company inside the US. So in terms of which one is the best, it'll be very, you know, case specific. I would say that, I mean, for people who aren't too familiar with the eligibility criteria, an O1A visa, you need to have a petitioner, which can either be your direct employer. It can be an O1 agent, which is a US citizen who kind of oversees your work and will be authorized by, a lot of gig workers will use that. So they have like existing contracts and they freelance. And so the clients that they freelance with are willing to authorize this O1 agent to petition the O1 visa application for the individual. And then the third option is to have a US entity that you own petition you for your work, which is the startup founder route. You can, you know, have a co-founder depending on your circumstances, or you can have a majority stake in the company as well. And there's certain requirements you need to meet to demonstrate an employer-employee relationship, which we can also dive into on this session as well, because I think that's the biggest crux of eligibility for these work visas that is specific to founders. But not only that, you then need to demonstrate that you are of extraordinary ability, which high level is, you know, layman's terms may mean something different to everyone, but USCIS clearly identifies what those 8 criteria are. You need to meet a minimum of 3. And for different founders, for different industries, the types of evidence that we can kind of submit to demonstrate that you meet this criteria varies. Like I said, the regulations and the law is written in a very academic nature. So it's pointed towards, you know, there's a criteria for scholarly articles, but someone who is in an entire, I'm trying to think, who's in retail, right? And in design, I mean, they may have written scholarly articles related to design and while they were in university or pursued academia, but for the most part, that's not the case. So really, it's about delving into what your industry is, the nature of your startup and your specific work, and then how you can use your experiences to date to demonstrate that you kind of have this corroborating evidence in those criteria. And so that's the O1A. In terms of the green card routes, then the O1A criteria is very similar to the EB1A criteria. Instead of 8 criteria, there's 10, 2 more that are related to arts. And it is a way higher threshold. For an EB1A, you don't need an employer to sponsor you, so you can self-petition. It is a first preference employment-based green card route, which also means that priority dates for green cards are a lot. It's a much shorter wait time, which is why they are very heavily sought after. But meeting the threshold for an EB1A is a very high standard. And so generally, based off of my client situation, we'll get them going on the O1 and we'll come up with a game plan of how to enhance their profile so that they're EB1A ready in the next year or two, depending on where they're at with their application at that point. We kind of do an assessment. We work together and identify what is feasible with their career. Sometimes getting publications going takes a long time versus one of the criteria is peer review. So that requires less work in terms of having to sit and publish content, but it does require more networking and engagement in the industry. So we kind of strategize on what makes most sense, because you're also creating and growing your startup at the same time. And so there's only so much you can do while also pursuing your goals, right? You get so focused on the US immigration side of things, and then your company fails because you're just so focused on that. So it's really an alignment of understanding this is a long-term journey, but it's doable, and it's really about being as targeted as possible in your approach. And then the EB2NIW has been a great route, I think, again, for the last 6 months in adjudication for both EB2NIWs and EB1As. There's been an influx of people just applying to get their foot in the door. And not all these cases are viable cases, unfortunately. And so it's kind of backlogging the system and making it difficult for people who actually have viable cases to get approved, and it is increasing RFEs. And so, but like I said, you can never really game the system and figure out a best time to apply. If you are in a position where you are eligible, I would say still go for it. Work with an attorney who knows what they're doing and will work with you on kind of presenting the best case, but be prepared to be met with potentially an RFE, to be met with a bad adjudicator who may deny, and you may need to refile or you may need to litigate. The system, unfortunately, is not the best system, but there are mechanisms to kind of eventually get there. It's just, you got to be committed. But the EB2NIW, just like high level, is demonstrating that you're going to be pursuing a proposed endeavor. Technically, this endeavor doesn't need to be clearly defined, but it won't be approved if there isn't clarity on what it is. So you need to identify what your proposed endeavor is, and then on top of that, demonstrate that it is in the national interest of the US so that they can waive the labor certification process, which is the more classic employer sponsorship route for green cards. The EB2NIW also allows for self-petition, so you are not tied to your employer, which allows for greater flexibility too. But there are like additional eligibility criteria, but just high level in terms of whether you're selecting to pursue the EB2NIW versus the EB1A. EB1A has a higher threshold. Most people who will pursue EB1As are primarily Indian borns, because for an EB2NIW, if you are eligible, wait times for a green card aren't ridiculous, and you will, be likely eligible in the next few years to be able to either adjust your status or get a green card. So, and if you did pursue the O1 or any other of the startup visas, be it through an L1 or an H1B, you likely have at least 2 to 3 years of work authorization while you're waiting out for your priority date from your green card to be current.
Right. And also in cases like these, the role of the right kind of attorney for you also comes into play, right? You should have the right attorney to help you with your case, right? So guys, if you're looking for an attorney, and if you have
a startup, and if you want to get a visa, and if you're looking for an attorney, so you can get in touch with Alyssa. Here are her details. You can email her on info@crossingfrontiers.ca, info at crossingfrontiers.ca. I want to spell it right so that people can note it down. And also, you can also please visit our website, which is www.crossingfrontiers.ca. Yes, do visit our website, and also you can write to her. You can email her. And now, Alyssa, thank you so much for that detailed answer. So I would also like to know for you, for founders who are early in their careers, so which visa option would you recommend for them, so that they can that would offer them the most flexibility to pivot or expand their ventures?
Yeah, I think it is, like I said, of the main four, the go-tos, it really is dependent on, the nature of how they're kind of developing this startup in the US. And then there's also some like case specific based off of nationality for the E2, for example, versus if this is an intra-company transfer where someone has their startup that they started abroad and are now bringing to the US. So those are all considerations, but I'd say high level, like the pros and cons of the four, I can kind of go through those. Like for the O1, a huge benefit is that, there's no limit on how many times you can extend. You first can get up to 3 years, and then technically every time you request an extension, you can only get one additional year each time. But if something major has changed in the trajectory of the company, we can kind of file this as a new employment. And so we can request 3 years on an ongoing basis with that. So the benefit of an O1 is that you're not limited in number of years like you are with many of the other visas, including H1Bs and L1s, which are limited to 6 years for an H1B and then 7 years for an L1A or 5 years for an L1B, which can be quite limiting. That time goes by so fast. So that's a benefit of the O1. A downside is that your spouse doesn't get work authorization from you having an O1 visa. They would have an O3, which has no employment associated with that. They would need their own employment visa in order for them to be eligible to work. And that is quite limiting for some families who both spouses do work. In terms, again, another limitation of the O1 is demonstrating that you're an extraordinary ability and that you meet that criteria. But I do find that many founders actually do not realizing that initially. So I would say, do your research, look online at the criteria, at the 8 criteria. You probably will check off at least 2 based off of, think deep about it, about your portfolio, about things that you've done to date. And most clients, when they come to me, at a minimum, have at least 2. And then we kind of work on pulling their profile together, seeing if we can kind of reach a 3rd or a 4th, or, I give them like a 3 to 4 month time frame. And I'm like, okay, focus on these ones and then come back and we'll reassess. So that can be limiting because you need time to do that and you need authorization to grow your profile if you're in the US. So you need a backup visa or something else that's keeping you inside the US if that's your plan and you need to start working immediately. So that is a limitation. In terms of H1Bs, they are beneficial in that you don't need to demonstrate this extraordinary ability. As long as your role is in a specialty occupation and that you will be paid the prevailing wage and you can demonstrate that need, then it's sometimes easier to meet that criteria as a founder where you are quite early stage and haven't built up your portfolio so much. However, there's limitations to this. You need to be able to have enough funds to pay yourself the prevailing wage. For the O1 visa, there's no minimum amount that you need to pay yourself. Generally, we recommend, obviously, making sure you're compliant with local employment laws and all of that. But, you can pay yourself a larger portion through equity. And that can kind of, offset paying yourself a little less and demonstrating to USCIS the nature of your work, which is very common for founders. So the limitation of the H1B is that you are, the Department of Labor has to, approve, and you need to demonstrate that you're going to be paid at least the prevailing wage of your occupation based off of your geographic area, which can be quite limiting. But there are strategies around this. Instead of submitting a full-time H1B petition, you could submit a part-time one where you'll pay yourself hourly and within a range of hours that you disclose in your application. So some clients will do that. They'll start off only working 5 to 10 hours a week as they're growing their business, and then they will add on longer periods of time or switch to a full-time H1B once they have sufficient funds for that. Like I said, a downside of the H1B is you're limited to 6 years. Time spent outside the US can be recaptured into that 6 years. With one exception, under AC 21, if you meet any of those requirements, you can extend beyond the 6 years, but that is if you are pursuing a green card route. The other thing is that spouses cannot work, H4 spouses cannot work unless you have an approved I-140, which is the green card pathway, and then that will allow for work authorization for H4 spouses, which again, pro or con, right? Another pro of the H1B is that it's a dual intent visa. So for most US temporary work visas, they are non-immigrant intent, except for O1s. They're kind of quasi non-immigrant, quasi dual intent, but the rest of them, like TNs, H3s, these are all non-immigrant intent, which means that you cannot have the intent to permanently immigrate to the US. However, H1Bs and L1s are dual intent. So if you have a pending adjustment of status for your green card, that won't implicate your intent issues with your underlying work authorization. So there's some benefit to that as well. And then in terms of L1s, so that's like, again, very case specific. You need to, high level, there's more eligibility criteria to it, but you need to have worked for your foreign startup, or it doesn't have to be a startup, your foreign company that you own abroad for one full continuous year in a managerial or executive capacity for an L1A. And then you open up your US operations and you keep your foreign operations going. And so you have hired a team out there who's running the foreign operations, and then you start up the US operations, work for it for one continuous year in a managerial capacity or executive capacity as well. That not only gets you a work authorization, which is the L1 visa, you also may be eligible for the EB1C, which is a green card route, which is like the EB1A is a first priority. So it's a good strategy for some Indian-born nationals to kind of take this route towards a green card that may be more plausible with their long-term plans. So sometimes that's a strategy too for founders. If you are willing and open to starting your operations abroad first and then coming to the US, then that's a route as well. I would say L1s are very USCIS kind of digs deep into them. You need to demonstrate the eligibility criteria. Our fees are very common. It's better if the individual moving is a professional in some capacity. The nature of their work will be professional. Doesn't mean it's not doable for others in terms of like a restaurant. It just is a little bit more challenging. You need to demonstrate more. USCIS asks for more supporting evidence for that. And then for the most part, you need to be able to demonstrate ability to pay, unlike for the O1. So you need to show that there's funds in the company that can pay you. And then for the EB1C, especially, that you will be able to pay yourself up until you get your green card. So you do need enough funds, which can be limiting. But an L1, like I said, is a dual intent visa. So that's good. Spouses get an open work permit based off of the primary applicant having an L1. So that's a benefit as well, because if your spouse will be working, then they're not tied to an employer except for to your startup, and probably just dependent on their spouse, but that's another story. And then the next one is the E2 visa, which is a very common investment visa. And the limitation of it, well, there are a few, but the main limitation is that you need to be a citizen of a treaty national country. So you can look up the treaty countries. Canada is on that list, but India is not. But so a lot of people who have immigrated to Canada and have now attained their Canadian citizenship, which is a way faster process than it is in the US, can then do an investment into the US through an E2 visa. There's no minimum investment. Generally online, you'll read that people recommend $100,000 minimum. This is not a threshold that the US government has set. It's not a real threshold. I would say $100,000 plus is definitely a case that may be an easier sell to the government, but I've had successful cases where they've spent $15,000 to $20,000. Ultimately, you need to put the money at risk. You need to demonstrate that the company you're investing in, either through a purchase or through starting on your own, is going to be, you show your 5-year plan, your business plan, that you're going to, make some US hires, that you're going to be, creating enough income that's more than just to support your family. And that's kind of the threshold you need to demonstrate. And in terms of the amount of investment, it needs to be substantial compared to the nature of your business. So if someone is going to be starting a trucking company and only investing $15,000, that doesn't make sense, right? You need a fleet. You need to demonstrate that you have purchased some of these, that you have a place that you're keeping them, and 15,000 isn't going to cover that. So that's not realistic. Versus someone who has a tech company that's just starting with one computer and this software that they're developing, 15,000 may be doable. So it's really about spelling out the nature of the company, what the long-term plans are, and then there's a component of sourcing the funds, which is a part of the E2 visa, which is important. So depending on, you can get funds from, I was going to say anywhere, not anywhere, but it could be gifted to you from a family member. It could be VC funding. Ultimately, you just need to demonstrate that the funds were given to the applicant or the treaty national company, and that those funds are now at risk and being spent on the business. So that's kind of how we focus on the sourcing of it. And then for E2s, another benefit is that your spouse can also work. So of the 4, spouses can work on L1s and E2s in terms of the dependent visas, and sometimes on H1Bs, depending on people's green cards. But for O1s, they definitely can't. So these are all considerations based off of, everyone's, I guess, unique circumstances. So, yeah.
Right. Thank you so much for such detailed answer. Thank you so much for, explaining everything in detail. And that was really, really insightful, Alyssa. Thank you so much for that. So with that, I know a lot of people are waiting, and we also have to take the Facebook questions as well. But still, I would like to know one more question. So are there instances where a founder, might have initially opted for one visa, a type of visa, and then, after their business became successful, then they transitioned into and they opted for, a different visa?
Yeah. I've done a few of those. It's just all dependent on people's, situations. But like top of mind, what like a certain case stands out to me as someone who was on H1B. They were a founder. They started on a part-time H1B, and then they switched to an O1. And they did that because they were hitting their 6 years and they didn't have an approved I-140 at that point. So they were running out of time on their H1B, and they wanted to, and then they were eligible for an O1. So during that time when they were building up their startup, on a part-time basis through their authorized work on their H1B, they were profile building so that they could meet the O1 eligibility, so that they didn't have to leave the US for that 1 year and then come back and be reselected in the H1B lottery. So it's very common. I think if anything, for the most part, I would say once someone is a founder and on an O1, they generally won't switch to a different one, because at that point, you have a little bit more flexibility, unless, of course, someone is looking for work authorization for their spouse, or certain circumstances based off of, if they have travel and they want to be on a dual intent visa while their green card's pending, then they'll kind of consider something else. But I'd say most founders, once they're on that O1 route, they're now focused on their green card application and know that they'll continue extending their O1.
Right. Okay. Thank you so much again for answering the question. Now, let me quickly move to our audience's question. So, Kalpesh is here from LinkedIn, and he says, interesting. Thank you so much, Kalpesh, for your comment. Let us know if you have a question, if you would like to know anything. Please post your question in the comments below, and we'll be more than happy to take it. So, let me start with Dharmesh's question. Dharmesh says, for founders seeking an E2 or L1 visa, how do you assess if the business and investment actually meet the minimum substantial or qualifying thresholds required?
Yeah. So,
We also have a
sorry.
part two. I'm so sorry. We also have a part two. And he says, are there common misconceptions about what substantial investment means? Okay, let's start with the first question.
Yeah. So, in terms of substantial investment, that's required for the E2, not for the L1. But for the E2, like I said, I think we kind of did touch on this later on after Dharmesh posted his question. But basically, the investment needs to be the argument needs, we need to be able to demonstrate that the amount you're investing is reasonable and substantial for the nature of your business. So we would really, demonstrate that through pulling your business plan, looking at what you have already spent on, and then the nature of your business. So if all you really need to spend in the next year is on marketing, and that's reasonably a few thousand, then we would demonstrate that that would still be that's all that is really needed for your company, because the product is already developed. It's already been, it's really, there's not much more financial investment that needs to go in order to sell to clients. But again, like I said, if you have more inventory and you need it for the nature of your business, then we need to show that that money is substantial for what it is. So there isn't a clear definition. It's about arguing to the officer why this investment amount is substantial compared to the nature of what you are going to be doing in the US. And then for the L1, there isn't a requirement of how much you need to pay yourself. Usually if it's on the lower end, officers will question, how true and operating your company is if you're not paying yourself a reasonable amount. But for the L1, the focus is more on demonstrating your qualifying relationship between the foreign office, the US office, and then specifically with your managerial or executive role abroad and in the US, or specialized knowledge. So the focus then is on including evidence that shows that you have proprietary knowledge, or that you were leading a team, or you led a function of the organization. So that is kind of how that will be documented.
Okay. So Dharmesh, I hope you have got your answer. In case you have a follow-up or anything else that you would like to know about, please continue posting your questions. We'll be more than happy to take it. Okay, so Lasha is also here from Facebook, and he says, I'm already in the USA. I have a work in social. Can I still participate into green card lottery? And if I win, do I have to leave the country?
I actually don't deal with too many of the diversity lottery. I think he's talking about the diversity lottery green card, which I think just opened up last month. Don't quote me on that. I don't handle too many of those. So I won't be able to answer this specifically, but I would say kind of reach out to an attorney who does handle. I know that there's quite a few attorneys who specifically also only handle the diversity visa green card. So, like Rajni said, I think the focus on finding a U.S. immigration attorney is really, dependent on their area of expertise, which is unfortunate, because you want someone to kind of assess all of your options. But some of us are very, I am very experienced in working with startups specifically and within these various routes. And so I don't do so much of the diversity visa green cards, unfortunately.
But Lasha, we do have a lot of shows with a lot of attorneys on our channel. So you can, definitely subscribe to our channel, and we'll be bringing a lot of shows, and you can, ask your question, and we'll definitely ask one of our experts and we'll reply to your question. But thank you so much for, posting your question. We'll be replying to your question after asking it from an expert. Now, let me quickly take Ishani's question. So Ishani is also here from YouTube, and Ishani says, a startup client is considering acquiring a US-based company with existing employees on various work visas. What are the key immigration-related due diligence considerations and potential risks we should assess to ensure a smooth transition?
Yeah, that's a really good question. You should definitely engage with a U.S. immigration attorney to make sure that prior to purchase, because you want to make sure that you've kind of done all your due diligence, which obviously you're trying to do as well. I would say focus on making sure that you have access to all the petitions that the US-based company submitted on behalf of the employees, so you understand the commitment based off of financial commitment, in terms of length of period of stay, if there's pending green cards. And then you also want to make sure that you do your I-9 and E-Verify compliance as well. If they have been compliant, for them to provide that documentation to you. And if they haven't, that you make sure you engage with an attorney so you can set up a system internally so that you can make sure you're compliant moving forward, and you can demonstrate that and paper trail that. Also, when you do the purchase, depending on the nature of it, whether it's a merger or acquisition, the nature of the employees' work visas, you may need to disclose this to USCIS just to let them know that there's been a change in ownership, but that's very case specific. So again, I'd recommend kind of engaging with an attorney to go through that with you, because you want an attorney's eyes on those, an immigration attorney's eyes on those petitions prior, ideally, to you purchasing over a commitment for foreign employees.
Okay. So Ishani, I hope you have got your answer. In case you have a follow-up, please also post it. And thank you so much for your question. And okay, so Lasha is also back and he says, thank you so much. Of course, we are here to provide you information and provide you help. So thank you so much for being here. And let me quickly take Yuri's question now. And Yuri says, how do you evaluate the potential of visa options like the O1 or E2 compared to the H1B in terms of aligning with the startup's long-term goals? And then there's one more question. Then after you answer this, we'll be taking that.
Okay. Yeah, no, this is literally where I start off with my clients, right? If high level, they've consulted with me and we kind of know that they're potentially eligible for an O1 or an E2 and an H1B, then we unpack what makes the most sense based off of their plans. So if they already meet a lot of the O1 criteria, and then sometimes my recommendation would be to pursue that over an E2, because you don't have to put the money at risk yet. But if the nature of them, the startup, is that they're purchasing a company and the money's at risk anyway, then that may be the better route, because eligibility is for a longer period of time. If they do get married, or if they already are, then their spouse has that option. H1Bs are usually only applicable to people who have previously been selected in the H1B lottery, or are like simultaneously working with a cap exempt organization. So sometimes that's a limitation. And then at that time, I also want to know what long-term plans are. Do you want to pursue a green card? What are your plans? Do you want to change up your company? Are you going to start up a few companies? That's very common in the industry. And so how do we kind of want to frame your narrative for your green card application while you're pursuing your work option? So we kind of talk through that, and I try to understand your long-term goals and align that with what makes the most sense with the various temporary work options based off of that. And then also based off of adjudication at the time, right? E2 visas are not adjudicated for the most part by USCIS. They're adjudicated by the consulate office. So you're going in for an interview and someone's deciding on the spot whether you're eligible or not, versus an officer in USCIS who sits and goes through your documentation for days, right, or hours, and is really looking at everything very in depth. And so sometimes a strategy would be going to a consular office versus submitting it at USCIS, and there's strategies around that too. So it is all basically, I say, short answer is it depends on your long-term goals and the nature of your investment and what you're trying to do in the US.
But and so what if they don't have long-term goals? They're looking for like quick advice or instant advice for just that moment. So how do you manage that?
Yeah, I mean, I go into my consultations being like, do you eventually want a green card? Because if we need to assess that. But in terms of if that,
everyone does, right?
Sometimes a lot of Canadian citizens don't, because there's then tax implications of having a green card. So, and the proximity and all of that too. Sometimes it's not the long-term plan. Sometimes people just want to work in the US for 4 or 5 years and then go back home to their home country. When people tell me that, I say, if you are eligible for a green card, you should maybe still apply and decide at that time if you want to proceed with actually getting the green card versus not. Because, being eligible is, not too many people are. So if you want, that's a good opportunity to have. But again, very, very specific to the situation. But I would say in terms of evaluating I do on consultations, I will do like high level of collecting as much information through our conversation as possible and giving you my high level advice on what makes the most sense. I would say in terms of the O1, E2, H1B, like I said, there's all the pros and cons I listed previously, and it'll depend on, do you want to have to pay yourself a certain amount, right? With the H1B, do you want to put those funds at risk for the E2? Do you meet the eligibility criteria of the extraordinary ability for the O1? So if you meet all three of those, then it's a strategy of, okay, which one has better adjudication? Which one are you currently most prepared for? And likely, I'd say if you meet all three of those, the E2 is probably the better option, assuming you meet all three of those criteria. And of course, this is just, with as little information as possible on the circumstances.
Okay, and her next question is actually on the tax implications. So she says, please do discuss potential tax implications for investor visas. Also outline the application timeline and required documentation.
Okay, so in terms of tax implications, I am not a tax attorney or a tax professional, so I would recommend, because it's very specific based off of your home country and any tax treaties. So I would very much recommend that you speak to a tax professional on that. Like I said, there are tax implications for becoming a green card holder in the US, in that giving up your green card in the future or your US citizenship in the future for tax purposes. So because the difference with the United States, this is, again, I'm an immigration attorney, not a tax lawyer, but just in terms of informationally, the difference with the United States versus other countries is if you move abroad, you still have to pay taxes to the US government. So sometimes people will have, made a change in plans and they want to retire in a different country and they're still paying taxes to the United States. And so they may want to abandon their green card or their citizenship for tax purposes. And when you do that, you are, when you abandon your citizenship, the US government will ask you if you're doing it for tax purposes. And then in the future, if you ever wanted to come back, that will implicate your US immigration journey and options available to you. So that's a consideration in terms of once you are a green card holder and or a citizen. In terms of for the visas, the work visas, that is different. You obviously, when you're working in the US, you have to pay US taxes. How that works with your home country and treaties will depend on where your residence is and based off of the nature of the country. So for that, I would say talk to a tax professional. In terms of I think this is about the E2, right? Outline the application timeline and required documentation. So documentation, for the most part, will vary based off of the nature of your business. I'd say high level, you need to be able to demonstrate that you have the formation documents, that you have the business plan, you have all of the source of funding documents, and then you need to demonstrate your eligibility, why you're best to kind of run this business, which could be your resume, supporting documents of previous work in the industry as well. And then for E2 timelines, they are specific to the consulate. So you submit E2 applications to the relevant consulate in Canada. That's in Toronto. They're the only ones that adjudicate the initial E2s. And the timelines vary, but generally what I've seen is that when you submit the application, you'll usually get an interview within about a month or two max. That can vary depending on how busy they are. And then once you go to your interview, if they approve your E2, they'll send you your passport within a week or two. So E2s, in terms of, I'd say the application preparation time is a lot longer, but once you submit it, it gets rolling a lot faster versus an L1 or an H1B that get adjudicated with USCIS. And then if you need a visa, you need to go to the consulate or embassy and apply for that visa before you can enter the US. So timing kind of varies based off of your circumstances.
Okay. Thank you so much for that detailed answer. Alyssa, Yuri, I hope by now you must have got your answer. Thank you so much for your question. Okay, so Alyssa, it's already 1. We have crossed the 1 hour mark, but if you have a little more time, we can discuss a few more questions because,
Okay, I can do a few more minutes, yeah.
Okay, great. Thank you so much for that. Let me quickly take Arjun Mehta's question. Arjun is also here and he says, what are the unspoken challenges of switching between visa types? For example, moving from F1 OPT visa to an O1 or an H1B. Are there risk founders might not be aware of when they ladder through visa categories like this?
Mhm. It'll depend on, again, it's very important that you work with a qualified immigration attorney who's experienced in these, because what we'll do is we'll review to make sure that you were maintaining status in your previous visa status when we change status to one of the other ones. If there's a potential gap, if you, while you were in F1, you were unemployed for a bit, but you went beyond the permissible time, and that may raise a potential issue, then we may advise to do a consular process for your application versus a change of status from within the US. So it's very important to make sure that your immigration attorney that you're working with is reviewing your previous applications, your previous status, asking you those questions. And another thing to consider for F1 to one of the other visas is that F1 is a non-immigrant intent visa. You need to be able to demonstrate that you maintained your ties abroad. It won't usually come up at the change of status to another work visa, but it may come up at the green card stage. So you want to make sure that you are keeping documentation of your compliance of all your visas in the US. Documentation of that is keeping records of when you attended school, that you attended classes, while you were working, your pay statements, when you switch jobs, make sure you just download them and save them somewhere so that when you're applying for your green card in the future, if any of those things are questioned, you don't need to then go back to your old employer. You already have it all saved. And if there were any gaps in employment, that you demonstrate the exact dates and documentation that demonstrates that, so that you can demonstrate that you were within appropriate grace periods and that you timely filed your next application. So that's high level, but again, it's very case specific. Biggest recommendation I give to everyone is keep documentation of your whole US immigration journey, no matter what. It may never come up, you may never need to give it to you at CIS, but it's just the best way to be prepared for any potential questions.
Right, absolutely. And guys, if you want to get in touch with a good attorney for your case, so we have it right here. So you can get in touch with Alyssa. Her details are scrolling below, and also right there on screen. You can note it down. info@crossing frontiers.ca. You can write to her on her email, and you can also visit her website, which is www.crossingfrontiers.ca. Let me quickly take Rohit's question also. Rohit says, I have heard that national interest waivers and IW can be used for founders, but what does a startup need to demonstrate in order to genuinely show national benefit or interest? Is there any practical guidance you can give on the merit of a tech startup here?
Yeah, so it'll really be about documenting the genuineness of your proposed endeavor. So letters of intent of potential clients you're going to work with, or if you already have clients for your startup because you have work authorization to work for your startup, including those. Including, for companies that are quite early stage, haven't really taken off the ground yet, I would definitely recommend including a business plan that clearly demonstrates what you're going to be doing in terms of staffing projections, financial projections. That's not on the national interest component, that's on the proposed endeavor component to show the genuineness of your company. But in terms of the national merit, the national interest component, you will really need to identify the market that you're going to be in, the types of clientele. So I'd say if you're in the semiconductor industry, and that's an industry that USCIS has clearly, loves for national interest. There's a lot of supporting evidence in that. So you won't need to, the argument will be a little bit easier in terms of demonstrating the national interest versus someone who, is in real estate and in one geographic area, and you could be probably in affordable housing, and that is a national interest argument, but is it siloed to one geographic area? Is it national? So it's really for national interest waivers. The good and bad thing about it is that it's not definable. It's really about how you demonstrate to USCIS the impact of the work you're going to be doing and demonstrating that it is in the national interest of the US. And so that can vary based off of the nature of your work and the nature of your startup.
Okay. Thank you so much again for that answer, Alyssa. And thank you so much, Rohit, for your question. I hope you have got your answer. In case you have a follow-up, continue posting it in the comments section. And whenever we get Alyssa back for an episode 2, we will be taking that question maybe on in that episode. For now, Alyssa, I'll take a few more minutes, maybe 5 more minutes or 2-3 more minutes, if that's okay for you. I would like to share my screen and show those Facebook questions. I would also like to get an answer to those Facebook questions. So I think I'm already sharing my screen. I don't know why am I not able to show it. I would like the control to help okay, it's here. Okay, so let me take it from the top. It's just posted 1 hour back, and let me zoom my screen a bit. So this anonymous participant says, trying to figure out where to schedule an H4 visa appointment for my spouse. Is Islamabad Consulate Embassy still conducting these interviews for first time? Okay, I think this is for Pakistan. But then here is one question from Hari Krishnan, and he says, if I book Dropbox appointment in Chennai, can I submit documents at Bangalore drop-off location? So is it possible?
I would say for all the consular related questions, because they're so specific to each consulate, each consulate does things differently based off of location. So at a minimum, what I'd recommend is they have their email addresses posted and their phone numbers for the most part. So reach out to them, and you can also specifically ask. And otherwise, your attorney should be able to answer this question, because if they are providing consular processing support as well. But each consulate is different. Things change on an ongoing basis. So I would recommend reaching out to the consulate.
Okay. I think that's a great answer. Thank you so much for that. And then there is this one more participant who says, hi guys, the salary mentioned in LCA is different from what is mentioned in the offer letter. So which one to tell when the visa officer asks for the interview about salary?
Yeah, I mean, this is very case specific. I'd want to look at the whole petition to make sure that what was disclosed is the offer letter's salary higher than what's been disclosed in the LCA. At a minimum, you need to, if it's drastically different, you need to be able to, you likely haven't disclosed to USCIS the actuality of your petition. So you may want to file an amendment of the LCA. Sometimes what I recommend for clients, especially for startup founders who don't know how much they'll be paying themselves, is to put a range so that way, if you end up paying on the lower end of the range, or if you eventually want to pay more, you can you have that wiggle room. At a minimum, you need to be paying above the prevailing wage. So I would, if you are going to the interview and you are going anyway, I would make sure that the offer letter salary is higher than the prevailing wage for the specific role and the location, which likely is the one in the LCA.
Okay. Thank you so much for that answer. And then there is one more participant who says, hello, everyone. I took 10 months of break due to health issues and did not travel to USA on H1. I have H1B valid till October 2025. Will it be any issue at immigration? And from past 3 months, my pay stub did not generate.
If you're outside the US, you don't have any obligation to be paid. USCIS only has jurisdiction on your work authorization while you are on US soil. Did not travel to the US on H1, so any of that time you were not using your H1 time, you don't need to demonstrate that you were being paid during that time.
Okay. So after this, let me take maybe one more question for today's show, and then maybe we can wrap it up. So this participant says, I just appeared today, 4th of November, for consular interview at Chennai, and my visa H1B was approved, but I have not received any blue slip from the lady who took my interview. Is it normal? And any idea by when can I expect my passport? I selected VFS Delhi for delivery. Please, if anyone can provide clarification, it'll be grateful.
Yeah, again, dependent on consulates. Mm-hmm. Yeah, but for the most part, I'd say unless you're put into administrative processing, which they may do afterwards too, even though they said it's approved, it could still happen. That may delay the process, but for the most part, once it's approved, you'll generally get your passport within a few weeks. And then if you don't within a few weeks and you haven't heard anything about administrative processing, then I'd recommend reaching out to the consulate to touch base on when you should expect it.
Okay. Thank you so much for those answers, Alyssa. I would really like to take more questions, but unfortunately, that's all the time we have. Thank you so much for extending the time too. And thank you so much for being here. And, it was a great episode. And thank you so much for that great debut that, on Immigration and Jobs Talk Show. And for our audiences, I would like to say to get in touch with Alyssa, you can email her. Her email ID is info@crossingfrontiers.ca. I would like to read it. info@crossingfrontiers.ca. Yes, that's our email. And you can also visit our website, which is www.crossingfrontiers.ca. Thank you so much again for being here, Alyssa. There were so many questions still pending and we were not able to cover all of them. So if you're okay, we would love to have a second part to this episode.
Yeah, I would love to do that. I like this. And I think that the more, targeted questions we get as people are more informed too, then we can kind of unpack them more in detail as well. So I'd be happy to do another session. But I had a lot of fun doing this. I, love talking about U.S. immigration for startups. So this was a lot of fun.
Thank you so much. Thank you so much for that, for those kind words. And we are going to see you very soon. And we are going to, schedule the show. We'll check your availability for a second episode. And thank you so much again for being here. And your answers were insightful, detailed. So thank you so much for being so elaborate and so detailed with your answers. Thank you so much again for being here.
Thank you.
Guys, that's it from our side for today's webinar. We are going to see you very soon. With an episode 2 of this webinar, and we are going to have Alyssa back soon. But until then, you guys keep on watching and keep on subscribing to Immigration and Jobs Talk Show. I'm Rajni Parara signing off for now. Take care and keep subscribing and keep watching Immigration and Jobs Talk Show. Bye for now. A big hello and a warm welcome to all of you to Immigration and Jobs Talk Show. I'm really happy and thrilled to have each one of you join us. I'm Nipasa Pradhan and I'm going to be your host for today's session. And we are streaming live right now on YouTube, LinkedIn, and Facebook. And before we start with our webinar today with our guest, I have this very important disclaimer, and that is, by watching our videos, you agree and understand that the information provided by our experts, including comments and replies from users, is not legal advice. Use of information is at your own risk. So very, very thrilled today to be here with all of you to explore this topic that impacts countless lives out there and the future of our workforce. Definitely, today is election day, and we are looking ahead to ask, what will U.S. immigration look like in the next 5 years? I'm sure this is very, very exciting, overwhelming for all of us today. And with so many recent changes today, we are going to discuss and basically talk about what does America's future look like. And joining us today in an expert with decades of experience in immigration law is, for the first time joining us here on Immigration and Jobs Talk Show, none other than Mr. Charles Cook, who is the founder and managing partner of Cook Baxter LLC, where he leads the firm's global immigration practice. So it's really very, very exciting and such an honor to have you with us here, Charles, today. Thank you for joining us.
It is a joy to be with you today. Thank you so much. What an exciting day in the United States.
It is. And I'm sure, I mean, you are a new face in our channel, but folks out there know you and they would love to know you better. So could you please tell us more about yourself?
Well, thank you. I'm actually the former national president of the American Immigration Lawyers Association, otherwise known as AILA. I'm also a founder and former president of the Alliance of Business Immigration Lawyers. I've been doing immigration law for 36 years. You can tell by how old I am and all this gray hair. I've represented more than 75,000 people in their immigration journey through all types of immigration, not just H1Bs and labor shirts and Ls, but literally everything from asylum to adoptions to naturalization. I've done it all. Including lots and lots of federal court litigation. I am one of America's leading immigration lawyers in the area of litigation and bringing justice to people whose cases have been pending for a really long time. I've also done a lot of lobbying in Congress. I've testified in Congress a couple of times. And I do a lot of commentary on the Twitter machine as well as it relates to immigration. But most of all, I am the grandson of immigrants. I grew up in an immigrant household, obviously not from India. Obviously, you look at me. My grandparents are from Germany. My dad's first language was German. He was born in Brooklyn. I was born just over the river in New Jersey and spent my growing up years there living in my grandparents' house. And today, as quintessential American story, I don't speak German.
Okay.
I speak Spanish fluently, so quintessentially, I am the American experience. I mean, you look at me, I know I look like he looks like an American. And in reality, I'm the grandson of immigrants, like everybody here in America is. So for me, America is a very special place. It is a place where you can truly make your dreams happen, regardless of who the president is. Just sometimes it's easier than other times.
It's really, truly an honor and a pleasure to have you here with us today, Charles. You look vibrant and radiant and so full of knowledge already. I'm super excited to have you burst out whatever you've got to say today.
I should be nervous because of the election, but oddly enough, I'm not nervous about the election. I have a feeling of confidence in a good outcome. So it's where we stand.
Definitely. So what can folks out there who have joined us expect from us today?
Well, let's talk about what immigration is going to look like. Obviously, where immigration is going depends on who the president is. Now, keep in mind, only Congress can change the law. And the law is 40,000 green cards in EB3, 40,000 in EB2. That's the law. No president can change that. Presidents can change interpretations of the law, however. So, for example, a long-time interpretation of the EB1, EB2, EB3 numbers is that it includes family. So it's not 40,000 EB3s a year for 40,000 workers. It's only 18,000 because the average family size is 1.1. So the numbers are drastically reduced by counting family. That is an interpretation of the law. It can equally be interpreted to say, no, it's just people. Congress clearly didn't think that only 18,000 foreign nationals should get a job and a green card in America each year. It's a silly interpretation. But that takes a president who believes in it to get that interpretation changed. So a lot of what's going to happen in the next 5 years really depends on who's at the helm of the USS United States. And so today is the election. And although I think something like 73 million Americans have already voted early, America's very weird on elections. There's not just an election day. It's an entire season that starts 3 weeks before the election. And Trump's been campaigning since he lost the last election. So a lot will depend on what happens today. We don't know the vote total. So 73 million people have voted, but we don't have any idea how they voted. They don't release those numbers until after 7 p.m. Eastern time, which is tonight. I'm on Eastern time in the United States. They begin releasing the vote tallies from those that close. And each state controls when their polls close. Sometimes it's 7, sometimes it's 9. Sometimes judges order they stay open because there's long lines. American elections are a mess. But here's what happens. If you're elected, let's say Trump wins, he doesn't become president right away. He doesn't become president until January 20th. That's when our presidents are sworn in. So Biden would remain president really for the next almost 3 months, and then Trump would take over. Same thing with Harris. And we're not going to know tonight it's possible we know tonight, depending on where Georgia goes, where Florida goes. But unlikely we won't know until 2 o'clock in the morning, 4 o'clock in the morning, when we get poll results out of Wisconsin, Pennsylvania, and really further west out in Arizona and Nevada. So we don't know. I mean, it's just literally a toss-up. Every pollster says 50-50. One thing I will tell you this. Our law firm, we have 45 folks that work here. 40 of them can work and can vote. 40 of them are citizens. And every one of them already voted. Every single one. That's highly unusual in the United States. And they all voted for Kamala Harris. And that should tell you something about where we think and who will be a friend to immigrants and who will not be. I see far too much on the Twitter machine from folks from India who think that somehow Donald Trump is going to be really good on immigration. And Nabasa, that's just not going to happen. The very first plank in his platform on immigration is, day one, issue an executive order that children born in the United States to parents who are not citizens themselves are not citizens. Which, of course, is illegal because we have a constitutional amendment that says they are, but that lets you understand who he is as a person and what he believes about immigrants. Now, while Donald Trump hates immigrants so much, I don't know. He married 2 of them. Once again, immigrants doing jobs Americans won't do. Pretty funny.
don't know
And of course, Kamala is, her mom's from India, right? So she is half Indian. She is the quintessential American. Dad from Jamaica, mom from India. How does that even happen? How do they even meet? So, and the thing about Kamala Harris is that she actually understands immigration law, which is crazy. Very few presidents do. But she has delved into the area. She was involved in it as a lawyer. She was involved in it as a prosecutor. And she was one of the best friends that immigrants had when she was a U.S. Senator. So she gets it. Now, unlike Biden, honestly, he's a nice guy. He's a nice old man, and he saved us from Trump. But he doesn't get immigration. He was never, ever, even when he was in the Senate, he was never good on immigration. He just wasn't. And same thing with Obama. He was never good on immigration. So we have a lot of hope for Harris. But let's talk about these policies, all right? So in the United States, there are 4 ways that you can come here legally and immigrate. You can get asylum. It's not happening right now from India, right? You can win the green card lottery, which of course India can't participate in. And you have employment/investor immigration and family immigration. Now, family immigration itself is pretty fixed, delineated by Congress. Congress has written the laws. There's not much you can do as a policy perspective on family-based immigration, except you can do what Trump did the first time, which was stop adjudicating cases. I know that because I sued him hundreds of times for not adjudicating cases. They just don't do them. They just put them in a box and don't do them. So you have to get courts to intervene. That's all they can really do. On employment-based immigration, however, there's a lot of bad things that can happen in a Trump administration and some good things that can happen in a Harris administration. So, for example, if Trump is elected president, one of the things that could easily happen on this employment-based immigration stuff is he can get rid of STEM OPT. So you're in the country, you're in a STEM field, STEM OPT gone. They are definitely going to do that. They're going to publish a regulation. STEM OPT is gone. One proposal written by Vice President Vance when he was in the Senate actually bars anyone from immigrating under EB1, extraordinary ability, or EB2, naturalization waiver, until they have lived outside the United States for 10 years after they graduate from a U.S. college. That would be crazy. That would eliminate a lot of people, including many Nobel Prize winners, from getting green cards in the United States. They can change how the H1B lottery works. Right now, this next year is the first year of the higher fee, $215, I think. And you're gonna pick by the foreign national. So you, not your employer, but you are going to put in for the H1B. Whereas what Trump will do will say, no. H1Bs are by bidding. It'll be like the eBay of H1B. Who will get paid? We will give H1Bs to the highest paid people. That was his proposal last time. They just didn't get it published in time. That's going to be published in February of 2025. We're going to see drastic changes to the L visa program, where they're going to make it very hard, not that Biden hasn't done a terrible job with the program anyway, but make it much harder to prove who's a manager or executive. H1Bs are already now more limited under the new Biden administration. They're going to crack down on what jobs require degrees. One of the things that's been happening in the United States over the last 10 years is there's been a movement away from requiring degrees for jobs that have historically required degrees. A great example is a software programmer. Why do you need a bachelor's degree to be a software programmer? You don't. Heck, look at all the people losing their jobs because AI is doing it, right? So a lot of negative things can happen in a Trump administration on employment and family-based immigration. Now, Harris, on the other hand, obviously will keep in place the program for STEM, obviously, probably expand it to a certain extent. But what she will also do is look at the H-1B program a little more critically so that it works more effectively for the United States. Because she's a prosecutor, I think they're going to go after job shops, companies that just throw in thousands of applications for visas that don't really have work for them. Or where they abuse the employee and say, we're not going to pay you. I think there's going to be a massive crackdown under the Harris administration for H-1Bs in that regard. I think we're also going to see some attempts to change some of the interpretations of how regulations work. We're also on family-based immigration with her. The new Biden family parole program will keep going if we win the court case, which is today, by the way. And I don't think a lot of people in India realize this, Napasa, but there are a lot of undocumented Indians in the United States. Do you realize that? There are a lot. There are hundreds of thousands of Indian nationals in the United States who do not have immigration status, who came as students and overstayed, who came illegally. Hundreds of thousands. Many of them are helped by the Biden family parole program. And so I think that will definitely continue if we win the case today. Literally, the hearing is today on whether that program is legal. I think it is legal, but we'll see. I'm not the judge. So a lot of these key immigration issues will be drastically impacted negatively if Trump wins, and not at all or positively if Harris wins.
You're absolutely right. I mean, if Trump or, they have similar stances like what you have just said, and on immigration, everything is going to be heightened with a lot more scrutiny and stricter enforcement. I think it's going to be even more hard with regard to immigration for sure. But thank you so much. I mean, those were great insights. I mean, so much in the first 15 minutes already, so much processing and so much happening, I'm sure.
There's so much going on. Now, one of the questions you gave me was on, what is going to happen today? All right. So I don't know. I mean, I'm not a prophet, but I will tell you this.
We will discuss on the questions, but I think I'll just quickly say hi to our folks who already have questions, and you might see some of the comments popping up there. Right. So big hello to Anjali and Luan Dial, Luca. I think we should pick up a few before we go
that's
on
great.
with our
Anjali's got a great question here. How might the election outcome impact the likelihood of establishing a pathway for undocumented immigrants? Well, I think you hit the nail on the head. If Trump is president of the United States,
Anjali, we're taking your question.
There is 0% chance that there will be anything to help undocumented immigrants. 0%. In fact, there will be a crackdown, as he has promised, to deport 11 million people. Now, that is a great way to destroy an economy. That's how it works. You want to destroy an economy? I don't know if you know this or not, boss, but we've done this before. This wouldn't be the first time. We did this in 1957 and 1958 and 1959, 1960 on something called Operation Wetback, which today is, of course, a slur. Back then, we deported over 1 million Mexicans who had come to the U.S. during World War II to work in our fields and work in our factories while we sent men abroad to fight. Eisenhower created this, and we deported over 1 million Mexican men and 500,000 U.S. citizens. So it's not like the U.S. is fully capable of doing stupid things, which then led to a recession. Because that's what will happen. So, yeah, there's nothing coming from this. Now, Harris, on the other hand, has said repeatedly she voted for bills that were pro-reform when she was a senator. She will advocate for them. And think about this. This is actually really important to understand. Biden was always walking a tightrope on immigration because he wanted to run for re-election, and he knew he was running against Trump, who was anti-immigrant. If Harris wins, there's a whole new dynamic. Trump's not running again because he's probably going to be in prison. So he's not going to, maybe not. Maybe she'll pardon him, but he's not running again. So, and I believe that as Trump is defeated, so will we defeat this anti-immigration rhetoric. So it puts her in a much better position to work with Congress on not just passing this border bill on asylum that she says she'll pass. By the way, that bill would never pass again unless you add in some sort of legalization and take away the per country limit. Increase, and it's not just, hey, taking away the country. I mean, I've been an advocate for hey, the limit's the limit, and that's it. And people have really ragged on me about that. Because if you're going to take the women away for employment, you got to take it away for family. But that doesn't solve the problem. Right. Because all that does is share the pain, right? And now,
it's not
and now that ROW is the same, is terrible too. You have to increase numbers. You know, if I've got a lot of clients who applied for their green card in 2012, 2013, 2014 from India, and they're not getting a green card for another 10 years, 15 years. Even if we reduce the number, even if we said, okay, everybody, Indians can get them all, it's still 20 years. And then that cuts the rest of the world off, which makes no economic sense to anybody. So there's a really good thing that would come from a Trump defeat, is that would be a defeat for anti-immigration forces. That would relegate them back to the ash heap of history and would embolden the president, I would hope, to work with Congress and look, let's fix this problem once and for all. We can do that. So there you go.
Thank you so much for taking that up for Anjali. Very passionately answered, I would say. Thank you, Charles. Well, let's go on. We have a lot of comments on LinkedIn as well. So let's take this Luan Dial, if I'm pronouncing it right. Do we pay for visa or trips when we get jobs in USA?
Well, That's a great question. And the answer is no, you should not be paying for the visa. So let's say, I'm going to assume you're talking about the H1B visa. So the H1B visa, the employer is required to pay for that, the lawyer fees and the filing fees. You also should not be paying an employer for the job. That if immigration knew about that, they would deny the visa. I can assure you. I know people do it, but it's and I can't tell you it's illegal. I can tell you that immigration thinks it's fraudulent. But the trips, the airplane fares, that's on you unless you've got a really good employer. I mean, that's been my experience. You got to differentiate out the visa fees, the lawyer fees, and then travel expenses are different things.
Thank you for taking that up for Luan Dial. Thank you for your question. Now let's take up Luca. This is on today. Trump's advisors are already preparing massive cuts to legal immigration as soon as he enters office. That's what we were discussing. And everything from families and refugees to skilled workers is threatened. Economic insanity. What do you have to say about this comment?
What do I have to say about that is 100% accurate. Keep in mind, our refugees, there were essentially no refugees that came in 2019 and 2020. None. And keep in mind, that was when there was massive refugee crises abroad. Remember Syria? People forget about Syria. Germany took in 1 million Syrians. Not us. Not the Great White Hope. Not the Statue of Liberty. Not under Trump. So yeah, it's America will revert to a 1924 close the borders, shut the system down kind of country, and we will enter a massive recession, the likes of which we probably have not seen since 1929. That's a reality. And then tariffs on top of that, which of course are taxes on U.S. citizens. So there you go.
It's crazy what can happen today. But what do you think? I mean, let's take on when can we expect the election results to be out?
That's a great question. So in some states, so America has 4 time zones. I don't know how many time zones India has, but America has 4. How many time zones does India have, Napasa?
One only.
You have one? You have one time
Yes,
zone?
just one only.
That's crazy. It's a huge country.
It is, but we are under one time zone.
We have 4. So we have East Coast, Central, Mountain, and Pacific. What that means is, and about 70% of the population lives on the time zone Eastern, on the Eastern time zone, up and down the Eastern seaboard. Those polls, no election announcements are after the first polls close. The first polls close at 7 p.m. in some states. Some close at 8, some close at 9. Some states like Florida and Georgia count during the day, and then you will get initial results, especially on early votes, right at 7 o'clock. And but you won't get final results for Florida and Georgia until 8 or 10 o'clock at night, maybe midnight. States like Pennsylvania will give you initial results for maybe 20% of the votes at 7, but you won't get final results till 2 o'clock in the morning. Some states, we already know who won, like New York. Harris is going to win New York. All right, she just is, because that's just the way it is. I mean, it's most of the states in the Northeast are going to go for the Harris. So these swing states are what matter. So I have a home in Tennessee. Tennessee is red. It's as red as red as red as red. Trump wins it. So, and then you move every hour more in the night, you get the next set of polls. So this, if you've never watched an American election result, go online to one of these news sites like CNN and watch their video, because it's just fascinating. By the time California, and I will tell you, Western time zones, the last time zone, Pacific, we call it Pacific time, California, Washington, and Oregon, Hawaii, Alaska probably go Trump, but they don't have a lot of power. Hawaii will definitely go Harris. California Harris, Washington Harris, Oregon Harris. Then there's Arizona, which is the only other state in the Pacific time zone. They're a toss-up state, but the election may well be decided by the time their polls close, which are at 11 o'clock Eastern time. I will likely be in bed because I like waking up at 2 in the morning and seeing what the results are, or what they aren't. I will tell you this: in 2016, Florida reported at 9 o'clock that Hillary lost. I went to bed because I knew the election was over at that point. She was the first Democrat to lose Florida. If she lost Florida, she lost the election. Now, that's a different thing today. Now we know Florida is going to go Trump. We know that. So we don't really care about Florida's result. It's Georgia, Pennsylvania, and Michigan, all in the Eastern time zone. And then Wisconsin in the Central time zone. And if or North Carolina as well. If she wins 3 of those states, she's won. It's over. It's just over. And then the rest is just gravy. So that's kind of what to look out for.
Great, but still, again, so that's what we are expecting, folks out there. And I know how exciting this is and overwhelming at the same time. But I hope you're all vigilant and doing the right thing and practicing your right. Well, we have Bikram's question now. This is also on LinkedIn. We should take this up. But Charles, who is better precedent for tax cut for green card holder and citizens?
Well, if you're a billionaire, Trump. But if you're not a billionaire, not Trump. It's Harris, because Harris is not going to tax anybody. Taxes are going to go down for anybody under $400,000. Now, I know that sounds like a lot of money. And it is a lot of money. I get it. But in the United States, there are millions and millions and millions of people making more than $400,000, and billionaires that are paying essentially no tax. So she's going to go after very, very rich people. If you're, the average, ordinary American green card holder, citizen, Harris is your best friend on tax cuts, because Trump only wants to cuts for the rich people. And that's you can Google it. It's a proven fact that the people that benefited from his tax cut were in fact people that were billionaires. I will tell you this, something that a lot of people don't realize, Napasa. If you're a green card holder in the United States and you die here, basically all of your assets are taxed at 50%. Whereas if you're a citizen, there's like a $4 or $5 million exception. So if you're a green card holder and I don't really want to get a citizen, and you've got assets, you're a fool not to naturalize, because your relatives that you leave behind are going to be paying a lot of taxes. Just FYI.
Thank you for that very important information, Charles. I think that's a very important point you pointed out to be kept in mind. I think we should take up some of our questions now, Charles. Yeah? So let's go with mine. How might the election outcome directly impact key immigration policies such as family-based and employment-based visas?
We talked about that. I talked about that for the first 10 minutes. I mean, the reality is there's going to be impacts either way. But Trump, they're going to be mostly negative, and with Harris, they're going to be mostly positive.
Right. Well, and now let's take up another question. Let's take up Vikas's question.
I love
this is on YouTube.
Question. This is a great question. Great question.
Right. Indian Americans have historically favored the Democrats, but there has been an incremental shift in the community's voting behavior in favor of the Republican Party this election. Do you agree? And what, according to you, is making this change, Charles?
Well, this is 100% true. We've seen a lot of Indian Americans that favor Republicans. And that's because Indian Americans are very entrepreneurial. They are the wealthiest immigrants in the United States by far and away, wealthier on average than many native-born Americans. And that's just reality. And when you have wealth, you tend to go towards the Republican Party. Because historically Republicans have taken care of wealthy people, and Democrats have historically, and I'm talking since about the 1960s, not before. Before 1960s, it was reversed. The parties kind of switched positions, and Democrats will kind of focus on the poor, the disadvantaged, and help people, which means taxes. You got to take money to pay for that, and so we've definitely seen that, which is with Trump kind of an irony. Because he clearly does not like immigrants. It's just clear he doesn't like them. And so it's just, the irony doesn't escape me, but it's absolutely true, especially over the last decade or so. And I would think that if Republicans had nominated a normal Republican who actually believed in Republican policies, because in many respects, Trump's not a Republican. He was a Democrat most of his life. Did you know he gave Kamala Harris $2,500 when she was running for Attorney General like 15 years ago? Yeah, he was a Democrat for most of his life. So he's not really a Republican. But the reality is Republicans tend to be more favorable towards businesses, and that's why.
Well, thank you. Thank you so much for taking that up. And Vikas, such a lovely question. Thank you for participating. You can keep commenting if you have any further questions. Let's get back to Luan Dial. She's back with another question. I applied for a job in USA, New York, and they told me that I must pay for work permit. Is that legal?
No, that is quite illegal. And in fact, if you really want to burn it, make a complaint to Wage and Hour. Go online to the Department of Labor, Wage and Hour, H1B complaints. Just Google that and file a complaint against this employer so they stop doing this.
There you go. There is a permanent solution to that. Thank you, Charles.
I like this question. Go to this question from 1233. It's a great question.
Let's take this one.
It's a great question.
Anonymous, I wish we knew the name, but yes, we have seen a lot of reduction of tech jobs, which was caused by mass layoffs in the last 2 years. Which candidate could be the one trying to get back those jobs and stabilize the job market again?
Well, you have to ask yourself, this is a great question. Why were there layoffs? Were there layoffs because the economy reduced? No, the economy is growing like crazy. We're at 3%. Worldwide envy for the growth of our economy. The problem you have with a lot of these tech jobs is they can be done by AI. This is a problem. This is a big problem for tech. I don't think either president is going to say you can't use tech to do this work. Let's use Elon Musk as an example. Elon Musk buys Twitter and eliminates, 80% of the people working there? Now, initially, that meant the platform was garbage, but now it works again. What do you think the lesson learned from big tech was? You don't need all these people. And I'm going to tell you, tech jobs in the United States are not necessarily the future. First of all, you're not going to be able to get within about 10 years, H1Bs won't be available to many tech jobs. They just won't be, because we won't be able to prove that you need a degree to do the job. So the reality is, I don't think either president is going to do anything to stabilize the tech market, because both presidents, to me, seem all in on technological advancement. Maybe the better question is, how are they going to help people who are displaced by modernization, mechanization, and AI? That's the better question. And the only party thinking about that is Harris and the Democrats. Republicans are like, well, go shovel poop at the chicken house. That's what they think. Go find a job somewhere. Whereas the Democrats are planning for that with retraining and rehiring and things like that. So Democrats, I think, your only option in that respect. Now, keep in mind, I'm a lifelong Republican. I've got a picture of Ronald Reagan hanging on my wall over here. But the reality is, the party of Ronald Reagan is dead. It's gone. That's the reality.
But I mean, too much of everything is scary. I mean, look at technology advancement; it's scaring us now.
Well, I could be talking. In a year, I could be talking to AI for this interview, an AI video, right?
Yeah, they will need me.
You can.
Who knows? You will have an AI version of yourself doing your job online.
Yeah, I mean, you could just put me as an avatar, and they're talking to me, and they're talking that. There's no doubt that that's the future. If we can build enough power plants, we have to build more power plants, so that's going to happen. But the reality is, what does that mean for human beings? Does it mean that we're all going to be online playing video games all day long? Or does it move us to the next level? Hopefully it moves us to the next level. I'm a big Star Trek fan, so I believe in the future. I believe in the future. These things make us better. So there you go.
Definitely. Thank you. And Lawan Dial is back with saying, thanks, Charles.
You're welcome.
And we have another question. Do we have to pay for anything when you meet all the requirements for the job after the interview?
No, you don't pay for anything other than your plane ticket. No.
I think she's making her budget, but definitely thank you for your question.
Wanda, don't be deceived by this. The internet in the job market is full of scammers. It's full of scammers. And sometimes you just hire a lawyer, have a consult with a lawyer who's got a good reputation, so you can get an answer if something's real or not. That is not real. That is a scam. Don't do it.
Thank you. Now let's take up Shubham's question. There are two parts to this. Could the judiciary overturn immigration reforms passed after the 2024 election, potentially influencing policy implementation and enforcement?
Well, the courts do not overturn statutes in immigration law. This actually, I'm actually a law professor in my free time. I've been teaching for 25 years at Emory Law School. And the courts have a doctrine called the plenary power doctrine. What that means is that when Congress legislates on immigration, that's it. That's the final word. The courts will never overturn an immigration statute. What they will overturn executive branch or presidential policies and regulations. And we have a very conservative Supreme Court that is not necessarily friendly to immigrants, but generally speaking, they have not been super hands-on on immigration policy. For example, DACA is a great question. I mean, they could have ended DACA years ago and they didn't, because they realized this is going to hurt people. So could they overturn it? Yeah. I mean, they let a Muslim ban stand, right? The Muslim ban stood. So I would not suspect there's going to be a lot of overturning. And there's been a couple of recent cases out of our Supreme Court that limit different parties' ability to actually sue, whether they have what's called standing, whether they're actually allowed to sue, and then what jurisdiction the courts have over those cases. So there's a lot in play there, but I don't see them invalidating any congressional reforms. I do see them playing a hand in permitting some regulatory policy changes.
And he was continuing to say that the federal courts, including the Supreme Court, have the power to review and invalidate reforms deemed unconstitutional or non-compliant with existing laws.
Well, yeah, they clearly have that power in certain circumstances. There's actually an immigration statute that limits the power of the courts. Our courts, what's called jurisdiction, is defined by Congress. It's not defined by the Constitution, except as it relates to constitutional matters. And immigration issues are rarely, very rarely, constitutional, except when it comes to things like immigration detention and some deportation contexts.
Right. Thank you so much, Charles, for taking up all these questions. And thank you, folks out there, for participating. Keep commenting. We're really happy to have you participate. And maybe, Charles, you could tell us more, since we were talking about DACA. What could the election outcome mean for DACA recipients and other undocumented individuals who are in the U.S. currently?
DACA, if Trump wins, DACA's gone. It's gone. It's history. It's over. He will end it with a regulatory publication in February. It's gone. If Harris wins, it's still kind of hanging in the ether sphere. It's still kind of, and there are something like 50,000 DACA recipients who are Indians, from India. So it's not, this doesn't just affect Mexicans. There's a substantial number of Indian nationals who have DACA. Right now, DACA exists for people that received it before September 2017. Biden republished DACA and allowed new applications between January and May of 2021, but then a court stopped it. And that case has been ongoing now for 3.5 years. Then there was oral argument in the Court of Appeals of the Fifth Circuit last month on DACA. That court will likely find that DACA is illegal, but will allow DACA recipients to keep renewing. And then it will go to the Supreme Court, and we will get a decision probably sometime in late 2026 or early 2027 from the Supreme Court if Harris wins. The hope, of course, if Harris wins, Congress just says, look, if you've got DACA, first of all, the youngest DACA recipient today is 22 years old. 22. The oldest DACA recipient is 42. These are not children anymore. These are adults, many with families, many with kids, and it's just time. They're not going anywhere. This is their home. Fix the problem. The refusal to fix this is not just frustrating, but it's immoral. This is a morality issue at this point. When people have spent essentially their entire lives in the United States, deportation becomes banishment. It becomes maybe an unconstitutional punishment for them. And, an argument we can go into in the future.
And I mean, there's so many families who are breaking apart just for this reason, and it's so sad to see.
So I had 2 consults this morning for 2 people who had criminal convictions, unfortunately, both long-term, one from Vietnam, one from Mexico, long-term residents of the United States. They got addicted to drugs. They made some bad choices. They're gone the rest of their lives. They're never coming back ever. Our immigration laws are mean. I don't know if you've ever seen the play Les Miserables. Les Mis. I don't know if you've ever seen that play. It's a great story.
I
And
think it's Hugh Jackman, and it was like a musical, right?
story of Jean Valjean, who represents mercy, and Valjean, and then Javert, who represents justice. Our immigration laws were written by Javert. They're all about justice. There's no mercy in our immigration laws, and that's what makes them so terrible.
Here you go. We have Shubham back again. He has another question saying, "Thanks for taking my question. I would also like to know how will the outcome of the 2024 US presidential election impact the future of immigration courts and the processing of asylum claims?"
Well, there's a lot of Indians that come to the United States in the last couple of years seeking asylum. Honestly, I don't know where they're seeking asylum from. I don't know. Good question. I don't want to be in a pro-growth country. I don't know. Something. But our asylum system is completely broken. We have two different asylum systems. We have a defensive asylum system in immigration court, and then we have an affirmative system with the immigration service. There are over 1.6 million asylum cases in the affirmative part of the process. There's only 300 officers. 10 years. If you file today, 10 years before you get an interview. If you're in immigration court, there are over 3.5 million cases in immigration court. We have 675 judges. So if Trump comes in, they're going to want to hire judges. But here's your question. Who wants to be an immigration judge? What kind of person do you have to be that would enjoy the job that requires deporting people? You have to be a lawyer for 5 years. I'm not sure there are enough lawyers willing to sell their soul to do that 24/7. That's just awful. Harris wins. The reality is they will find more positive judges who will want to grant asylum and work these cases more efficiently. But we're never going to be able to deport our way out of this problem. And of course, if Trump really does win and want to deport people, you just can't pick people up you can't pick them up on the streets and deport them. If they've never been in proceedings before, you actually have to put them in front of a judge. And now you have 3 million people in front of you. That's why I said the system is entirely, completely, and utterly broken. There you go. All right, any more questions?
I think we'll quickly go for a short break and be right back. And by then, we'll take up a few more questions, Charles, if that's fine. Welcome back,
Hey,
everyone, to Immigration and Jobs Talk Show. I'm Napasta Pradhan, and this is the second half of this webinar we are having today on Election Day. What will U.S. immigration look like in the next 5 years? And we have with us none other than the very, very amazing guest for today. We have none other than Charles Cook. Thank you so much for this very insightful webinar so far, Charles.
my pleasure. It's great to be with you today. I love talking immigration.
Absolutely. And so are our, viewers out there. They have such amazing questions. It's really lovely having your questions and have you participate with us. Thank you. So, Charles, I think, yes, we have Luandi thanking you. Thanks for the eye opener, Charles. Thank you. Well, I think I would have this next question. If you can tell us, how might enforcement priorities at agencies like ICE and USCIS shift depending on who is elected?
Well, for USCIS, it's really important to understand that Trump has promised through the individuals in his campaign who have immigration background and will work in the agency that every application will have to go through a fraud review and supervised review before approval. That's not currently happening. That will slow things down to a crawl and will result in a lot of false claims of fraud by the Immigration Service because they are notoriously bad at identifying fraud. So it's going to be very, very slow at USCIS if Trump wins. I don't expect any changes if Harris wins, other than hopefully getting better management. Immigration, USCIS is so terribly managed right now. They basically promote from within, so they don't really have people that have outside business type of experience, how to run a large organization. And as a result, they're really bad at their job. ICE, on the other hand, as for the last 4 years, they've kind of just been twiddling their thumbs like this, waiting for the chance to deport people. So ICE, which we call ICE, will be very proactive in looking and searching out people with removal orders and working with local police as they arrest immigrants for various crimes or driving violations and put them in removal proceedings. It's going to be big changes for both agencies.
I would also like to know, what impact could this election results have on the backlogs? I think that's what most of us are concerned about. And also the visa bulletin and family-sponsored visa categories.
Well, of course, the visa bulletin is constrained by the law. Only Congress can fix the visa bulletin. It can't be fixed by anybody else. So you could, as I mentioned earlier, the administration could reinterpret who is included in the 40,000 in each of the EB3 category, EB1 categories to only include actual workers. They could do that. I'm not sure they will, but they certainly can do that. We tried to get Biden to do it, and he wouldn't bite. But I don't think he had the right people on the bus. I think we might have better. I know the person currently advising Harris on immigration. He's fantastic. And I think we've got an in on getting that interpretation done. But as far as the other aspects of immigration, Trump's going to make it worse. The backlog you have today will be much worse under Trump. And Harris, keep in mind, Indian nationals have a friend in the White House, right? This is how does it get better than that to have someone with an Indian mom in the White House? It doesn't get any better than that. And she loved her mom. So I think there's going to be a movement, and I think we will see aggressive movement by the White House to kind of cut back on that backlog and increase legal numbers. But ultimately, it's Congress that controls it, not the president.
Definitely. But America being land of immigrants, I think we are so much excited to know what changes will happen in the immigration front, and I'm sure that's going to be a lot.
Rich guy. All I can tell you is what should happen, not that it will happen. I've been fighting for immigration reform since the last time Congress destroyed our immigration area in 1996. So it's almost 30 years that I've been going to Congress every year, lobbying them, talking to senators. The thing is, most of them know what they have to do. They're afraid of losing an election if they help immigrants. And that's why defeating Trump is so important, because it will allow us to throw that anti-immigration rhetoric out the door, out the trash can, and embolden some Republicans to say, I love immigrants, like George Bush always did. I want to fix this. So that's what will happen.
Thank you. We really need some solutions for so many of these loopholes to be covered and be fixed as soon as possible. But definitely talking about those, I mean, the visa bulletin, the dates changing, I don't know when will that happen. But yes, we have some comments. Let's take up Dheeraj from LinkedIn. He's asking, will there be any effect on H1B holders after the elections?
Not after the election, but if Trump wins after he takes office in January, you will see rapid changes to how immigration works. I would suspect they will immediately republish their rules, which I was one of the lawyers that beat back the rule on prevailing wages. And they will publish right away, probably with immediate effect for the March lottery, the H1Bs based on job income, so that people with the highest salaries will get H1Bs. I think that will be an immediate thing in February and March of 2025 if Trump wins. If Harris wins, you won't see any changes. No.
Thank you, Dheeraj, for your question, and thank you, Charles. It's been lovely having you. I wish we didn't have to wrap up so early, but I think this is it. And thank you so much for joining us today. But before we leave today's discussion, if you could leave all of us, especially our viewers, with an end note, it would be great.
All I can tell you is this: America is a great country. It's a great place to live. It is an land of opportunity for immigrants. One of the things I've dedicated my career to doing is helping immigrants achieve that American dream. Not everybody can come legally. Not everybody has that opportunity. Not everybody's got a degree. Not everybody's got a relative here. Some people come seeking refuge, and that's okay too. America's got room. We have room to grow. We have room to be. The only thing we have to worry about in America is if people stop coming here. People stop coming here, we do have massive problems. But until then, until we talk again, good luck. Pray for America tonight. Pray for a Harris win, and we'll move forward.
Thank you. Thank you so much, Charles. It was really lovely having you. I'm really looking forward to having you back as soon as possible for such passionate discussions on immigration. Lovely having you. Have a great day ahead and enjoy your day ahead.
Thank you. Bye-bye.
Bye-bye. Thank you, folks. Thank you so much for joining us here on Immigration and Jobs Talk Show on today's discussion on Election Day. So, who is going to win and what is the next 5 years going to look like on the immigration front for the US? Well, I think we'll just have to stay tuned, and you have to stay tuned on Immigration and Jobs Talk Show because we are coming up with a lot more updates on today, Election Day. Thank you so much for joining us. This is Nipasa Pradhan saying bye for now. Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm really happy to be back again. And I'm Nipasa Pradhan. I'm going to be your host for this session today, and it's going to go on for an hour or so. So, before we go off with the discussion, I got this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, thank you so much for joining us. We are live right now on YouTube, LinkedIn, Facebook, and I'm very happy to tell you that you can also participate in this discussion and you may have some questions. And as you can already see, the topic of discussion for today is H1B compliance in the Trump era. So, are you prepared for increased scrutiny? And we are definitely going to discuss about H1B site visits, especially on this episode. So please feel free to comment whatever questions you have and to help us navigate through this very important discussion. It's none other than Attorney Justin Rivera joining us from Wasden Immigration Litigation. Thank you so much, Justin, to join us. How are you doing today?
Hi, I'm good. I hope everybody else is doing well. Friday, mid to late afternoon, close to the end of the day, so can't
Yes,
complain too much.
for sure, for sure. I was thinking we will not be able to make it today, but I'm so glad you are here. And
Yeah, my son may guest star at some point as a result of having to pick him up early from school, but other than that, we should be good to go.
we would love to have our guest star for today, but for sure, I'm really just glad that he's all right. And
Thank you.
folks out there, thank you so much for joining. We are going to discuss today about H1B compliance in Trump era. So maybe you can just give us a few pointers what folks out there can expect today in this discussion, Justin.
Yeah, so I think this has got to be a pretty unprecedented event where you have a new administration coming in that is not the incumbent administration, but has previously served a term. So I think what we're really going to highlight today on the discussion is what were some of the things that were done previously by the Trump administration the last time that they were in control of the White House. What is it that we likely anticipate to be done moving forward, and how to prepare as an employer or even an H1B beneficiary to deal with what is very likely going to be a more complicated next 4 years for U.S. immigration.
That's what, friends, we are going to be talking about today. A lot to discuss about, and 4 years is a long time. Right now, also, we are going through a lot of changes, and we are worried just about year 2025. So let's dig in and let's see what have we got for our future. And so, Justin, to help us, step into this topic, I got this first question. So, given the Trump's administration's history of increasing wage requirements for H-1B visa holders, what can we expect in terms of wage obligations in the future, and how will this impact employers and H-1B workers?
So I think inevitably you're going to see attempts that are made to alter, how the H1B process functions, just based on how Trump made some those sorts of changes in the previous administration. Obviously, not Trump in particular, but Stephen Miller and those under his umbrella. I think in the past you saw things like the level one wage issue, which was something that came about during the very initial part of the Trump administration, where basically they began just attacking any type of level one wage. Basically saying, level one is reserved for the absolute bare minimum entry level position into the field, and anything that seemed like it was above that in terms of job duties, or job requirements, they would use to knock out those cases. So that right there is already something that I think it wouldn't be shocking to see, be rehashed or altered in a way where they continue to assault the lower wage levels as a way to make all wages go up overall. The other thing is, hey, bud, you got to stop. You got to stop. I told you you can't do that. Sorry. The other way that you're probably going to see changes is I'm sure they will try to introduce some level of new regulation altering how the wage system works for the H1B. They may either try to do that through the lottery, the H1B lottery, by making the H1B lottery weighted in a way by wages, where basically there's somehow a higher level of probability added to a higher waged position, or they may try to redefine the scopes of the wages, basically saying, each leveled wage is actually a higher spectrum than it has been previously. So those are just a couple of ideas of what they could do. Overall, the big thing to say about how immigration law works, stop. The way that it works is this: if you want to create new law, obviously it takes steps. You have to take measures to either pass something, issue an executive order. A lot of times that's hard because it's subject to scrutiny at the court level, right? Eventually it can be challenged and overturned. What it's easier to do, and what I expect you're going to see a lot of done immediately, because it was done during the previous administration when they were in power, is just a tightening of existing rules and regulations. I think right out of the gate, that's probably what you're really going to be looking at, is really curtailing and trying to use what's in place to limit the scope of what does and doesn't qualify. And so I think that's really where you're going to see them coming after pretty much everything that they're able to come after from an H1B standpoint. But yeah, in terms of wages, it would not shock me if they attempted to make some sort of significant change over the course of the next 4 years to impact the program. And obviously, we have to realize, if you're increasing wages, for the entry point into an H1B, the people who are probably going to be hurt the most by it are going to be people who are trying to go into the lottery, people who are trying to get those first H's that are most of the time coming directly out of college. Because the problem, obviously, that begins to become for the employer, how much is too much, where it's just the floor to pay an employee is so high that it's just not worth it to actually employ that person, and instead we'll just find an alternative.
All right. So we can definitely expect a lot of changes and a lot of tightening. And since rules and laws cannot be changed overnight, but we are definitely going to see wherever they can make changes faster, I think we can expect some definite changes for sure. So let's look out for that. And thank you, Justin, for giving us a heads up on that, at least, so that we can prepare ourselves. So now moving on, I have this next question for us, Justin, and this is: how will the Departments of Labor's rules on wage levels for H1B and other foreign labor programs affect the hiring and retention of H1B workers?
Yeah, so I think that's a great question. And I think that obviously it's impacted by what types of changes are going to be made to either the wage scale or, the actual full-on change in the implementation of utilizing H1B wages in a lottery type system, in a quota lottery type system. Like I was saying before, obviously, if the point of increasing wages drastically in the H1B program is to make it restrictive. And that's the underlying goal, would be to have less people that are actually, going out and employing individuals on H1B, because it just becomes cost prohibitive. So obviously, I think it will have a negative impact. But at the same time, it's the way in which these policies are implemented that open the door for the possibility of litigation. I know people will hate hearing this, and I think you're going to hear it a lot over the next 4 years. It's a bit of a wait and see. It's a bit of, how do we look at what it is? Because not to be, I'm saying this because it's just the truth. There's not really a lot of definitive information that's really come out there about Trump's immigration policies as it applies to legal immigrants, right? A lot of the things that have been capturing the attention of the media are in relation typically to people that are undocumented in the U.S. So that's going to be, things like the mass deportation idea, and then the idea of, I believe birthright citizenship has seen a lot of attention recently. Now, the caveat to that is, what is the implication of those issues, as they will subsequently inevitably relate to people that have legally immigrated? So what I mean by that is things like, we had seen in the previous Trump administration an attempt by them to basically say, if we deny you, let's say you're on an H1B and you apply for an extension and you get a denial, we're going to issue an NTA, a notice to appear, because you're unlawfully present. Well, an NTA can be a leader to being placed into deportation proceedings. Coming on the back of this idea of mass deportations, do they then utilize that kind of program or that ideology to subsequently move against people that are on, legal status, who have their extensions denied and are then unlawfully present in the United States? So I think that there's going to be stuff that, in the moment when he says it's impacting, illegal immigration, it's still probably going to have an impact on legal immigration as well. I think the other thing to highlight too would be like the note, like birthright citizenship notion. Whether or not that's an actual thing that can be done is left up to interpretation. But hypothetically, if it were done in the way that he alleges it would be done, The idea would be that in order to qualify for birthright citizenship, you would either need to be a one of your parents would need to be a U.S. citizen or a legal permanent resident. So that would subsequently mean that anyone that was in the United States on a non-immigrant visa who has not had the opportunity to adjust status to a green card that has a child in the United States, that child would not be a U.S. citizen by virtue of just being in the United States. Would be born and would not be, which is it's a crazy thing to even think about, because I don't even know how the long range implications of that work. Do you get a grace period to file for a visa? How exactly does that even make sense? But anyway, all of that is to say that it will have all of these changes that are being implemented are going to impact in a certain way people that have entered the country legally. And I know I kind of got off topic on that question, so I apologize. But I did want to make sure it was brought up in the discussion.
No, that was great, actually. Thank you so much for your insights and for your perspective, for sharing that with us. Thank you, Justin. Well, to move on, I wanted to quickly say hello to our viewers who are already participating. So, Christopher, we have Supriya with their questions. So, I think we will take up your questions, but just stay with us for now. I have a few more questions on my end, Justin. So, this next question is with regard to third-party placements. So, what changes can we anticipate in the eligibility criteria for H1B visas, particularly regarding the definition of specialty occupation and the requirements for third-party placements?
Right. So, during the Trump administration, they already attempted to make alterations for third-party placements, right? There was the entire issues with the, memorandum regarding third-party placement requiring, specific work examples. You would need to show work orders. You would need to show the full 3 years that there was specialty occupation work available. A litany of issues that were highlighted and eventually struck down by litigation. So that obviously fantastic that the end result was the removal of those things. However, knowing that third-party placement existed as an issue during the last period in which this administration was in a position of power, it stands to reason that it will be something that they again look at to try to place some sort of barrier that makes the process more difficult. Currently, they are still bound by the requirements that came out of the IT-Serve versus CISNA litigation, which is, their prism is supposed to be specialty occupation. They're only supposed to be looking at, does the position qualify and does the person qualify for the position? So unless they're able to introduce new policies that allow them to specifically attack third-party placement, they shouldn't really be capable of doing anything other than what they're doing presently until those new policies are released. Are those new policies possibly rehashing, under a different argument, the need to provide documents for third-party placement or the need to show work available for a full period of time? Maybe. Or they may try to attack it in a different manner. That all being said, with what they can look at with specialty occupation and beneficiary qualifications, I think it's worth thinking about what I said earlier. The idea that they are going to tighten the existence of existing regulations. They are going to make it harder to qualify for specialty occupation. They're going to make it harder to qualify for beneficiary qualifications. How do they do that? So for specialty occupation, there's a couple of different ways in which you can qualify. There's 4 different ways, to be specific. And in order to do that, you provide, evidence at that's supposed to meet a standard that subsequently allows the service center to approve the case. What we saw kind of during the Trump administration previously was basically invalidating the legitimacy of evidence by pushing something to an impossible standard. So what do I mean by that? One of the ways you could show specialty occupation is to say, hey, look, I have 15 software developers in my company, and all of my software developers need a bachelor's degree in order to do the position, okay? So I'm going to produce evidence to show you that. Well, back during the previous Trump administration, when you present that kind of argument, they would basically attack anything they could to invalidate it. Things like, well, that specialty occupation software developer actually does X and this one does Y. So those aren't similar positions, or this guy is actually paid at a level 4 wage and the guy you're talking about is paid at a level 2. That's not really the same position, or things like that, to basically push it to where it was very difficult, if not impossible, to meet the standard unless you really were able to stick to some really solid evidence. I wouldn't be shocked if there was a real uptick in the need for expert opinion letters pushing back against RFEs for specialty occupation, just because they're one of the strongest items of evidence that you can provide. So I wouldn't be shocked to see that. I think what you're going to also see is the kind of evidence that that you get away with now. Things like maybe articles, insight, professional insight, that kind of stuff is going to be lessened. They're just going to find ways to say that that's not legitimate and that's not something that actually shows the position qualifies. So I think that'll be a problem. From the beneficiary qualifications standpoint, it's going to be much harder to really say what qualifies someone for a specific specialty. And what I mean by that is this. I can remember before, during the Trump administration, that there was a litany of denials for people who had previously been having no problems getting approved with like an electrical engineering degree. Just something that was, somewhat related to the position, but the Trump administration was coming back and saying, absolutely not. If you're doing computer systems analyst work, you need a degree in computer science or IT. And that's basically it. So just the idea that you're really going to see that tightened probably even further than it has been now is something to be aware of. And so that does kind of get back to the idea of, do you just start getting those combo evals at the outset, those education plus experience evaluations, to then fit the person into the bucket that you want to put them in terms of, this is the specific type of education and experience they have that gives them this degree type. It's a lot of times, I think now we'll wait for the RFE. We'll see what the RFE is. I don't know if you want to wait for the RFE now, because if they catch you on one issue, they're probably going to do what the third thing is I was going to talk about with the Trump administration was the boilerplate litany RFEs, where they're just going to start hitting people with specialty occupation and beneficiary qualifications on every RFE. And it's just, the whole purpose of it is to delay the process, open the door for there to be more problems that could arise with the case based on what kind of evidence is provided. So I think people are going to have to adapt as a result. And we'll see, do they try and come out with a new definition of specialty occupation? We'll see. I think that would be difficult to do. I think they've had success in curtailing the definition as it is under the current rules. And I think what they're going to do is just continue to do that. I mean, if I remember right, I saw recently in an article, I believe the RFE rate generally for H1Bs under the Trump administration rose something close to 20-something percent. I think it was 24, 25%. So if that's what we saw in the last administration, it makes sense that that's probably what we're going to return to, if not seeing higher levels.
Absolutely. And I think we also saw a lot of problems with extensions when they wanted to extend their visas. They were also facing a lot of problems. So we might as well expect that to happen even in Trump 2.0.
Yeah.
Right. Thank you so much, Justin, for explaining that in detail. Now, I think
Sorry for the noise if he's walking around in the background.
No, please do not bother. It's all right. In fact, if you want to take a break, we can have a quick break.
Yeah, if you wouldn't mind giving me like 2 minutes, that'd be awesome.
All right. So, folks out there, just hang around. We are going to discuss further on H1B compliance in the Trump era. So, don't go anywhere. Stay tuned to Immigration and Jobs Talk Show. We'll just be back after a short break. Welcome back after the short break on Immigration and Jobs Talk Show. This is Nipasa Pradhan, and we have with us our guest for today, Attorney Justin Rivera from Wasden Immigration Litigation, and we are discussing on H1B compliance in the Trump era. Are you prepared for increased scrutiny? And if you're not, if you have any questions, please feel free to comment them because we are definitely going to keep some time to take them up for you. Justin, thank you so much for being a part of this. It's been a great conversation so far. And we are talking about, we want to also know more about the scrutiny if we can expect on H1B site visits. Do you want to talk about that too?
Yeah, absolutely. I think it's something that's going to be it's going to be problematic moving forward. I think that really right now there's probably going to be a familiar issue for people who are particularly handling third-party placement. I believe they're typically called, IT consulting companies, things like that. Right now, I think if you're an IT consulting company, you're probably seeing some level of site visits. Maybe it's not that bad. Maybe you're getting a couple a year, something along that line. I think that it's reasonable to anticipate that during the Trump administration, there's going to be a significant ramp up. Probably going to be done under the allegations of fraud, that there'll probably be some sort of idea put forward that, oh, there's fraud taking place in the visa system and we need to catch the fraud. They'll probably throw money into it to hire more officers, more FDNS site visit officers in order to carry out these site visits. And as a result, I just think you're going to see a significant uptick. The thing about site visits, which we've talked about before, is a lot of times a site visit is used as a fishing expedition. It's an opportunity to come in and gain as much information about H1B employees within a company as possible. So it's always common to see these broad-ranging questions asked. Things like, how many H1B employees do you have? Can you give me a list of all of their names, all of their work locations, all of their wages? What that really does for them is it just gives them an opportunity to then start looking through more and more information with the hopes, and I really want to reiterate, the hopes are that they find information to get cases revoked. That's what the FDNS officers are doing. They're not there to be your friend, and they're not there because they're just verifying information. Their intent and purpose is to catch fraud. And the more fraud they can allege, the better it looks for them as an agency. So if we were looking at a level of scrutiny that, let's say, was mild to medium during the Biden administration, I would expect a significant uptick. The reason for that is, it's pretty simple and straightforward. This administration wanted to restrict legal immigration during their last tenure. I see no reason to think that they're not going to be trying to do the exact same thing. One of the best ways that they can do that is by going to people's places of employment, doing site visits, and then trying to revoke H1Bs with a finding of fraud. If you revoke an H1B with a finding of fraud, that employee is inadmissible from the U.S. and set up with a permanent ban. It's a great way, if you're trying to restrict immigration, while still remaining within the confines of the law. So I think that what we're going to have to do and what we're going to have to look at moving forward is an understanding that you need to have your employer and the H-1B employees set up in a way where they're able to succeed in the event of a site visit. Because you're not going to know typically when the site visit is occurring, and you're not going to, most of the time, be prepared. And I think that era needs to go by the wayside, because in addition to issues with DOL violations for improper wages or placement or things like that, as the employee, the beneficiary, the holder of the H-1B, you're at risk if something happens. If something goes wrong where your case gets denied with a finding of fraud, you're in a bad situation. And the fact of the matter is the employer can typically walk away from it with not much of a penalty to them. Maybe they lose the employee, which sucks, but that's really all that's happening for them. So unless there's really a repeated pattern of them doing these things, it's really not as big a deal for them as it is for the employee. That being said, for the employer, as I told someone who I had a conversation with earlier today, when you get popped with an issue of fraud on an H-1B, you're basically opening the door for them to basically try and utilize that information across the board for any other H-1B employees. You know, what does this do to your other employees' extensions isn't as big a deal as what does this do when you go to the consulate. Because the problem you're going to also face as a result of this is at the consulate, I cannot see why they wouldn't start to issue even more 221Gs than they're issuing presently. And so, yeah, really when it comes to site visits, you're going to have to be absolutely on top of your game with the information. I think it would be ludicrous at this point to not have legal representation when you're dealing with FD&S, because I just think it's too difficult to combat what the officers are trying to do unless you have someone there telling you what you actually do and don't need to require to answer. Because they're not playing that game. They're going to, like I said, they're going to try and get as much out of you as you are willing to give them, and they will use every piece of information that they have against you when they can. And so, yeah, I mean, it's really incumbent on the employers and as well as the employees to really process what is happening, what is going to happen, and get ahead of that process by making sure you're prepared. And the last little thing I do want to say about this, because I've unfortunately worked on cases as a result of this very thing happening, you can have a site visit to your home. If your home address is a work location, like it is for a lot of us nowadays,
Right.
you can expect an officer to show up to your house.
Mhm.
That's something that people need to be prepared for, because I have seen horror stories where people have been working from home and, like myself, have their kid in the background and they're trying
Yes.
to answer an officer's question and they misspeak and say something wrong. And that officer, most of the time, isn't going to say, "Oh, hey, sorry, I think you said something wrong. What's going on?" They're going to say,
It's going to
"Okay,
use it against you.
report the information," and
Right.
then they're going to forward their report with a finding of fraud and a request that your H-1B be revoked.
I can only imagine. And it's happened. You said horror
Yeah.
stories, and it's not just one story. There's so many stories. So many people have been revoked because of this situation. And I think confidence also plays a very important role in this, the way you answer to these officers, or how timid you get, or how unable or nervous you become when these officers suddenly surprise you with their visits. Unexpected, right? And
Right.
it's so scary that they note down all these, and they take your weakness and they just play it against you for their benefit.
Yeah.
Crazy. But thank you so much. Yeah.
Thank you. No, I just, yeah, it's a tough situation to deal with when you're in it, especially if you haven't been, properly trained on what you're supposed to do and what you do have to say and what you don't have to say. And, the big thing too about legal representation is you can really just close the door on any line of inquiry right at the outset and explain that any level of correspondence has to go through your representative. And that's
Right.
when it comes into play that
Okay.
having that attorney representation removes you from having to make any of these difficult decisions in a moment where you're going to be stressed out. What it also does is it
Mm.
places you in a situation where you're eventually dealing with correspondence through email, which is great because then there's a record to show exactly what you've said, or you're doing it on the phone with your attorney present. And so in that circumstance, you're in a much better situation than you are if you're just handling the process by yourself.
There you go, friends. And it's always best to have your attorney with yourself who would answer most of your questions for you. Thank you so much, Justin. Much needed. I think folks out there they have questions regarding this because, like you said, it's happening nowadays.
Mhm.
So let's move on now. I have this next question. How will My next question for you is what are the implications of the Trump administration's rules limiting H1B approvals to 1 year for work at customer locations? And how will this affect IT services companies and other affected industries?
So for now, they're not really able to get away with doing that. What they had been doing in the past under the Trump administration is using those third-party placement memos. What they had done is they basically curtailed approval notices to the duration of a work order. So a lot of work orders They're typically going to be going till maybe the end of the year or maybe even the end of the fiscal year because they renew. And because they renew, even when we were responding to requests for evidence, we would be highlighting, just because this is the end date listed on the work order doesn't mean the project ends. It's subject to renewal. USCIS was ignoring that essentially and just saying, nope, you've only got that end date on there. So that's the validity period that you get for an approval. That has been invalidated by litigation. So it's not something that they're currently capable of doing. In fact, they actually cannot shorten a validity period anymore without giving an answer or a justification. Basically, because it's a partial denial, it has to be explained. So can they bring that back, I suppose, is kind of the issue to think about. And I don't know how they would do it, because I think they would have to get around the litigation that's already there saying that you can't. Because really how that issue came about was, like I said earlier, there's 4 ways that you can show a position's a specialty occupation. What they were doing was focusing on the 4th way, which is like the duties and the nature of the work is so specialized or complex that it requires a bachelor's in specific specialty. What they were doing was basically saying, oh, we have to know what these duties are. Otherwise, we can't tell if the position qualifies for specialty occupation. So we have to look at the work being done. And somehow they used that to justify that they needed the work orders. They did it with the employer-employee relationship in there as well. But it's all under this guise of specialty occupation because that's all they're really allowed to look at. So because that's been invalidated, I think that for now, I don't know how they would reasonably be able to do that, how they would be able to come back and shorten that. Again, I know, like I said earlier, you're going to hate hearing this, but it is a bit of a wait and see. We have to kind of see how they plan to implement that, if it's something that they want to implement, instead of being proactive in that regard. Like I kind of was saying earlier, though, just because they're not going to be able to attack the H1B that way doesn't mean that they're not going to try to come up with new creative ways that exist within the confines of the current construction of the law to make the process more difficult. Maybe trying to attack wage levels again, maybe trying to find ways to increase the wages in the H1B. Again, really trying to tighten down on what a specialty occupation is. So I would say expect to see, all of that. But this may be something that they're not able to touch unless they're able to figure out a different way to do it.
Okay. Thank you so much, Justin, for the detailed explanation. And at this moment, Justin will take up this question from our viewer. This is on YouTube from Sandeep. Sandeep, Sandeep is asking, is there any chance of green card backlog reducing by passing some law? I have a priority date of 2016. Any chance of getting current in the next 4 years?
I don't want to hurt anybody's feelings, but I've definitely seen this idea floating around on social media that the Biden administration's inactivity, and their lack of desire to make substantial, meaningful changes to legal immigration merited them, going a different way in administration. What I mean is, the immigrants thinking, well, they're not doing anything, so maybe if we get Trump in there, he'll do something. I would be shocked and awed if the Trump administration took any act or did anything whatsoever with the end goal being of benefiting legal immigration in this country. I would love to be wrong. It would be amazing to me. But the fact of the matter is, the people who are in charge of the immigration policies that he's going to be, he's going to be putting forth, the people who are in charge of those policies, they want immigration restriction. They do not want immigration restriction purely within the ideology of illegal immigration. It is a totalitarian belief that immigration should be curtailed as much as possible. So why, if that is their goal, would they pass any meaningful legislation to benefit people that are waiting for a green card? I just don't know why they would do that. Again, I would love to be wrong. It would be awesome if I was wrong. It would be really great if Trump, for whatever reason, woke up and said, this is messed up. I have control of pretty much the entire government, the entire federal government, because my party is in charge of basically everything, and I'm going to help these people out. That would be
It'd be
fantastic.
great. I know.
Could he do it? Yeah, I think he probably could. Is the other side of the coin. And that's where you start getting into what is the political benefit to him of taking that kind of action? And what is the rhetoric, the MAGA rhetoric he wraps that in to sell that to his own supporters? Because I'll already tell you just off the top of my head the way something like that would work. He would maybe introduce something that would work to curtail the backlog under the guise that the people who immigrated legally into the United States don't deserve to wait forever for a green card because it's not fair. Okay, that's a nice sentiment, in terms of this is unfair and we want to make it fair. His base will in turn very likely come back and say, why are you helping them? Why aren't you helping us? You're supposed to help us. Why are you helping them? What about my problems? Why does my groceries cost so much? Why is gas so high? Why is it so hard for me to get a job? So you do have to think about, you really have to think about why would he want to do this? What would he do? Why would this really help him in any capacity? And then looking backwards from that, look at the people around him, the Stephen Millers of the world, the Heritage Foundation, the people who really do immigration policies, and think about what they want and how he would be able to somehow spin this idea to them. So that being said, I would love to be wrong, and please, if I'm wrong, you can rub it in my face. Find me on LinkedIn and tell me I was wrong. I will tell everybody, each one of you, I will say, you are so right. I was wrong. I apologize. Congratulations on getting your green card. I would love for that to happen for you guys. I think it's an
Sure,
unrealistic.
Justin. For sure. But thank you so much. I think never better the way you explained it. And Sandeep, there you go. You have the harsh truth, but that is what it is. Thank you for your question. Thank you for participating, Sandeep. And now we have Jagadish on LinkedIn. I think we should take that up. Yes. Asking, is there a possibility to start the domestic visa renewal again?
So this again goes back to what do you think the Trump administration is going to do? And I think their underlying goal is going to be make immigration as difficult as possible while operating within the legal parameters of the law. That being said, I believe that the domestic visa renewal program was a pilot program that was being tested out where people were able to renew their visas here in the United States rather than having to travel abroad to do that. So obviously renewing your visa in the US was easier than traveling abroad. So no, I don't think it's going to come back. I can't say it any more plainly than that. I think that you're going to have to go out of the country to renew your visa. You're going to see more scrutiny at the consulate, and you're going to see more scrutiny at CBP because it's good. You're going to have multiple opportunities where they can check when you're entering and applying for a visa to see if there's a reason to deny you.
Mm-hmm. Thank you, Justin. Thank you for taking that up for Jagdish. And I think we can take up Christopher's question now. This is with regard to RFPs. Yes. The Trump administration's stricter H1B policies, what specific documentation and evidence should employers gather to demonstrate the specialty occupation's complexity and the beneficiaries' qualifications?
Yeah, so this is kind of where it gets back to what I was talking about earlier with, I think that evals, position evaluations that are from, accredited professors at accredited universities or whatever. I think those are going to become big again, because those were really one of the strongest levels of evidence you could have. I think you're going to have to really, you're going to have to get real specific into the weeds about the job duties being performed for the offered position. They're probably going to want to see things like percentages, which is a ridiculous notion. I've always found it hilarious that, we're supposed to provide specific percentages for job duties as if I know how much of my day is spent checking an email or drafting a motion or reviewing a petition. But that's another thing that it wouldn't shock me if it comes back, because, you know, what they were doing before was if you weren't providing percentages or, you know, 15 to 20 job duties, the argument became, oh, we're not able to tell if this position qualifies because we just can't really tell what this person's doing. And I had even seen that moved into the vein of, you know, a professor does a position evaluation and they say, yeah, but the professor relied on these job duties and I don't know what he's doing in these job duties. So how did the professor? So, I mean, you're going to have to get really, really specific about what exactly the person's doing and how they're doing it. Again, you're probably going to need evals. The ONET and the OOH are basically gospel for USCIS. If you don't know what the ONET and OOH are, those are databases online that has employer information. The percentages related to the degrees, you know, people that have degrees for that position, that's going to come back probably in a big way for them to say, oh, you know, you're a market analyst. The ONET says only 30% of market analysts have a degree. So how do you qualify? So I think you're going to have to really start looking at what specialty occupation category are you in and how do you fit into that category? Because the other thing that they're going to push on now is pushing people out of the categories that have those higher rates. You know, so let's say maybe a software developer is an 87% bachelor's degree on the ONET or OOH information. The other thing they're going to attack is this isn't a software developer. They're going to make this broad claim that this is actually position Y instead of position X. And so not only is this not a specialty occupation, but your LCA is deficient. So really it's going to be, you know, really having to hone in on the job, making sure it's in the right occupational category and making sure that the duties, you know, are detailed and strict in how they relate to the position itself. For the beneficiary qualifications, I mean, you're going to be looking at them restricting it as much as possible. It would really shock me if unrelated degrees get through without getting an RFE moving forward. And by unrelated, they're really going to press it. You know, they're really going to make sure it's very specific fields in relation to what's being done. That's where you come back with those combo evals, those education plus experience evaluations. You have to be really careful with those because just like they try to attack the job duties for the professor eval, they're going to try to go after those qualification letters as well. So when you're saying I have 5 years of experience at company X, expect them to start trying to come back with things like, oh yeah, we see that you said that, but we don't know what your duties were. So how do we know that this is a legit position, you know? Or, you know, that document wasn't on company letterhead. So how do we know that this is legitimate? You know, I think I've even remember seeing in the past, and I'm not even joking when I say this during the prior administration, I think I remember seeing a case where it was signed and had all the information, but USCIS questioned the credibility because it did not have the signature information under the signature. So it was basically signed, you know, thank you, John Smith. But they were like, where's John Smith's phone number? Where's his email address? And why doesn't it say his job title? So yeah, that's what I would say you could expect. And also, I'm sorry for the vibe being so, you know, down during this. I feel like I'm answering all of these questions really negatively. I'll try to find some.
Okay, let's you know, take a U-turn. Maybe you could tell us what are the positive things we can expect then on this note, Justin.
Wow.
I know that's hard, right?
Yeah, that's a tough question to answer. You've put me in a tough spot. I mean, look, is there a world in which, you know, really because the focus of what Trump had been running on is purely in relation to, the, you know, purported illegal immigration and border issues? Is there a world where that kind of gets the forefront of his attention and the brunt of his attention in the beginning of the administration? I think maybe. I mean, it's maybe possible that happens, but yeah, I don't know. I don't know how to find a real big positive spin on it, just because I was practicing. I started practicing the first year Trump was in office. So all of this stuff was normal to me. And it wasn't until I got out of the administration into the Biden administration that I saw things and realized, oh, wow, actually it was a little bit crazier under the Trump administration, just because the difficulty level was ramped up so high. So I would say, you know, I guess the benefit of it would be this. Now that I think about it, thank you for giving me a moment. The benefit is we've seen the administration before. There is some understanding of what had been done in the past, and I think that it will make it a little bit harder for them to make these changes in the future. A lot of attorneys practicing in immigration already have the experience under Trump's previous administration that we did not have before. We were having to create arguments whole cloth to combat these things that came up because they hadn't existed before. And we were able to find success once we were able to, get to that point where we found those arguments that worked. So I think that's a benefit, is that we are more equipped and prepared, I think, this time than we were before. Of that, you're not going to see as many denials as there was the first time the administration, the Trump thing is, litigation is a tool, and it is an opportunity to, go after the administration when they act in ways that just straight up. So, yeah, I think they've been sued before and they've lost. And they moving forward, we know that. So it is tough when you take on Goliath. It is difficult when you face the government, but you can be successful. And I think that's important to know. It's not a hopeless situation just because it's made more difficult. I think more than ever, the employers that are willing and able to adapt and that are able to understand that standards may be enhanced, understand that difficulty may be higher, and they get ahead of it before it becomes a continuous issue for them, they're going to be in a position to succeed. I think it's the nature of the profession to be reactory and wait until something bad happens to then seek help. I think we have to be proactive. And I think we have to go ahead and start making sure that what we're presenting is stronger than what we're used to, with the understanding that it will inevitably begin facing a higher level of scrutiny.
Thank you so much, Justin. I mean, that was a real good perspective, and thank you for sharing that with us. I think we really needed to hear that.
Yeah.
Yeah. Thank you. So we have Sahil also, Pavan. Thank you for your questions. Stay with us, and I hope we can take them up shortly. But Justin, at this moment, I have another question, and that is, how can employers ensure compliance when H1B workers are placed at customer sites, and what additional legal obligations might they face?
So when you have an employee placed at a third-party location, that location is designated in your labor condition application, which means it is absolutely opened up to the scrutiny of an of a site visit. Site visits at third-party locations, you lose power there, obviously, because as the employer, you're not physically present on site. So a lot of times in that situation, it's going to be kind of incumbent on the employee. The employee might have to be the one in that situation that's more properly trained and ready to respond to the inquiries that occur at that third-party work location. Just generally speaking about some things that really need to be clear-cut when you're placing someone at a third-party work site in relation to the petition is their name. And what I mean by that is this. I know you're like, name, what does it matter? It's a silly thing. In your I-129 petition, there is one place for your name, and then there's a place below for any other names that you have or you may have been known by. If you are somebody who comes to the United States from another country, and because you're, maybe trying to assimilate, or because you've noticed that people have difficulty with your name, you say, just call me Jim. They all know you as Jim. Which means if an FDNS site visit officer shows up and says, hi, I'm looking for Sahil, they may say, I don't know who Sahil is because I don't know a Sahil. I know a Jim, but I don't know a Sahil. Understand that that's literally all they need. They will say, okay, cool, turn around and walk out. Guess what? You're getting a notice of intent to revoke because they're claiming that you weren't working at the work site when they showed up. And when you say, well, I was working at the work site, they're going to come back probably and say, you may have been, but you didn't say in the petition that you were known by any other names. So how were we to know? all we have is the petition and the information in the petition to verify. So when it is a third-party work site, I definitely think it's at least worth, as the employee, maybe just letting them know in some capacity, hey, if somebody shows up and they ask to speak with me, please let me know. Please come get me. If I'm not there, please tell them, hey, I'm out, and give them my email address or something like that. So that way I'm able to, communicate with them. The other thing about it is, when they talk to these third parties, it can create issues with miscommunication. Perhaps the third party who has you assigned there as a contractor doesn't necessarily know how many hours you're working. Maybe it's unclear what your actual job title is to them because they just know you as a consultant. So those are things where, you really want to try to make sure that the information that's presented with you at the third party location, as much as possible, matches up with the information that's in your petition. Sometimes that's genuinely outside of your control. There's some things that you can't control, but it's always important to know that within the bounds of what you can control, you should do everything possible. And so that should be, letting them know about the potential for a site visit, letting them know how to get in touch with you, and letting them know that you want to be notified if and when a site visit occurs.
For sure, for sure. Thank you so much, Justin. And I think it's very important to be on the same page, especially when you have to deal with other parties and, the risk is you and your job. So you might as well try to communicate better, have your friends. I know not everyone is a friend in a world like this, but I think you will still have to try to be together in the same page so that, you are safe, and make sure that you're playing safe. Basically, just that, doing the right thing, and being able to communicate properly is also much needed. That's from what Justin just explained. Thank you so much, Justin.
Hmm?
I think we can. How much? I just want to know how much time do you have? Can you stick around a little longer, or do you want to wrap up as quick?
I could maybe try to give you about 5 more minutes, but my son is being as quiet as he possibly can be, and at some point it's just not going to be tenable anymore. So.
All right. So since we have a lot of questions, and this is a very, very vast topic, and I'm sure folks out there also have so many questions, we can continue this for another episode. But before we go, Justin, if we can wrap this up in a good note, and also give us pointers to keep in mind so that we are able to prepare ourselves for these coming days.
Yeah, so just generally speaking, not to, incite fear, because I'm not trying to, but I think if you have an extension that's pipelined, let's go ahead and get that filed now. Get it done now, sooner rather than later. If you need to go, for visa stamping and you have the opportunity, do it now. Any sort of thing that you have the potential to get done presently before late January to early February, I would get those things done, as expeditiously as possible, because it's always better to deal with what you know versus what you don't. And so
Yes.
I would just say if you have that potential to do those things, do those things. That all being said, I think that, like I kind of was saying earlier, I think that the immigration community is in a much better spot in terms of preparation than we were back in 2016. And so I do think that in order for them to really go after the H1B program and H1B holders, I think they're going to have to be more inventive and creative than they were before. So we are already on notice, basically, of the kinds of things that we were used to seeing, and we're ready. I think we're more ready and more equipped to deal with them than we were before. I mean, really, honestly, like just the notion of even suing on denials, I remember back, before, it almost seemed ludicrous, this idea like, oh, wow, really, we're going to go sue the federal government just on an H1B denial. Like that was something. I don't know if those will become more commonplace as the denials get more outrageous, or if there'll be different avenues that'll be pursued. But that all being said, I just feel like we're in a better spot than we were before. And as a result of that, I am hopeful. And then obviously, with Wasden immigration litigation, you have John ready, to do what he does best. And I am ready to, handle those petitions moving forward and ensure that we have the highest probability of approval possible.
Absolutely. That is what is required, I think. And folks out there, you can always contact Attorney Justin Rivera, have a one on one consultation, maybe consult with him regarding your case. And you can call him on his number. His number is 844-592-7336. You can note it down. And you can email him to get in touch with him also. And the email address is support@wasden.law. And go visit www.wasden.law to get to know more about Wasden immigration litigation. But thank you so much, Justin, for joining us today. It was really insightful. I wish we didn't have to wrap up as quick, but see, we've completed an hour and there's so much more to talk about. So I'm hoping to see you again soon, next week, maybe.
Absolutely. I'll do my best to be available.
Thank you so much. You have a great weekend, and I hope your son is going to be superb very, very soon. I think he already is feeling fidgety.
Fine with me.
All right. Happy
Thanks.
weekend to you and your family.
Say bye.
Bye. So sweet, but thank you so much. I hope you're doing good.
Appreciate it.
There he is.
Bye.
Thank you. Thank you. Bye bye. Well, we've got someone saying you look like Junior Trump, Justin. Banda was saying that. That's just a view. But thank you so much, all you folks out there, for joining us. It was really great having you. And if you still have more questions, I'm really appealing to you to keep commenting because, as you just heard, Justin is going to join us very soon again in the coming week. And we are hoping to cover all your questions and discuss further on H1B site visits. Thank you so much for joining us today. Y'all out there have a great day ahead. And please do not forget to subscribe to Immigration and Jobs Talk Show and hit that bell icon so that whenever we have discussions like these, you are notified. Thank you for joining us. Have a great week.
Welcome to Immigration and Jobs Talk Show. I'm Rivera, your host. And before I move ahead, let me very quickly read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right. Welcome back, everyone, to Immigration and Jobs Talk Show. I'm your host, Rajni Perara, and today we are diving into a topic that's on the minds of countless families worldwide. Studying and settling in the US, what are the myths and realities? I mean, there's no denying the allure of the American dream, especially for students aspiring to study and build a future in the United States. But how much of what we believe is rooted in fact, and how much is simply a myth? To help us separate the truth from misconception, we are joined by a very distinguished guest, Attorney Prashant Ajmera, with years of experience guiding students, families through complex journey of studying and settling in the US. Prashant brings unparalleled insights and practical advice. So stay here because this topic is going to be interesting and the questions are going to be amazing and the conversation is going to be amazing. So now, without any further ado, let me welcome Prashant to Immigration and Jobs Show once again. Prashant, welcome back.
Thank you, Rajni. It's always a pleasure to come back. And very nice. I think the show is moving forward very well. So
Right.
happy to be back.
Thank you so much. Thank you so much for taking our time and coming back and doing the show, Prashant. It's always a pleasure having you. I love your insightful answers, and you actually go deep into the questions, and you try to possibly give a very detailed answer. Is what I like the most about you. So thank you so much for that.
Thank you.
But before I ask you my first question from today's show, Prashant, I would like to know, I would actually try to get a reaction from you, because now, we saw that the Republicans have won and Trump is back to, I mean, he will be back in January. So, I mean, there are mixed emotions all over social media. Some people are happy, and who are not supporting Trump are not happy. How do you react to this?
See, Rajni, as you know, that I've been in practice since last 32 years in this immigration industry.
Mm-hmm.
And even earlier also, when Trump won for the first time, it was a similar reaction was there. So, look, it's a majority of the people has voted for him, and that's why he's the president of the United States.
Right.
But small number of people who are liberals do not like these conservative ideas, the way in which he's talking and so on and so forth, and they say that this country is not worth living. So this exactly the same reactions happened 8 years back as well. How many people left? Yes, migration of people is just become a way of life for every country. There is no perfect country for anybody. So the people, small number of people move from their home country to somewhere else for a better opportunity, better family compositions. You found your love somewhere else, or you found a business opportunity, or you want to do a better tax planning. Better wanted to have a better quality of life. You think that living at the seashore is going to be better. So, so I don't think it's just some reactions, I would say, immediate reactions, but nothing much going to happen. Most of the people are going to stay and continue to stay in the USA. But yes, it does create the jitters and talk on the social medias, and it becomes the talk of the world. Oh, people are leaving America. Why we want to go back? But same reaction were there before.
Right, but Prashant, how do you see how is it going to impact? How is it going to create an impact on India and on Indian immigrants? Is it going to be better, or
See, he
yeah,
cannot do he cannot do anything to the legal immigration. People coming legally, they want immigrants. He didn't say that I don't want an immigrants. What he says is basically, if you read carefully, is he doesn't want the people coming illegally,
right?
and which no country wants it, and
Absolutely.
that's what he wants to stop. That the American border has become like a banana republic. Anybody can enter, and thousands of people are coming, and from the north, from the Canadian border, from the south Mexican borders. So means no country would be interested in taking illegal immigrants. Even in country like India, we have an immigrants problems coming from from the Pakistan, and also from the Bangladesh, the Rohingyas, and Sri Lankan from the south, and Chinese from the north. And we don't want them. But at the same time, as a country, we want the largest number of tourists coming to our country and spend money here.
Right.
So nobody, and even the similar reactions you'll see in Europe as well, that we do not want immigrants coming in an illegal way, in by asking for a political asylum where they have fabricated the document, fabricated the stories. That's what they don't want it. And tell me, who would like to have an illegal immigrants coming in their country, irrespective whether you are a small country, poorest country in the world, or you are a United States? No, and it should not be. My brother is there in America, say for example, I have to wait 20 years to get my green card, right? But I can spend 50,000, 80,000, or $100,000 and illegally, and I cross the border and come to America. How fair it is?
No, absolutely.
That's what he's mad about it, and that's, I think most of the people mad about it is that stand in the line, come through the front door, don't come from the back door.
Right. Absolutely. I mean, if you're legal, then you don't have to worry about anything, right? If you're
Yeah,
doing, if you're entering,
exactly. It's not going to change at all.
Mhm.
See, overall, these developed countries do want immigrants. They want
Mhm.
tourists, and that every country wants it. But when it becomes an illegal, but people get confused between the illegal immigrants and asylum seekers,
Right.
and those ones, and then the students, and then the immigrants and family class and the investor class and EB5. People are getting confused without understanding everything. And most of the time, what happens is that the decisions, or somebody has given an opinion, people read the headlines and then they just go out and start believing or telling people, oh, now it's closed down. All the Americans, Indians are going to be kicked out. No way. It's not going to happen. If you are
I
legal
think
in
they're just
America,
trying to
nobody
create a
can
fear
kill you.
inside people, right? They're just trying to create fear inside people. Otherwise, if you have done it legally, you have all the documents, you don't have anything to worry about. I mean,
Worry about
why?
exactly.
Yeah, why would they kick you out from the country if you have everything
Yeah.
ready?
See, when Trump was there in the first term, it did happen that the scrutiny of the files were very, very strict. And
Hmm.
that's also people don't like it.
Which I think how it should be, right?
Well, that's how it should be,
Exactly.
that you have to scrutinize files. And why they are scrutinize the files? Because too many people are waiting in a line in every category. So they have to reject somebody,
Hmm.
particularly the immigrant visa.
Right.
Because immigrant visa, there is a fixed quota is there. They cannot issue a one more green card than the quota available. This is decided by Congress 32, 35 years back, way
Hmm.
back in 88 or something like that.
Hmm.
So they are bound by that one, and that's many visa they can issue. So if you're going to have, say, 10,000 EB5 visa, and 30,000 people are applying for an EB5, what's going to happen? Obviously, they're going to be very, very strict and reject the files on a small issues. Whereas before 2010, when we were doing EB5, and there were not enough files, they were not rejecting any files. Every file was approved. Every file was approved.
Right.
And
Right.
even they are giving us the chances, the second chance and third chance to provide an RFEs and the documents and everything. But when the number of application increased, you have no chance. You have to make sure that all your documents are there in a one go,
Hmm.
because they can issue only 10,000. That's the reality. So it's an up and down. People just worry for nothing. I mean, I have seen it. It does changes and everything, but if somebody believes that the door is going to close down and they're going to throw away every immigrants from America, I mean, they're out of their mind.
Right, absolutely. And imagine, I mean, they are talking about deporting 11 million people. So, how many illegal immigrants are actually living in the US, right? I mean, it's
That many
scary.
millions.
Mhm.
Say that many millions, because
That
it
many
has
millions.
built up. It has built up. See,
Right.
the first time the America given asylum to these illegal immigrants in 1986, if I'm not mistaken. That's
Hmm.
called LULAC. That if you are on such a particular date in USA, irrespective of your status, we will give you immigration.
Hmm.
Now that 1986, the amnesty never came, but that one amnesty of 1986 has given a hope to the people till date. One day, the government will bring the rules and they will make me illegal. So I will continue to stay in USA in that hope, and people has died living in that hope.
Right. I mean, it's good to have the American dream, but if you are planning to live your life like that, I mean, it's also sad. I don't think so. It's a good thing also, right? You have to have a quality life and a good life. And you
Yeah, sure.
can't, yeah, you can't do it like that. And now coming back to our today's topic, Prashant. So, we are actually supposed to talk about, studying and settling in the US and what are the myths and realities. So, I would like to start by asking you, so if you can please talk about what are some common myths and misconceptions that parents and students have about studying in the USA. And if we talk about the reality in 2024, so what exactly is the reality in? for
Okay.
this year?
So one questions and episode finished.
Oh, okay. That
So okay, let's start with this one. Let's go back to the history of the immigration started in USA, say about after the Second World War in 50s and 60s.
sure.
And at that times, my cousin brother's older one has gone to USA in 65, 67. Within a few months, he got his immigrations and now well settled and very well, doing very well. And now the third generation is in USA, right?
Mm-hmm.
Now that over the period of time, till I would say up to 2000, it was very easy and the green card lines were not there. After the 2000 Y2K and when the technology came, the number of people started coming more and more. But from 1960 to 2000, in that 40 years, what presumption has gone in people's mind is that first presumption is you go to USA, your life is set, your American dream. You're going to be successful, you're going to be well.
Mm-hmm.
That's one myth. The second one is that as soon as he finishes his job, he's going to end up with a good job and immigration is automatic after that. Now, the reality is that getting a job is very difficult. I know the question is already there on the chat, but on the chat. And the second one is that the number of immigrant, green card that the US government or USCIS can issue is same 140,000 per year all over the world and not more than 7% per country. Now, after the IT people started coming more and more into this one, this line is increasing, particularly for China, Vietnam, Philippines, and India, is increasing longer and longer. So now IT guy is waiting there. So that myth is there in their mind that, okay, my son go to America and he's going to end up with the best jobs and his life is set. But that the presumption is of the 60 to 2000s. The reality of 2024 is different.
Right.
For an Indian guy who has gone to USA in 2005, he applied for his green card in 2014. He is getting his green card now.
Wow.
Under the EB2 and EB3 category. And right now, the Indian students, when they are leaving and their parents, they still presume, again, that myth that my uncle went to USA in 1972. He got a green card in 2 years. They think that I'm going to get a green card in 2 years as well. That's the big myth. The reality is different. They realize it after reaching there in 3 months or 6 months. So that people has to come out with this one. The second thing is that they believe that the study abroad is the only way to settle abroad. There are other ways are there, but they don't want to look at it. They don't want to talk about it. Also, for the parents particularly, they are very late in planning. Okay, so then the two things is happening in the world right now when it comes to study. If you look at it before the 2000 or up to even 2010, the people who are coming to USA for studies were only for a master's program, which is a 1 year or 2 years programs. Nowadays, as the economy is doing very well in countries like China, Taiwan, Korea, even in India, the students are going, larger number of students are going under the undergrad programs. But it's a 4 years program. And that expenses has increased. But they want to send their child after 12th or after high school diploma. But no planning is done by the parents. They are too busy. They are thinking at the last minute when they got their mark sheets in their hand. Then it says, okay, now I want to send my son to America. So grade 1 to 12, they were just sleeping. Oh, it's too early, it's too early. So that's the biggest mistake they are making, because if you want, as a parents, I'm telling to the parents that if you want your child to study,
Right.
you have to start thinking as early as possible. and started getting the information about it, what he's going to study, how he's going to study, whether it's going to be science or commerce or an arts, liberal arts, what it is. And then you have to weigh that, okay, is he going to study liberal arts or is going to study commerce or a science or an engineering or a medicine? And what are the prospects? How do we go about it? It's a major decision. Because Rajni, you have to understand that nowadays in a developed country, the students' foreign education has become the highest expenses
Right, absolutely.
of the average family.
Yeah.
And in that case, if this is your highest or biggest expenses of your life as a normal family, middle class family, in any country, I'm not talking about only India, but in any country, and you are not doing any planning, any thinking, any work, and you want your child to study abroad, and you say, once he goes to America, life is set and my American dream is done. That's people are facing the problems.
Right.
And that's what we start getting the questions from the people.
Right.
They are coming in.
Yeah.
So, and then the reality comes to the parents when their child has gone to America. They spend 3-4 months or 6 months, and when child reaches there, then he says, Dad, it is not like what we were thinking and what we were expected. Life is difficult. I have to manage everything myself. My job cannot pay for my tuition fees. You have to send me the money, which used to be the case that it can be financed by you working on a campus or an off campus. So that's the second myth, that people want to finance their educations by studying part-time. In reality, that is not the way the foreign education works. We made it like that. Then, okay, you pay for a 6 months or a 1 year of tuition fees, then you will work part-time, and then you save up and then finance it. If that's how you're planning, your visa is likely to be rejected. Means I have done in a similar manner. But you cannot plan your study that, okay, I'm going to do 1 year of studies and I have enough money for a 1 year, and then I'm going to work there part-time and do it. Because see, you are studying full-time, you are working, and then you have exams and everything coming. It's too much.
Right.
And when you are in a grade 12, when you are being completely pampered by your mother and father, you haven't gone out of your house, and when you have to manage everything by yourselves, most of the kids in America, even in Canada, they feel completely homesick. Completely homesick. They are not in a position to manage anything. It takes us 6 months, 1 year. They manage, but it takes a time. And that's what the people are not preparing, or parents are not doing it. All this information nowadays is available on internet, but the parents are too busy. They don't do enough research on their own. If they are educated, they are good in English, they don't know what to do it. Again, they go on those myths. I have money, I earn money, I send my child to America, American dream is done. No, not in 2024. So you have to get the information. That's number one. Number two, if you can get the information, be ready to pay to a consultant or a good lawyer who can give you a career counseling. Don't go to an agent who is going to give you a free advice. Free advice give you a free things which has no value, and obviously he's not working in your interest or your child's interest. It's a complete waste of time. But people, 95% of the people do that. And then they reach there, they say that, oh, now how do I get my green card? How do I get my green card?
Absolutely.
So that's the realities people has to realize. And when the parents, particularly when you have a 2 child or 3 children, and if you want all your children to study abroad, the financial burden is going to be very high. Are you ready to do that? Are you ready to spend that kind of a money that 3 kids studying in America doing an undergrad? You are talking about almost $1 million.
Right.
For their living expenses and tuition fees and everything. And then you go to this one. So first of all, as a parent has to do a lot of things, research on this one. Also, the additional things what the parent needs to do is their financial planning. That if they are saving the money for the children's educations, are they doing the right kind of a financial planning? Are they saving the money in a foreign currencies? All those issues needs to be looked into, because now as a parents, from particularly from India's and neighboring countries, they are spending a lot of monies in foreign holidays and everything. But are they really saving money in foreign country? No. So the dollar effect is also hurting you. The difference of the tuition fees in the locals and the internationals, most of the parents are not aware of it. They realize it afterward. If we would have known before, we would have done something different, because the tuition fees difference between the international students and the local student is big, particularly in USA and in Canada. It could be difference of 30% up to 40%. In Canada, it could be up to 80% difference. And tuition fees is also increasing. And also, the worst thing the parents can do is taking the education loan without realizing that how you're going to repay those education loan. You borrow the money at almost 8%, 9%, 11%. I don't know what's the interest rate on this. And then they go there, believing that, he is going to get a job, he's going to earn a lot of money, and it will be paid back. I'll give you an example of two Jain associations I know that I consulted them, that they created a fund to finance their Jain students going to study in Canada and in America.
Okay.
With the presumption that these kids will get a wonderful job and they will pay back. That was the only condition, that we are giving you money interest free. Go and study in America or Canada and you pay. But the students were going without any preparations, without any realizing what kind of job they are going to get, how they're going to get their immigrations. So 65 crore rupees this organization lost in 7 years.
My God. Goodness.
Because these students, they were from their own community. They could not pay back because they didn't get the jobs, because they didn't do the homework. They didn't do the preparations. It's a 2023, 2024. And if you don't do your homework, your American dream or Canadian dream is way far away, way far away. And you're going to start hating America and Canada rather than loving it.
Absolutely.
So these are the things for the parents. Then certain things I mentioned, the myths about the students. That first and biggest one is that they are always in a hurry and a peer pressures. My friend is going, I got to go as well. Don't do that.
Right.
You have to do your own assessment. You can't depend on that my friend is going, so I got to go. The second one is, particularly in Asian countries, in India, in Gujarat, in Punjab, they all want to go to America, Canada, these English-speaking countries, but their English language skill is pathetic. Very bad. So that they have to improve on it early enough. That parent has to take care of it. Also, the third thing what students are making mistakes or myths is that as soon as they finish the educations, they're going to get the immigrations. But what they are lacking is that they do not have an experience related to their education. They have not done enough research about the education or the program they're going to study and the job prospects. That if I'm going to study this particular programs, what are my job prospects? And believe me, Rajni, it is all there on the government official website. That if you become a computer engineer, or if you become a software programmer, or if you are a cashier working in a Pizza Hut, what kind of salary you're going to make, what you're going to do it. So the job prospects are there to show them, and it continuously shows. But people don't do this research. It's only when students come to us and when we give them, then they say, oh, we never knew that this kind of thing is available. But it's very systematically published by the government of USA that if you take a particular job or particular study, in what field you can work, what kind of salary you can expect, where you can find a jobs, all those things are there. But that research work is hardly being done by the students. Also, they do not understand the education system, and they go to the agent and say, get me an admission into any education institutes. I want to go to Canada by January intake. I want to be out of, in USA by January intake. That's the way you don't go and study abroad. And then you complain that there are no jobs available. It's very difficult. The government has made very difficult rules. Believe me, the government has not changed the rules at all. Even in Canada and even in India, USA as well. But as the number of more people are coming, people who are not wanted in Americas are coming. So obviously they feel rejected and they say that, okay, there is nothing there. As I mentioned before, the students are depending on that they're going to finance their education by part-time jobs and a loan. It is going to be very, very bad that it's going to affect your education. And the biggest myth is that I go there to America, study, I'm going to get a job, and I'm going to get my green card. There's 1, 2, 3 steps, just like that. And that 7 years of that whole planning in their mental health is vanished in 3 months of their arrival in USA.
Wow.
That study is going to be very hard. Getting a job is very, very difficult. And immigration, if I'm from India, is going to take me 20 years before I get my green card under the EB2 and EB3 categories. And the last part, a couple of points, is with respect to the licensing requirement. That when you are working as, say, for example, civil engineers, if you are working as an electrical engineers where it needs a license, architect, doctors, paramedics, lawyers. Now, in India, our system is different, or in our Asian country system is different. What it is that you finish your graduation and you get your license, right?
Right.
So you can start practicing your profession. Whereas in the Western countries, that's not the case. So if you are a civil engineer, you think that, okay, I go to America, do my master's in civil engineering, say for example, I will get my civil engineering license in New Jersey or in New York State. No. You have to take a licensing exam. And then you become a licensed engineer. Or bar exam if you're a lawyer. USMLE exams in medical fields. NCLEX exams for the nurses. So when your occupation needs a license, and it's a state by state, it is different. In 50 states, it's a different requirement. So now you have reached to an America to do a bachelor's degree in civil engineering. You're not going to get a green card. You're not going to get a license. What are you going to do? Work as a supervisor on construction site. So you have not taken that factor into considerations.
Yeah.
When it comes to the law, because I'm a lawyer and as I'm based in India, I get a lot of inquiries. I want to go and study master's or a bachelor's law in England or in USA. And I says, how are you going to get your immigrations and how are you going to practice? I don't know. They say, I don't know. So I said, why you want to study? I said, by studying a master's degree in law in New York, do you think that your practice is going to excel in India? No way, unless you are a Chandrachud. It's a different brain, or different. That he went to do a master's in USA, did a law, came back, and he knew because his father was also a judge, and he wanted to be in a practice, but he wanted to understand the system, and he came back.
Yeah.
But
that's not lawyers also, right?
Right. Yeah. Exactly. So the legal fields, doctors are going to America without realizing this. And then they get into it. Like I got at least about 5 or 7 families I know across India who has approached me. They send their children to Australia and England to do a bachelor's degree in law. Then they realize it that they cannot get a license there, they cannot get an immigration, 3 years wasted. So the licensing is very important. Also for the students, what is important is the understanding the terminology. The masters, undergraduate, postgraduates, the diploma, everything, even if you pass after the high school, they say diploma. Here,
Yeah.
the diploma meaning in our country is different than what it is there.
Right.
And then this is where the most of the agents, student visa agents are taking an advantage. Post-graduation diploma in. So by Indian standards or by Asian standard, we understand that, okay, I'm after a bachelor's, I'm not doing a master's, but I'm doing a post-graduation diploma. Whereas in America or in Canada, you are studying in a community college after 12th. That is also post-graduation diploma of 2 years or 3 years. So now you have completed a bachelor's in engineering in India, and now you're doing that post-graduation diploma after 12th in America or in Canada. Because they couldn't understand the terminologies, and the agent has taken them for a ride. And also they think that study is the only way to settle abroad. No, there are a number of ways are there, number of things are there that you have to keep it in mind. And as a parents and families, if you want, still these are the wonderful countries to study, live and settle. But you now in 2024, you need a lot of research to be done, a lot of work to be done. And then you have to do the path that how do I go and what do I do it and how do I settle, whether it is for me or not. And I say to all my clients that after listening to me, after paying for me and my consultation, if you decide that I do not want to go to America, I say that is also a good decision, that you made your informed decision. That I do not want to spend 2 crore rupees in doing my bachelor's degree. And I have clients like that. When I explain to them that if you have 2 kids, you're sending them for a bachelor's degree, and it's going to cost you 150,000 each, 300,000 plus living expenses and everything. He says, Mr. Ajmera, is beyond my means. I cannot spend that kind of money. Or I do not wish to spend that kind of money. And they decided that, okay, let me finish bachelor's years and we'll think about master's.
But yeah.
Yeah, go ahead.
So Prashant, actually, I'm getting a lot of questions here.
Okay, so let's go to the questions. I think I've done enough talking, and so let's go to the questions.
Sarvesh, Arvind, no, I love actually listening to you, and you are making such important points. And I would like to take Arvind's question. So Arvind is actually asking about H4EAD and STEM OPT, which I would like to take. But Arvind, please wait for a minute, because I really want to ask this question, because sometimes, Prashant, what happens is, there are parents and there are families who are financially well off, and who they think that if they have money, so they can, it's easy for them to send their children abroad, and it's easy for them to get admitted to a good university and college. But do you think that having enough, good finance or having enough money will help their children to get a green card or to get into a good university, or good research is very, very important?
At what level? Bachelor's, master's, or PhD?
I mean, just to start with.
See, people generally they come and tell me that I ask these questions. The same questions the parent comes and asks me. Okay, what do you just ask me? That how do you help us? But I say, what is your objective? Do you have a big family business here that you want your child to get exposed? You have a lot of money. You want your child to get exposed to the American universities, educations, create your network with your alumni, and so on and so forth. And he's going to come back and join the family. I said, yes. Okay. Well, then probably if your child is good enough, go and take an admission into a good university, try for that one, and he comes back. Do you want your child to settle in America? And which is 80 to 90% of the parents is going to say, yes, that's our plan. Then you need a much more plan, what I just mentioned to them, that what are you going to study? How are you going to study? What, in which university you want to go? You want to go to the Ivy League? You want to go to the A grade? You want to go to the B grade, C grade? Universities are good, but then what occupations you are going to go after it? What is the job prospects for that one? All those things needs to be put it in a line. And that particular professions or an occupations, what you're talking about or thinking about, need to be researched. Like just last Friday, I had a girl and father called me, very wealthy, and father said, my daughter is going to go to Australia to do social worker. So she wants to take it. I says, okay, well, something new. So he says, okay,
why not do that in India? I mean, social work.
yeah. No, but so she wants to get it. So she did some little bit of research that if I take a degree in social work in a bachelor's, then I'll get my immigration very quickly. Says, okay. So that the point was very clear that she wanted to get an immigration and she wants to settle there. She's working in a very premium school right now. So then I said, okay, I understood, but I realized it that she has not done the half of the other research. I said, do you know what the social work is involved? He says, well, we do these research papers and I do these writings in this one. I say, yeah, in 11, 12, what you're doing in your social studies is different. And working as a social work is different. Social worker. And then I had to find out exact definition of social worker in Australia and read out to her that this is the work you should be doing in Australia. So you go for your bachelor's. This is the work you should be doing in Australia if you are ready to do that. And if you do that 2 years of work, you will get your immigration in no time. Okay. But if you say that I'm not going to work, I'm just going to finish the degree, then you're not going to get an immigration. And that's where she was hesitant that she needs to work in old people's home. Now she is coming from very wealthy people, a very wealthy family, taking care of the drugs addict, taking care of the small kids, the autistic children.
Right.
Bringing the government programs in the particular cities or a state, bringing it to the underprivileged people in that country by their standard. And when I started explaining this one, I can see the expression on her face. I said, gosh, I'm not going to do this.
It's better that I'm in India. I'm going to do the social work.
Right. Yeah. So I said, yes, you've done a good research, but this part, the big part of this jigsaw puzzle is missing, that understand that what it is required. And I give an example to her. It's happened to one of my clients that he was a bachelor's in pharmacy, and in a hurry he went to New Zealand and he took a program in this same thing, taking care of the old people, that diploma he took it. So he got it. But he's coming from a not very wealthy family, but well-to-do family. He had a hard time to convince that I have to go and take care of the old people, make a living out of that one, and work on that 3 years in this one, get my provincial license that, and then I'll get my immigration. And it took him 11 years before he can get his immigration.
Wow.
In New Zealand, because he didn't do a research about his job.
Right.
That what are job prospect, what is the job duty, and these are the standard there in the government books, and this is what the immigration officer referred to.
Right.
And it is all now. It used to be when we started the practice. It used to be in the volumes, and we used to buy those volumes every year or whenever the edition is there. But now it is all of them are available online for America, for Canada, Australia, New Zealand, and that's what you have to refer to it when you are talking about the occupations. And then the occupation outlook, that is also published by the government. That's what you have to look at it. Licensing requirement. Whom do you go to? And that's where we got the information and tell our clients. So that's where we advise that, okay, guys, you go this, da, 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 da. So that this planning of your occupation, what you're going to do, what you're asking me, that how do they do it? They have to do it a lot before even they get on thinking about this one. If they don't do it, then they will have a hard time.
Absolutely, absolutely. Okay, so there's one more viewer. Does the lawyer handle? Okay,
Handle
actually,
US immigration.
yes.
Yeah, well, one clarification. I'm an Indian immigration lawyer. I handle the US immigration cases, what are required to be done in India with the Indian consulate. But US immigration, what needs to be done in USA, I do in association with the US immigration lawyer.
Right.
So I'm not a licensed US immigration attorney.
But you do help with.
Yes, absolutely,
Right.
absolutely, we help with.
Okay, so Akshay, in case you want to get in touch with, and in case you want to have more clarity and want to directly get in touch with Prashant, you can give him a call on his number, which is, I would like to display it so that you can also note it down for yourself. The number is an Indian number, so make sure that you add +91 in the beginning. So +91 99 742 53030. I would like to repeat it, 99 742 53030. And you can also email him. His email ID is prashant@ajmeralaw.com. And you can also visit his website, which is www.ajmeralaw.com. So make sure that you visit his website, you send an email, and you can also give him a call. I think this number is also available on WhatsApp, right, Prashant? So
yes, yeah, that's WhatsApp as well.
Right, so you can give him a call on WhatsApp, and maybe you can send him a text on WhatsApp. You can directly get in touch with him. And right, okay. And after Prashant,
should I think Sarvesh has asked, should the international student
before Sarvesh, I actually would like to take Arvind's question, if that's okay, Prashant.
Yeah, okay, go ahead.
Prashant, he wants to. What Arvind says is, what are the impacts on H4 EAD and STEM OPT? My wife is studying masters in H4 EAD and also doing an internship. Should she stay in H4 or switch over to F1? Please advise.
But so what what is his question? I think I need more information on that one, to be honest with you.
No, so what he wants to know is, should she stay in H4 or should she switch over to F1?
Obviously, you stay on H4, right? Because F1, you are spending more money on your student visa fees and everything like that.
So H4 is better.
H4 is better.
Okay. So, but Prashant, now I think with Trump coming back, there were also talks about that he might cut down on H1Bs, and then do you think H4 are also? Yeah. Do you think H4 are also getting affected with that?
Yes. Well, what happened the last time, what he did was that they were not allowed to work. H4 people were not allowed to work. Right. They used to get an open work permit. Then again, it came back. So that's again, it might happen. We'll know. In the new year, we will know. He will come up with a lot of new regulations for sure.
So we should wait until he comes back.
Yeah.
Okay. So thank you so much, Arvind. If you have any more questions, please, you can continue posting. If you have follow-up, please post it in the comments below. For now, let me take Sarvesh's question. Sarvesh has asked something that is related to today's topic. He says, I have heard that accessing healthcare in the US is complicated and expensive for international students. What are the realities of healthcare access, and what insurance option should international students consider?
It's only insurance. And the international students do not get any government benefit. Even like Americans also do not get any government benefits. There is no freebies available. Everybody has to take your own medical insurance. If you are without medical insurance, hospital will not let you in. So when you are an international student, you do need to take, and every university is asking students to take the compulsory insurance. Then it's up to you that how much more you want to take it. But when you are on a campus, they have a nearby hospitals and is there. And generally when the students are sick, international students are sick, that particular insurance take care of their expenses and so on and so forth. So it's not complicated, but it's not free, but it's very expensive.
Right.
So you need to take enough insurance to cover your medical things. And if you have some kind of a medical conditions, my advice would be that take a bigger insurance. Otherwise, I mean, you can go bankrupt in America by paying the medical bills. Like, say for example, give you an example, extreme example. A kidney operation in India costs $10,000. There it's got $300,000.
Wow.
30 times.
Yeah.
So it is very expensive. Medical is very expensive. Plus the complicated, what he might be, Sarvesh might be mentioning was that waiting period. Because generally in the Asian country here in India, when you go to the private hospitals, means our test and the access to the doctor is done in like a few hours. There it can take a longer time because there are not enough doctors are available. They take their own time. They take their own time in checking, verifying, doing the test, and that is taken many a times. It can take sometimes a weeks to get your test done. Whereas here we try to do it in less than 24 hours. So that things could be difficult for the people to do it in a medical system. It comes, but if you have a medical insurance done, then you should not worry about it.
Right. And, there's always a joke going around between Canadians and Americans because Canadians say we at least have, they say your country has so much problems, and then Canada say we at least have a better healthcare system than you. So,
Right? Yeah, exactly.
so yeah. Thank you so much for answering the question, Prashant. So now Kalyan is also here. Let me take Kalyan's question. So he says, I am commerce graduate from India, married with a kid, and in my 40s. I've been considering moving to the USA for a while, but I'm not sure when to start the process. Is it still the right time for me to consider an F1 or H1B visa? What other options do I have?
Bad idea. Too late. Because say taking a consideration that he's the age of 40, if he comes, and I know of two families that they are really having a problem. That F1, that means at the age 40s, are you going to really go back and study? If you are passionate, certainly you can do it, but it's very hard for most of the people to do it. If you are experts in a field where you can get your H1 visas for making money, you can come and you can means basically continue to stay on H1 as long as you can. But green card would be 20 to 25 years down the road. So if you are 40, you already retired. And the second problem would be that your children would be over 21. Right now, he has two kids. Probably they are in the age of 5 to 10 years. But by the time he is ready for green card, the children would be already 21. So they will not be dependent on them. So like, give you an example. It happened to one client came to us. The husband was chartered accountant, wife was a computer programmer. And in the similar age group, because another sister was already in USA, so they moved to USA on a H1 visa. So initially 3-4 years, it was all fine. When children started growing, they realized it that there's no way they're going to get their green card. And still they're waiting on their green card. Nothing has happened. So now they have sent their daughter, because they cannot afford the American international student fees. They send their daughter to Canada, to Vancouver. And now what they are expecting, that the daughter will stay in Canada, get the Canadian immigration, and then she will sponsor the parents.
Oh, okay.
So it's a whole generation gone in American dream.
Wow.
So the only options, if you are wealthy enough, is do the EB5, which can get you an immigration. And the option is that, okay, if you're getting a job on an H1 visa in America and you want to go and well paid 5-7 years, 10 years, go to America, make your money, come back to your home country without longing for a green card, then it's fine. Let's go ahead and do it. But if you are waiting for a green card, then you are there till you retire, and you're not going to get your green card.
Right, right. Okay, so Kalyan, I hope you have got your answer. Thank you so much for your question. Let me take Chandra's question also. Chandra says, many believe that international students can easily secure jobs in the US after graduation. However, I've read about challenges related to work authorization and employer sponsorship. Can you clarify the realities of post-graduation employment for international students?
Okay. So first of all, you have to understand that while you are studying, you can, after 1 year of your study, if your grades are good, if you're regularly going, you can get an on-campus, off-campus authorizations, which we call it an optional practical training. If you are in a science program, then you can get an additional work permit up to 3 years. And that work permit, what you are getting while you are studying, is OPT or optional practical training. It could be in any job, but related to your education. They prefer or it is required that it is related to your educations, and you can do that one. And that one you can go and work for a small companies, and the company doesn't need to sponsor you. But as soon as you finish this education and this work permit is finished, then you are looking for an H1 visa where you need a are going to stop them that's to sponsor you, apply for an H1 lottery. You need to get selected in that one, and then you work for that company, and then again you pray that that company will sponsor for my green card and I'm moving towards my American dream. So basically the point I'm trying to make, Rajni, is the difference that while you are studying and STEM and OPT optional practical training, what you're doing is automatic, and you can go and work for any companies, and the company doesn't need to sponsor you. But once you finish your education and you finish your period for OPT optional practical training, and then you are continue to work in America, then your option is generally the H1 visa or a J1 visa that you can obtain, and that's where you need an employer to sponsor you, and that is always a big challenge. So unless and until while you are on this optional practical training, if you are not master your skill related to your education and you are not a deserving candidate, you will have a hard time to get your H1 visa sponsored or your J1 visa get sponsored.
Okay, okay. Thank you so much for answering the question in such detailed manner, Prashant and Chandra. I hope you have got your answer. Thank you so much for your question. If you have follow-ups, you can continue posting them in the comments below. And I know that it's time to wrap up the show, but but we are definitely going to take your question in next episode that we do with Prashant. But Prashant, we also have one more question actually that we have got in one of our WhatsApp groups. And this is actually from a viewer. I would like to read the name. It's actually from the viewer named Gopinath. So Gopinath has posted this one in one of our WhatsApp group. He says, "Hi all, I'm planning to apply for H1B to H4 visa conversion. Any idea which location I-539 application needs to be sent? Anyone have any idea on this? My spouse already has H1B status and I'm applying for this change of status separately."
I have no idea of this particular office address of back of my head. I have no idea.
Okay, okay. So we'll try to get an answer from maybe one of our attorney, maybe who knows about this.
Right. Yeah, those who are in USA, those who are doing on a regular basis, they might be in a position to answer. Means if he wants an answers, I can find out on doing this one where he can switch over and reply. But I have no idea about this one top of my head.
Okay, no problem, Gopinath, but we will try to give an answer to your question. Maybe we are going to reply in that WhatsApp group where you have posted this question. We will try to get an answer from one of our attorneys who has an idea about this. So Akshay, what Akshay says, Prashant, is I'm planning to do a DO PhD in, I think he means doctorate PhD in USA.
No, no, do PhD. Planning to
Oh,
do
I'm planning.
PhD in USA.
Oh, okay. I'm planning to do a PhD in the USA.
In
Okay.
USA.
Yeah.
Okay, very good questions. Okay, it will take me a good time to explain. See, again, when it comes to a PhD, it requires a lot of research. Here, particularly in Asian country, in India, when we finish masters, we just go to the university, write some thesis for 3 years, study it, and you get your PhD, particularly in chemistries and physics and the management subjects and so on and so forth. Whereas in PhD, when you're trying to do an USA, not necessarily it is going to be an USA. Because first of all, when you want to do a PhD in the USA, that means you are already a bachelor's and you have already finished your master's in your home country. If you have already done that one, that means you have narrowed down your subject to that the area in which you are want to do a research or trying to do a research on that. And it is very important that depending on the area in which you want to do a research, that you find out a right kind of an university where the professors and the research facilities is geared towards that your area of research or PhD. I'll give you an example. Like one client came to me. This has really happened. With several of my clients, it happens that he wanted to not PhD but masters, and in a particular, but he was already like a research material, I would say, student, very brilliant students in chemical engineering. And he came to me that I want to go to Austin, Texas, this particular universities, because I've done my research and they do this inorganic chemistries. What I want to do it, they are teaching that, so that's how I want to go it. But when I did a consultation with him, when I sat down with him and understand, then I advised him the way in which to find the right university where what he really wants to do a research is being done by that professors in that university. Don't go by the title name, but you have to go deep into the subject. And believe me, these particular students ended up getting a university in Birmingham in England.
Mm-hmm.
And he finished his bachelor's there, a master's there. He became the youngest engineer. I think I mentioned last time about this one as well. And now he's doing extremely well. And he has nothing to do with America. He says that I went to the right university, that there are only 3 universities in the world is doing the research what he's doing it. One was in Europe, another one was in there in Birmingham, and the third one was in USA. But at that time, we could not find that university, or he could not find that university, that this is where work is to be done. So when you want to do a PhD, and if you are serious about PhD, it is very important that you identify the universities, then you ask the questions, get a hold of the professors, ask the questions that what research they are doing it and what you are doing it. If you are not clear about your PhD work, what you are going to do it, narrow it down. That this is the 1 or 2 or 3 areas I want to do it. I've just advised one student that he has done a bachelor's degree in astrophysics. Now he's going for a master's because he knows that in astrophysics after bachelor's, I need to do a master's. And he is going for Canada. So he identified the 3 areas in which he wants to do research. So there are 7 universities in Canada which offering the master's program. But there are only 3 universities offers the research what he wants to do at the master's level. So he's going to those 3 universities. And that's the kind of a work you need to do it. But if you cannot do it by yourself, you need to take in help of the professionals and narrow it down and then say that, okay, then your acceptance would be possible. Once you get accepted, they will also appreciate that, okay, you are coming to our university because the research what we are doing in our universities, you are there interested in that one, you will be research assistant. Eventually, you will become a research fellow. You will be doctorate from our university, because see, the research work are going on in universities in a one particular one subject, in chemistry or physics or even biologies. So many varieties are there, right? So you have to narrow it down just like a needle, that this is the research I want to do it, and let's try to find out the universities. So you need to do that one, and then only it will work. It cannot be USA. If you want to do a research in a molecular science, say for example, particularly, and Harvard is going to give you an admission, or you got an admission in Harvard, but they are not doing that research in that field, what are you going to do? Tell me.
Right. Absolutely. Thank you so much again for such a lovely answer, insightful answer, Prashant
Thank
and
you, Rajneesh.
Akshay. I hope you have got the answer. In case you want to directly get in touch with Prashant, because by now you must be knowing that he knows everything about it. So it's better that you directly get in touch with him and reach out to him. And here are his details. You can give him a call. This is his India number, so make sure that you add +91. His India number 99742533030. I would like to repeat it, 99742533030. You can also send him an email. His email is prashant@ajmeralaw.com, and you can also visit his website, which is www.ajmeralaw.com. Thank you so much, not just to Akshay, but to all the people who commented in today's show and asked their questions. Thank you so much, guys, for being here. And thank you so much to you, Prashant. It was a
Thank you.
great, great episode. I know there's so much to cover. I mean, I think we were only able to do one question, like you said.
Yeah, that's what I told you. That one question, then the episode is done. But yeah, means the other questions are there, and then whenever next week or week after, whenever we can do the other one, we'll cover more questions.
Mhm. Absolutely, absolutely. Can't wait to cover, other questions with you so that people get more clarity and more answers about studying and settling in the US and the myths and realities behind it. But thank you so much again for being here. I know you're in India, and I think right now it must be too late for you. So thank you.
12.
Yeah. So thank you so much. I hope you enjoyed the show today.
I always enjoy, as I said, that this subject I can keep going on for hours and hours. Anyway, thank you guys. Thank you all of you for asking questions. I hope that I've given some useful information to you. Rajni, thank you for having me, and to your team and everybody. You guys are doing wonderful jobs, and whenever you invite me, I'll be more than happy to join.
Yes, we would love to have you back soon. Maybe, depends upon your availability. I'll get in touch with you, and I'll check your
Sure.
availability, and we'll schedule another episode with you. Thank you so much
No
again,
problem.
Prashant.
Thank you.
Thank you so much to you, our lovely audiences. Thank you so much for posting your questions, for watching our episode, for being here. And we are going to have more webinars with Prashant. So make sure that you subscribe and you press the notification bell so that you know that when is the next show going to be with Prashant. So thank you so much for being here. And until I see you again, I'm Rajni Parara signing off for now. You guys take care, and don't forget to subscribe to Immigration and Jobs Talk Show. Bye for now.
Hello and welcome to Migration and Jobs Talk Show. I'm Sam, your host, and before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. All right, once again, welcome back to today's very exciting live show. And today we are diving into one of the most crucial topics for anyone who is navigating the immigration journey. And today our topic is exploited or empowered. What's the truth behind H1B workers and companies? Well, guys, this topic is really exciting for so many people because today, most of the people they don't know whether they are being exploited or whether they are being empowered. And what's the reality behind H1B workers and companies? So, today we are going to uncover this topic with someone who has seen both sides of the story. So, help me in joining us for the very first time on Immigration and Jobs Talk Show is attorney Ira Katz, a highly experienced immigration lawyer for over 15 years and who has also worked extensively with so many H1B cases. So, Ira, welcome to Immigration and Jobs Talk Show, and it's a pleasure having you. How are you?
Hi, thank you very much. I appreciate your having me here.
So, Ira, I would like to know that what's the vibe in the US? Are people celebrating Trump's winning or are they like having mixed feelings?
Well, it's 50-50, just like the country itself. There are there are a lot of people that are in mourning
Oh,
on
God.
one side,
Right.
literally, and a lot of people that are ecstatic over this. It's really who you talk to, and it's just a very wide selection of opinions about him.
It will be. It will be. So, Ira, what can you say? Like by seeing the current situation in US, what can be the future for H1B workers look like in the upcoming years under Trump's administration?
I think immediately, I don't think there's going to be any impact particularly over the next year, possibly 2 years. I think they're going to be distracted with quote unquote illegal immigration and his promise to deport millions of people. I think that's going to be their priority to start with. As far as H1B is concerned, I don't think we're unfortunately going to see a rise in the cap of workers. I think it's going to stay steady where it is right now. What I do see is that they're trying to implement rules so that companies can't cheat. The issues that they've been having with companies using multiple registrations for a single worker really got out of hand over the last couple of years. And they are trying to implement rules that will limit that are very specific to the individual worker themselves. So that hopefully will work so that everyone has an equal chance. Unfortunately, with that, the cap is not going to rise, I don't think. And I think we are just going to end up sort of in stasis for the next year or two. What I do see, however, is that they're going to crack down on the rules in place, meaning they are going to make sure that people have the means to support themselves. They're going to make sure that the labor condition applications are strictly scrutinized, and they're going to make sure that salaries are going to actually be paid, meaning probably more site visits and more audits.
All right. So, Ira, as you mentioned that I think before H1B process it will more focus on the immigration part. So, do you think, Ira, that as Trump says that he's going to deport millions of illegal immigrants out of America? Is this possible logically, practically? Do you think it will happen?
I think there's going to be a lot of bluster about it. I think they'll do a few test cases. They'll show a couple of busloads for the media. There'll be a lot of court challenges to his ability to do it. I'm not sure he's going to be able to do it. There's also going to be the fact that he's going to need funds to do it. He's going to have to go to a Congress, which I don't know whether it's going to be Democrat or Republican. The Senate definitely is Republican. We're not so sure right now about the House. If the House turns Democrat, he doesn't have the funds to do it. I don't know where he would get the funds to do it other than cannibalize other government agencies, which in and of itself, we would end up back in the courts because that would actually be illegal. So, saying something and doing something are two different things.
Right. Maybe it is also for like a kind of a strategy to scare illegal immigrants so that they automatically leave. Because I also heard this news that a few of the illegal immigrants, they are requesting so many immigration attorneys that please do this visa process as soon as possible, so them themselves are leaving the country without taking any action from Trump's side. So this can also
I
be
think,
a reason, right?
yeah, that is true. There's an element of that going on. A lot of people are, he's scared a lot of people. Both DACA recipients, illegal, quote unquote, illegal immigrants, and legal immigrants. I have a lot of clients that are checking their immigrant status right now to make sure they want to make sure that they are 100% covered, that they have no issues. I have companies that are calling me that are asking to make sure that they're compliant, their I-9s are compliant, their visas are compliant. He has there's a collective chill that has gone through the country, basically.
All right. So, guys, we are also live on YouTube, LinkedIn, Facebook, and X as well. So, join us from any of these platforms. And Ira is here with us for an hour. So, please have a good opportunity and ask as many questions as possible from Ira. He's definitely going to answer. So, Ira, coming back to our topic. So, there are people who already are H1B workers or trying to be one. So, and also they are not very much aware about the truth behind the H1B program, whether they are being empowered with the opportunities or they are unknowingly stepping into a situation where they might be exploited. So my question to you is that is the H1B program really attracting the best and brightest talent, or are companies just using it to underpay some skilled workers? What's the balance between talent attraction and exploitation?
That's a really good question, and it's a mixed bag because on the one hand, you have really serious companies who need the talent and do recruit properly and do pay proper wages and don't try to get around labor condition certification and things like that. And you find this mostly in the realm of high-tech areas, artificial intelligence, developers. On the other hand, and also in terms of the medical professions, nursing, skilled medical technicians, areas of that nature. On the other hand, you have third-party recruiters who are being used by unscrupulous companies here in the United States to essentially recruit scores of IT people. And the companies themselves have no interest in the individual workers. They need bodies, okay? And they don't really care how they get the bodies. And they have budgets, and they basically tell the third-party recruiters, okay, this is your budget. We don't care how you get to that goal. And that makes for a lot of sort of problems with how they use the workers, how they treat the workers, and how they pay the workers. And we see this constantly. We have a policy in our office, for example, we will not work, okay, with certain recruiters. I won't mention any names, but they're well known already, okay, and they bring in tens of thousands of cases. And I wish the rest of the bar, frankly, would adopt the same policy because we know they're exploiting the workers, okay. On the other hand, you have excellent companies here in the United States I have a particular company that I've been working with now for, I guess, 12 years. Okay. Constant flow of workers. They recruit them. They recruit excellent talent. The long term, we've even had people. I mean, unfortunately, the wait times in India are ridiculous for green cards. But we're finally seeing the first green cards. They sponsored their workers for green cards. They want them to stay, and they want them to stay long term. So it's really a mixed bag.
Wow. I think that's so much our audiences are getting to know, and I am really happy to know that you actually are uncovering these facts, because people out there, they are just in the American dream. They just want to have this H1B visa anyhow, but they ignore all these facts. So I think it's very important for them also to learn. So guys, please feel free to ask any questions from attorney Ira Katz. And all right, Ira. So as you were talking about the wages. So my next question to you is that H1B workers are also supposed to be paid fair wages that match those of US workers in the same designation. So, but there are also cases where employers pay H1B workers significantly less. So, is the wage structure for H1B workers fair, or are companies taking some advantage of foreign workers to reduce cost? Should there be stricter regulations on salary parity between H1B and US employees?
I think it's more in enforcement rather than, because the levels themselves that are promulgated are actually are good. I mean, I'm in constant touch with people, for example, in high tech industries. Some of the people that do hiring, HR hiring in Silicon Valley, and there is parity. If you're paying your worker what's supposed to be paid based on the Department of Labor, you're getting paid what's being paid, for example, in Silicon Valley for a comparable job in a comparable geographic area. The problem is not that. The problem is that, for example, someone will come to an employer and say, yes, I want the worker, but I don't want to pay the worker for 10 years worth of experience. Let's have his resume reflect 2 years worth of experience. Okay. So this is how they manipulate the system. Okay. So instead of paying, for argument's sake, if the wage was $125,000 on a level 4, okay, they would end up recruiting the worker and paying the worker on a level 1, which would be $75,000. And this is how they exploit the system. So what you really need is more enforcement. We need more audits, and we need Department of Labor to basically scrutinize companies really on a yearly basis to be able to, and fine them. Okay, basically to put the onus of this on the companies. And unfortunately, there's actually a case that's now winding its way through the courts where a third party, a recruiter, was used. Okay, and the worker, who happens to be from India, is going to end up paying the price for it. So there's an appeal going on because they're accusing him of fraud, the worker. Okay, whereas the company itself committed the fraud. Okay,
Right.
the worker had absolutely no idea, was totally innocent in the process. And that's really the burden that has to be shifted. The onus has to be on the companies now, to be honest about everything, to be upfront about everything, and to be checked and audited about everything.
Right. So, Ira, as you were mentioning that the companies, they only, initiate in these fraudulent activities. So, Ira, what can you say that is there some kind of that a company should face penalties for creating such a wage gap, or is this a fair reflection of a competitive market?
No, I think the company should face penalties if they're found to not meet the Department of Labor standards for pay levels and pay equity for different workers, and there's discrimination in payment to H1B workers. They absolutely should face penalties for that because they know better.
Yeah, definitely. All right. Ira, I would also like to add one more question that can an H1B worker lose their job at any time? And if yes, then why?
Yes, unfortunately, they can. Most workers in the United States are at-will workers, and which means that they can be dismissed at any time, except unless it's for an illegal, for something illegal. For example, discrimination based on race, based on gender, based on some sort of handicap or something of that nature. But other than that, workers can be dismissed at any time. And that's really a peril for H1B workers because basically H1B workers have 60 days then to basically find another job or leave the country. And that's a terrible position to be in. You've come here, you've made your life here, you've gotten a job here, and all of a sudden, the company just decides you're disposable, basically. And that is bad, which is why I encourage the workers. It doesn't protect you completely, but to try to have an employment contract, okay, really before you get to the United States. At least in that way, you understand that there's some sort of protection, there's some sort of a warning, there's a possibility of having a payout at the end, or a possibility of having help from HR find you another job, but otherwise you're really subject to the whims of the employer.
All right. Ira, all right. So H1B workers, they need to find out the job within 60 days. So what about those workers? Like if an H1B worker is doing great at their job, then is there also possibility that they can still be forced to leave the US?
Yes, unfortunately, yes. Same thing holds. It's really it's a question of the way the labor market works here, and that's for any worker. It's whether it's a U.S. worker or an H-1B worker. Most workers in the United States are at will, unless you have an employment contract that gives the specific details of your employment.
But I don't know, what can you say that why does this happen? Because if an employer is working well, then why he can get to face these types of situations? I mean, what's the reason behind it?
It's really the way the market is set up here. I mean, we are a capitalist society, and the balance of power, really, structurally between the employers and the employees is on the employer's side. The good thing that right now, because of the way the market is, and the fact that the employment rate is very low, and particularly in sciences and technology, employees have a little advantage in that it's become a little more difficult to recruit employees now. So that if I'm an employer and I've put in the time, the effort, and the money to recruit an H-1B employee, and the employee is a good employee, I'm generally not going to fire someone on a whim,
Yeah.
because it's going to be very difficult to replace right now.
Exactly. And it's not only difficult for the employer, but also for the company as well, because they are also losing a good asset, right? And I think
Yes.
employers, they only make a good company. So I think this is something very unfortunate, and this is something I think people should know, that it's not only about that you are working well, then only you will be, get the permanent residency in US. that is also the other case. You should also learn the other side of the coin, that even if you're working and even if you're doing a great job, then also you can be forced to leave the US.
Yeah, unfortunately, yes. Unfortunately, yes. And one of the big problems here is, from particular countries, and India being one of the countries, the time now that it takes to get a green card is just so long and so prohibitive
Yeah.
in most categories that that's another thing that sort of the employer has over your head, that because of that he can really push you out on a whim if he really wants to. Okay, but again, the market is right now so tight for employment that it really doesn't make sense for the average employer, particularly in high tech and in sciences and technology, to recruit, to bring someone over and to employ someone, to put the time and effort to train. Okay, and then basically just on a whim to fire someone. It's not it's not a usual thing these days.
Yeah, right. So, Ira, as like you mentioned about companies that they are firing. So, I want to know that why do then companies prefer hiring H1B workers over US workers? Because if they are, I mean, if the H1B workers, foreign workers, if they are going to have so many problems and still there is no guarantee to it, then why do they prefer to hire H1B workers? It's better now to just keep on working with the US workers themselves. What are the ethical implications of this decision?
That's a really interesting question. I think there are two sides to that coin. One is you have a couple of things that are going on in the United States labor market. Okay, one is that workers are changing jobs day to day. There is no loyalty, particularly in tech right now.
So, like US
So
workers, they are also not being in the company. That's also not
no,
guaranteed.
no, U.S. workers are spending an average of a year and a half at their jobs, tech workers, until they move on. Okay, and so what they're finding is item one is that the workers, H1B workers, tend to be more loyal to the company.
Yeah.
One, they're kind of in a position where they have to be, okay. But also in general, even where they have the opportunity to change jobs, we find that it's very unusual. Once they're in with the company and they like the company and so on, they tend to be very loyal workers, because there seems to be a very different mindset from other countries around the world,
Yeah.
where something has very much changed in our labor market. Again, particularly in the tech world, there is absolutely no loyalty today by U.S. workers. That's one. The second element of it is, frankly, H1B workers, the work ethic is higher than U.S. workers. They tend to put in longer hours. They tend to work harder. They tend to be. I mean, I get this from a lot of my clients. They're just and that's why they come back and they say, there are jobs that I don't want American workers doing, which is, you sit there and you say, okay. And then the third thing, again, in very specific areas of tech, the training is actually better, we find, from certain countries. In areas, it seems that in math, physics, workers from certain parts of Europe, from India, and from Israel are just better at their jobs than U.S. workers. And this reflects in tech hiring.
Wow, it's so eye-opening. But I mean, I would say that it's really also unfortunate, right? Because employers in US, the H1B workers, they are more loyal, right, than the US workers themselves. So it is something that actually, I would say it's a real reality behind, the H1B workers and the companies. I think, Ira, you are doing great, and I hope that employers and the companies, they are getting to know so much from this episode. So thank you so much, Ira, for your answering all the questions in a very detailed way. So, Ira, I would also like to add one more question that, nowadays most of the companies are relying so much on the remote work. So, my question to you is that with the growing trend of remote work, do you think that the company will rely on H1B workers in the same way as they were, or they will start hiring talent directly from other countries? How might this change the future of the H1B visa program?
I see it already because we see already there is a lot of hiring going on in, for example, the marketing sphere that's starting to take place from the Philippines, and that is really wage based. People are looking for lower wages, and these are hired through third parties, so they don't have to go through Department of Labor standards or anything. So they're being paid by companies in other countries. Okay. And so this is depressing wages worldwide, actually, as a result of that. Now, are American companies going to start doing this? Probably yes, because it's going to infect every sphere. The question is it going to make it into tech, high tech, to the extent that it'll affect the H1B program? Probably. Because we see more American workers, American employers are getting used to the fact that their workers are working remotely right now. So if they're working remotely from other states, I think it's just a matter of time before they'll probably figure out a way to be comfortable with the fact that they have workers working remotely all over the world. So yeah, I think it's coming. I think it will affect the program. But given the fact that for the lottery, you have 85,000 places, a 25,000 gap cap. Given the fact that last year we had, I think it was 240,000 applications for 85,000 places, it's sort of at the margins. So even if it cuts it down by a third, you're still going to have all the applications, and you're still going to have people clamoring for the jobs. And on the other hand, on the employer side, the good companies are not going to want to do this. Okay, you're not going to see this happen from from Apple. You're not going to see this happen from HP. You're not going to see this happen from from Nvidia. The companies like that won't take chances like that because they actually invest in their employees. Okay, so they will not go to a model that will affect the quality of work. Okay, they're clamoring for the cap to be widened. They want more foreign workers. They want better talent. They're constantly screaming that they can't get enough workers. We don't have enough tech workers here in the United States. We just don't.
But Ira, I would like to interrupt one thing that, according to our sources, on August 27, we got to know that there were 15,000 employees who got laid off from Google.
Yeah.
So, yeah, what is your take on that?
I think it's just it's just a shift in emphasis. Google is going through sort of, they're moving to AI, and I think that move to AI just naturally cut jobs as they were building. It's sort of where we lay off from one end, and we put into to the other side. I'll give you an example. For a while, the hottest thing here was trying to recruit full stack developers, okay, in computers, okay, and it was impossible to get full stack developers. I had people calling me and trying to see if I had connections overseas, if I had companies just were losing their minds. And we came to a full stop recently. Okay, no one cared anymore. It's like, no, our emphasis is now shifted. We want to find AI developers. Okay, and that's what you go through. You go through these sort of shifts, and the manifestation of that. I'm sorry for the long-winded answer. Manifestation of that were the huge layoffs at Google. So I think we will kick back and see a lot of different types of jobs and positions coming back, but coming back in a different way. Coming back, for example, now it'll be through AI development.
Wow, that's great. All right, Ira, thank you so much for your answers. And I'm really enjoying this show, and I am really so much in flow. And I think our audience are also. And with that, we have got so many viewers right now. So let me just greet them: Kiran, Vishnu, Monali Thakur, and Indu too. So, hi guys, and hi Mohit also. Please watch our show till the end, and we are definitely going to take your questions. So, Ira, should we take one question from our viewers? What can you say?
Sure, my pleasure.
All right, great. So, let's take up this question from Indu. So, Indu is asking that as few got selected after lottery, there is delay in the process. When can we expect for 2025 H1B process?
That's a good question, and they haven't really promulgated the time schedule yet, so it's really hard to tell. It's going to be dribs and drabs as it usually is, and once you get the selection notice, you're on the selection notice itself. You have the window, and when you have to have the petition filed by. There's not much more I can give you than that.
Mm-hmm. Okay, all right. So I think Indu, you need to wait for some time to get this answer, and I think Ira will some on the other. Maybe in the next show, we are definitely going to take this up. Thank you so much for your participation, and Mohit is also responding. Thank you so much, Mohit, for your response. We are definitely going to take up, and Kiran is here with a question, Ira, that how do the psychological effects of job insecurity and fear of deportation among H1B workers influence their productivity and overall well being? And there's a continuation. What longitudinal studies could be designed to quantify these impacts in comparison to US workers in similar roles?
A really good question.
Right.
Yeah, no, it's a really good question. Somebody had actually started a study at Northwestern University. I don't know if they followed through with it. I know anecdotally, okay, from my clients and from conferences that I've attended. It really does, and speaking also to HR management, it does have a real effect psychologically. When you know, all of a sudden you're getting to your sixth year, and you know, unfortunately you can't get a green card. You know you can't extend anymore. Your life is in the United States. You know you have social relationships in the United States, and you have to scramble to figure out something else, what to do. You know, in many instances, for example, I have two clients right now, okay, who unfortunately finished their 6 years with the H1B. They can't get a green card. We were trying to fit them to get O visas, but they just didn't qualify for O visas. So they went back to school. So they're in OPT right now, advanced training. Okay, they don't want to be back in school, but they want to stay in the United States. So this has it does have a detrimental effect psychologically, and also for the employer. Remember, there is so much time being spent in concentrating on your visa, and that takes away a lot of time from your work, a lot of time concentrating on your work, a lot of time, and you know the employers understand it generally that you have to focus on this, but it doesn't make for a smooth transition, even in leaving the United States. In other words, if the best idea really would be, you know, if you had the ability to extend, number one, the H1B based on need of the employer and the fact that you could prove that you have the center of life in the United States, okay? And I understand they don't want to give you a green card, for anything, but then at least give the worker the chance to be able to resettle. Meaning, okay, we understand your 6 years is up. You have no opportunity to stay in the United States for any one reason. Fine. So you have another year to be able to figure out what you're going to do. But the 60-day window is ridiculous. You can't really, okay, because it's not really a 60-day window, because in year 5 already, okay, or even at the end of year 4, my clients are wondering what they're going to do to extend. So they're taking time away, from work and taking time away from their lives, and this is really bothering them, and it does have a detrimental psychological impact.
I think this is something very important. Not only we should talk legally, but we should also shed our lights on how the psychological impacts it will happen.
Yeah.
And I think this is thank you so much, Kiran, also for taking that up. I mean, it's a very good question, and uh, just keep on posting these questions also, so that not only you, not only us, but also so many people out there should get to know about what's the reality behind H1B workers and companies. So I think we are going great, and lot of topics we have already discussed. So Ira, right now, I think I should. Ask some more questions from the FB groups, because there also we get a few questions from FB. So I think we should take that up.
Sure.
And yeah, so yeah, this is the question, Ira, that I would like to ask. That while filing DS 160 for my parents, should I write who will sponsor as me or my parent? Am I on H1B at US and they will be visiting first time? Also, they are from um, any problem from my side? Ira, can you hear me?
Yeah, I hear you. I'm sorry. I didn't see the question.
Right now, can you see my question?
Not entirely. It's kind of cut off. I'm just
Okay, no worries. Let me share it again. Wait, I think there
okay.
might be some, technical issues. Mm, yeah, just let me know. Is it, I mean, can you see now?
No, I'm sorry, I can't. If you would
Uh,
read it out to me,
yeah,
I'll.
sure, no worries. Let me read it out. So it is that while filing DS 160 for my parents, should I write who will sponsor as me or my parent? I am on H1B at US and they will be visiting first time. Also, they are from Kolkata. Anyways, to get both BAC and consular job in Kolkata. Yeah.
Oh, she's talking about her parents
Yeah.
visiting. So the DS 160 is for her parents on a B visa, I assume. Um,
Mm-hmm. Ira, can you hear us? I think we have lost Ira somewhere. No worries. I think Ira will be back. But all right, guys. So let me first of all let me say hi to all our audience who have joined us right now. Thank you so much, guys, for joining us. And till the time Ira will come back, we are also going to take a short break. So keep on posting as many questions as possible. Let's keep on going this great conversation again. And thank you so much. We'll be right back just within a minute. So keep on watching Immigration and Jobs Talk Show. Hi, guys, and welcome back to Immigration and Jobs Talk Show. But unfortunately, right now we are having some kind of technical issue from Ira's side as he lost some connection. So I don't think that from now, I mean, on today, we are going to continue this show because of some technical issues. Oh, all right, Ira is back. How is
Yeah,
that possible?
I apologize.
No, no,
We,
no. It's so great. I was just saying that to our audience that we are going to connect later on, and suddenly you pop up. How that is that possible? I mean, you lost the connection, right? And there was some big problem as well.
we lost power in my building. I'm actually on my iPhone right now.
Oh my God, that's really grateful to us. By even losing the connection, you're back with the show. All right, Ira, but we know that you are on your phone, so we won't take much time. But definitely, we are going to just add few more questions, and then we are going to have another episode also with our viewers. What say?
Sure, sounds good.
All right. So, Ira, let's back to our questions. As I was talking about that, there were so many people who were, facing these kinds of struggles and hurdles of H1B workers. So, I would like to know that what strategy should they have or option they can explore to stay in the country and secure their future in the US?
That's that's tough. First of all, the one strategy, even though right now, unfortunately, getting a green card is very difficult.
Yeah.
If you win the H-1B lottery and you get an H-1B and you enter the country on an H-1B, um, my advice always is to start the green card process literally from day one once you enter the United States. Now, you'll be, hopefully you'll be approved, but unfortunately, you're going to have to wait and wait and wait and wait. But will that improve? It might. We've had periods of time where unfortunately people have had to wait 10 or 12 years, and then it's accelerated to the priority dates being 1 or 2 years. So it really pays because you really don't know what's going to happen in the future. So that's one strategy. Second strategy is see if you qualify for another visa. Okay, once you're in the country, that you could change status to. So, for example, if you build up your resume in some particular area, is it possible that you could qualify for an OV visa, for an extraordinary ability visa? Are you doing something that may qualify for a national interest waiver, for example? Okay, so I recently just had a client actually who came over on an H-1B visa, um, and we were trying to keep them in the United States somehow. He had not told me that in his past life, basically, he had worked for the United Nations, okay, in a capacity, and that capacity was in terms of low income housing. He had he had actually been on a very important committee. Now, that's an issue in the United States that's extremely important right now. Housing is a terrible problem in the United States. So his experience transferred to the ability to get a national interest waiver in the US. And we successfully applied for him for a green card on that basis.
Right.
So you really, really never know, where you can get. You have to be very creative, but you have to start early. That's the key. Okay,
Right.
with everything, with registering for the lottery. Okay, and you know what? I have clients that register for the lottery every single year for year after year after year after year, and in year 5 or 6, they won. They got it. Okay, so it's being persistent. That's really the key.
All right. So, Ira, what do you think that as Trump is ruling right now in US, so will this impact companies that rely heavily on H1B workers because Trump is always America first, and H1B workers are obviously those are also immigrants. So, what can you say that do they have to face some stricter regulations, or will they find some kind of new opportunities under Trump's administration?
Um, I think I think in and of itself, not much is going to change. I think enforcement's going to change. I think they're going to become stricter as far as enforcement is concerned, and I think that's really the only change we're going to see. And I don't think we're going to see it immediately because I think they're going to be distracted again with quote unquote illegal immigrants for at least for during the first year and probably for the first couple of years of their administration. And remember also, a lot of the money that's behind Donald Trump comes from Silicon Valley, from actors in Silicon Valley. And they don't want to see the H-1B program go away because a lot of their workers come from the H-1B program.
Right. That's a very good point.
Yeah.
Nice. All right. Thank you so much, Ira. And Ira, one more question. This is going to be a last question for today's episode. So, in your view, I would like to know that what should any last message that you would like to share with our, with our applicants who are applying for the H1B or who has already been working as an H1B worker? Any last message that you would like to give them by keeping in mind the Trump's administration?
I, the really the last message is make sure everything is up to date. Make sure your company is complying. Make sure they're filing their I-9s. Um, don't worry about pestering HR, okay, because that's what they're there for, okay? And make sure you're always in compliance, okay? Because as I said, there's a case going on now with a third party worker who was brought in by a recruiter, perfectly innocent, okay?
Right.
And they're being basically charged with fraud, and they had no idea what was going on. This is wending its way now through the district court. And I look at the case and I basically say, should they have known? No, but they would have known had they known what was going on, had they asked questions. Always ask questions, okay? Never feel like you're in a position, okay, where you're threatened based on the fact that you don't want to stir things up or you don't want to be a pain in the neck. Be a pain in the neck. It's your right. Okay. Okay. You want to know the I-9 was filed by your employer. You want to know that your visa's properly in place. You want to plan ahead of time. You want to ask questions of your employer. Okay. Am I staying? Are you going to give me notice? Am I? All of these questions are very, very important.
Great. I think it's not a problem if you can be a pain in the neck, right, Ira?
Absolutely.
That's
Absolutely
how
not a
every
problem.
employer should be. They should have that
Yes.
much courage, to ask questions then on there.
And by the way, the same of your lawyer. Uh,
Mhm.
Whether, no matter who you're using, okay, they have to be responsive to you all the time. All the time. And don't take anybody that tells you it's too complex or it's too this. You want to know exactly what's going on and what your rights are all the time.
Right. All right. So, Ira, thank you so much. And we have almost reached to an hour. And, again, I would like to say that your insights were incredibly valuable. And I think people out there, they will definitely apply your insights. And I think they are very much happy. And we also got so much responses from people, though we couldn't take so much on this episode, but we are surely going to take from next episode. And Ira, thank you so much for your time, for your, even though you lost connection, but still we got you. And that's really, a good spirit, a very happy spirit, I would like to say. So thank you so much, Ira. And thank you so much, everyone who has joined us today. And please contact attorney Ira Katz on the given number in case if you're feeling or navigating any immigration problems, then feel free to contact him on the given number. That is 914-639-6750. I would like to repeat it again, 914-639-6750. And please email him at ira@icatslawoffice.com. I would like to spell it out, IRA at IKATZLAWOFFICES.com. And do visit his website, that is www.icatslawoffices.com. So I think now we have reached the end of our show. So, Ira, it was greatly having you. And, I was so happy with today's episode. And how was your experience? This was the first episode on our channel. So,
I enjoyed it very much. It was a pleasure chatting with you. Thank you for hosting me.
me too, me too. It was a pleasure for us too to have you as a guest. So, all right, thank you so much, Attorney Ira Katz, and thank you so much to all the lovely viewers. And don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. We will be here, and we will definitely bring up more different insights, more different topics for you to understand more about the reality behind H1B workers and companies. Thank you so much, guys, for everyone joining us. I'm Sam signing off for now.
Welcome everyone to Immigration and Jobs Talk Show, and I'm very happy to have you all join us today. I'm Napasa Pradhan, and I'm going to be your host for this session. And before we move ahead, I have this important disclaimer, and that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, it's really very fantastic to have all of you join us today. We are streaming live right now on YouTube, LinkedIn, and Facebook. And I'm very excited to tell you that this could also be a very participative session. All you have to do is type in whatever questions you have in the comment section, and we'll be very happy to take them up in this session later. For sure. And today we are going to dive into this very important discussion on this topic. Can product managers and software engineers qualify for the EB1A visa? And it's a topic that is especially relevant for highly skilled professionals out there in the tech industry. And of course, I am very excited today because we are going to have one of our very special guests back with us, joining us after months, really. I think we met last before summer. So please help me welcome attorney Prashant Dubey once again back here on Immigration and Jobs Talk Show. Prashant, really happy to see you after a real long time, and really good to have you here. Thank you for joining us.
Yeah, no, thank you. Thank you to the Higher IT team for welcoming me back, right? And having me on another episode, another webinar. Thank you, Nabasa, Zayed. Thank you for all the technical work you do in the background. I'm sure I'm going to have one technical difficulty at least. Otherwise, it would not be a webinar where I have participated. So if I pivot to my phone, don't be surprised at some point. But glad to be back.
Very glad to have you back with us, Prashant. And so, yes, today's topic, what can folks out there expect from us today?
Yeah. So today, one of the reasons why I think this webinar specifically around the EB1A is highly relevant, right? I know we've done a series of webinars before on this topic specifically, and it was very high level, right? Can folks in IT qualify for the EB1A, for example? And we talked about the EB1A process, application requirements, how people qualify. And I think this is a really good opportunity to start double clicking on very specific profiles, right? So for example, for today, we're going to be discussing how product managers, how software engineers specifically qualify. And I know behind the scenes, we were discussing, doing an episode for like cybersecurity folks, data engineers, that sort of thing. And over the last several months, one of the reasons why I kind of disappeared from these webinars is because that this part of my practice has really started to scale. And the reason was pretty straightforward. So since October 2022, EB1As have become a very hot topic, right? Ever since the retrogressions and priority dates happened. And I was working with one or two clients at a time over the last couple of years to help them get their EB1As approved. What happened earlier this year around the May, June timeframe, one of my clients who got his EB1A approved, he works at Meta. He went and posted internally in a Meta forum about his success with our firm, and then things just kind of exploded from there, right? So over the last, I would say 5 or 6 months, I've probably done twice as many EB1As as I did in my first, my last couple of years, where I've noticed this become a trend. Lots of consultations, calls. And so it's a really interesting time, at least for me, and I think the EB1A community, because there's a lot of best practices that I feel like I'm now uncovering as I'm doing this at a much larger scale, and with many, many more types of clients and different profiles and different case studies that I can bring to the table today, right? And of course, there have been some changes as of October in how USCIS is going to be looking at the EB1 criteria, and we can get into that. And then, of course, I know there's a lot of anxiety around, the presidential election and the recent results,
Right.
and we can talk about that too.
I was just coming to that, and I think before we head on to today's topic, maybe you could tell us how Donald Trump being elected the 47th U.S. president is going to affect even this category of visas, and it'll be great your point of view on this as well, Prashant.
Yeah. So there's a couple things to that. One is just like my personal experience, right? So like the very first EB1A I ever filed was for a dentist, and it was during the height of the Trump administration about 4.5 years ago, right? And he got approved just fine, right? I think when it comes to the next administration, what I saw previously between 2016 and 2020 was that there was impact for EB2 and EB3 candidates, right? Even H1B candidates. Reason being that there are different areas of that process where they can really influence what's happening, right? And what I mean by that is in EB2 and EB3, you have things like the prevailing wage determination, right? So they can slow that down. You have things like the recruitment process, right, which can really come back and hurt you, let's say at the I-140 stage. They have the perm application itself, in which they can increase their audits, right? And those are the types of things that we saw the Trump administration do previously, right? When it comes to EB1As and EB2 NIWs, I think any administration has a very keen interest in keeping the best and brightest people here in the US, right? And if you look at his rhetoric, it is all about, potentially changing rules, regulations as it relates to maybe asylum seekers, people illegally entering the country, right? But when it comes to these merit-based applications or these merit-based benefits like the EB1A, like the EB2 NIW, he really that's not a part of his rhetoric, right? I don't expect there to be a whole lot of impact for my EB1A and EB2 NIW clients, because this is a self-petition, right? These applications go directly to USCIS. You have nothing to do with the Department of Labor, so there's nothing they can influence there. It's just you and the officer and the case you present, in front of them, right? So I'd say from that perspective, I hope people aren't as anxious as maybe they might be coming off for EB1As and EB2 NIWs.
But definitely, I think everyone is anxious, especially immigrants out there, like what's going to happen. Some are really maybe even taking up actions before things get worse for them.
Yeah.
I mean, that's what their thought process is, I guess. So a lot of things are happening. I think people are still processing the whole information, Prashant.
Yeah, and I'm seeing it too, right? Like I've got clients who are like, can you take my case now? And I'm like, the earliest I can take it is at least January, right? Like I'm working with a cohort of people, that sort of thing. And I'm seeing a sense of urgency where people want to try and apply right away. And like our timelines are just not matching up, right? And that's okay. But I am seeing that sense of urgency where people are worried. But I think it might be a little overdone.
For sure. But let's head on to today's topic, and I got some questions prepared. So, Prashant, if you could just tell us, how might product managers and software engineers qualify for the EB1A visa? And this requires evidence for extraordinary ability in their fields. And what impact might Trump's previous stance on merit-based immigration have on their chances?
Yeah, I think that second piece I kind of covered in the first response, right? I think based on his rhetoric, whether it was the previous, from 2016 to 2020, or let's say 2024 or 2025 and, moving forward, I don't see an impact on merit-based applications, right? Especially not EB1As and not EB2NIWs. Again, any administration has a very high interest in keeping the best and brightest here in the US. Now, when it comes to qualifying, right, for the EB1A, for example, for product managers and software engineers, let's take the product manager profile first, right? Product managers are very interesting individuals because they sit at the intersection of IT and business, right? So one advantage that product managers have is that they can very easily and often, do very easily communicate the business outcomes that are driving their projects, right? The KPIs associated with it. What is the organizational impact? What kind of impact is my work having on the industry, right? And when you sit at that intersection, it's really important for at least two of the criteria: critical and leading role for a distinguished organization. Second one is original business contributions, right? Because we want to be able to prove that the work that somebody's doing is important at an organizational level, right? We want to be able to prove that the work that they're doing is innovative and also influential in the industry. So I think for those criteria, right off the bat, product managers are really well situated to satisfy those requirements. I recently had a product manager that I worked with. He's at Meta. He works specifically with networking technologies. Okay. And for him, we argued on four criteria: critical and leading role, original business contributions, judging the work of others, and then salary, right? And I often see for product managers, those are the four criteria that they are satisfying, that they are hitting, right? Most commonly. There might be others like memberships, awards, authorship, depending on the makeup of the profile. But at a baseline, those are the four that I typically see come across my desk, right? And, it's important, I would say, for critical and leading role to raise your projects that you've worked on to an organizational level, right? What was the organizational impact? What was the dollar amount impact? How much cost savings did you achieve? How many manual labor hours did you reduce, for example, right? And then for original business contributions, one of the things I want people to think about is raising it to an industry level. So not only, what you worked on was innovative, but how was it adapted maybe by other organizations, other companies out in the field, right? And for that, one of the best ways to showcase it is expert opinion letters. So recently, one of my new best practices is to kind of urge my clients, go and find one or two individuals out in the industry who are experts in their field. And an expert can mean many different things to many different USCIS officers. For some officers, an expert is somebody who has a Google Scholar profile with over 1,000 citations. Go find that individual. They might already be in your network. They might already be in your chain of command. An expert can also be somebody who is a thought leader, right? They pop up frequently in news media for, comments about what is happening in the industry. And what I'm finding is, as my practice has scaled over the last 5 to 6 months, the individuals that the one or two individuals that, received an RFE for whom I filed versus the individuals who had comparable profiles, right? That we filed and got approved, that was the difference. Those 1 to 2 letters of recommendations from renowned industry experts is what pushed those approvals over the edge, even though the profiles were similar, right? Didn't matter if it was a product manager, didn't matter if it was a software engineer, but that is something I'm seeing is really helping to set people apart, is having those strong letters of recommendations for your original business contributions criteria. For software engineers, it's very similar, right? We still need to prove that your work is critical at an organizational level. We still need to prove that the work you're doing and it's innovative, right? And you can do that in separate ways. Some clients of mine, they have patents. Some of them have papers, research papers or conference papers associated with those projects. Some of them have open source work, right? That they can point to and say, hey, the work I've done is laying the foundation for other developers to build on top of it, right? I sometimes have clients who come in who have done code reviews, right? Technical reviews out in the industry. I've had clients who will maybe go to freecodecamp.org and they will write blog posts about best practices, for example, in C++ programming, right? So there's different ways that you can come at the criteria that are kind of outside the box of just your traditional research, academic, PhD background. So that was kind of the TLDR of that answer.
Thank you so much, Prashant. I mean, that was pretty detailed and what we really need. Thank you so much for walking us through all these highlights that we really need to keep in mind. And at this moment, Prashant, we've got some friends who've joined us and who are commenting. So I'll just quickly say hi to them. It's My Channel says, good morning, Prashant. And then we have Kavya's questions. We have Amarjeet. Folks out there, please stay with us. We are going to touch up on your questions very, very soon. And yeah, thank you so much. Okay, Amarjeet. No, okay. Let's head on with our questions. I have one more question for you, Prashant, and that is, what level of professional achievement or recognition is generally required for software engineers and product managers to be considered for EB1A eligibility?
Yeah. And this is kind of a sliding scales question, right? And what I mean by that is in terms of what qualifies somebody from a recognition perspective can mean many, many different things, right? Recognition can be somebody that has multiple papers and research articles published. It can be somebody that has multiple conference papers, multiple blog posts. It can be somebody that has a very robust GitHub repository, for example, somebody that is very much involved in the Android developer community, for example. And recognition can also be thought leadership. And I like to call thought leadership basically like your speaking engagements, right? I do have clients who are invited to speak to DroidCon, right? Or they are invited to speak to at AWS reInvent. These really big industry conferences. Cisco Live is another one of them, right? So recognition can take many different forms. Recognition can also be, how is your work being adapted in the industry? So if you don't have patents, that's fine. But if you have somebody that is talking about how they've taken, your technical work, learnings from you and adapted it in their own workplace or in their own organization, all of a sudden that becomes very impactful, right? But, I always recommend, like, if you want to get recognition in the field, think about in your industry, what podcasts can you be a part of, right? And for product managers, there are multiple podcasts. There's some at the product school. There's one called Exponent. There's a podcast that's done by an individual over at University of Washington. You can participate in those sorts of avenues, if you're a product manager, to really get your thought leadership and your recognition out there, right? And that will help you from a final merits perspective. If you're typically, what I see my developers, what they've done is they're typically speaking at these industry conferences or even academic conferences about the work that they've done, right? And that will help you build your thought leadership, right? And the type of conference you present at is going to depend on your profile. For example, I had an Android developer who presented at DroidCon, right? I had a machine learning engineering manager from Pinterest who presented at AWS reInvent because he built their machine learning platform in partnership with AWS, right? So it made sense that he was presenting there. In addition to that, he had about 3 or 4 other conference speaking engagements within his industry, within his specific line of work, right? So this is going to be very relevant and kind of particular to the makeup of what your EB1A profile is and the story that you're trying to tell, right? It doesn't make sense to go and present in a conference that's about graphics technologies, for example, if you don't work in that space, right? Or if you're a data engineering doing AI/ML work on recommendation systems, right? Has to be very relevant. You have to find those opportunities that make sense for your story.
Definitely, without any doubt. Thank you so much, Prashant. And, I would really like to take it's my channel's question for now. So let's go for it. 2 design patents, one IEEE paper publication, reviewed or judged 3 technical papers. Can I still qualify in the expert category, or what is your suggestion to make this profile more stronger? And what are
Yeah.
the areas that I can add?
Yeah. So I think with the design patents, right, we would need to learn, hey, do you have any citations associated with them, right? That's going to be important. Same with your IEEE paper. If you have 2 patents and 1 paper, but you have 50, 60, 70, 100 citations, that shows that it's very impactful work, right? So your next step should be the people that have cited your work, cited your patent, cited your papers, identify the individuals that are, really renowned. And what I mean by that, are they academic experts? Is somebody there who has, cited your paper that has over 1,000 citations on Google Scholar, or has a lot of media attention, for example, for the work he's done? And can you potentially get a letter of recommendation signed from that individual, right? I think reviewing and judging 3 technical papers, that's fine. I would always urge you to do more, right? Because, I'm seeing my clients and they're reviewing 30, 40, 50 conference papers, right? So if you think about it, that is who you're going up against, right? So I would say do as much as you can when it comes to the technical review work in as many prestigious conferences as possible. And you can very easily find the prestige of a conference by going to research.com, right? And searching, for example, within the field of computer science, what the ranking is. If they're not even on research.com, you should seriously consider whether it's worth pursuing that opportunity. In addition to that, one more thing I want to mention, don't be disheartened by the fact that you only have a couple of patents, right? Because I had a CRM engineer from Salesforce, 1 patent, 4 citations. That was it, right? But what we went and did was we drafted a letter of recommendation from an individual that cited to his patent that talked about how they took inspiration from his patent and the work that he did, right? So if you can get a letter of recommendation like that, obviously the patent proves that your work is original. We also need to prove that it's influential, right? And so that letter helped us show that his 1 patent was influential in the industry, and he did end up getting the EB1A approval. So not somebody that had a robust patent or research background, but somebody who was able to prove that the one thing he did in the way of a patent was influential. Somebody did take inspiration from it, right? So just something to think about in terms of how you build your profile moving forward.
Yes, very much. Thank you so much for highlighting that, Prashant. And I think it's very important to make your profile stronger and as attractive as possible, I think. So thank you
Yeah.
for that tip, Prashant. And thank you, It's My Channel, for participating. Please keep commenting if you have any further questions. And now I think we should take up another question, and this is from Kavya. Kavya is saying, my contributions are mostly collaborative, working as part of a team rather than leading solo efforts. Can I still qualify for EB1A? And does the process amount for team-based achievements, or do I need to show individual recognition? And there's
Yeah,
another
good
question,
question.
but okay, we'll take that later.
Yeah, good question. So no one is a one-man army, right? Like none of my clients have ever operated in a vacuum, right? Like you're either a software developer or a data engineer or a cybersecurity person or a product manager, but you're not everything, right? And so you have to keep in mind that what we tried to highlight in an EB1A is your specific contributions, your specific technical tasks, your specific original contributions or innovative contributions, right? Um, if you're an author on a paper, you might be a co-author, right? But that doesn't mean that you didn't contribute to it just because you were in a team-based or collaborative environment. 99% of the time, that is absolutely the case, right? And that's okay. But what we like to extract by way of letters of recommendations is your specific contribution to that project, right? And my job is to make it seem like you did everything, right? As your attorney, as somebody that's going to represent you, right? I'm not here to talk about what your team did, right? I'm here to talk about the impact you had, your specific technical contributions, and then connecting it to an organizational level impact, connecting it to any news publications, any media, anything of that sort that has, like the project you've worked on, if it's gotten that attention, then we leverage those as exhibits, right? And I'll give you an example here. I work with many clients from Meta's AR/VR team, right? Meta's Reality Labs team. You can find a lot of news publications out there about how, Mark Zuckerberg has basically created like a 10-year roadmap or a 5-year roadmap for the Reality Labs team, how it's important to Meta's organizational goals and strategies, right? So automatically we know that if you're working on a project for AR/VR at Meta, it is organizationally important. It is important at a CEO level, right? And we've got news publications to prove that. If you are working specifically, let's say, within the wearable devices vertical of Reality Labs, right? I've had a client who does that. There's news publications out there, right, about the innovative nature of the wearable devices strategy that Meta has, right? So we automatically, can connect it to something that's newsworthy, talking about the fact that your work is innovative and also influential because it's going to impact the millions of customers that are buying the Quest headsets, right? So again, none of this happens in vacuum, right? But our job, my job, is to extract the specific details related to your specific contributions, connect them to those higher level organizational goals, connect them to those news publications that are talking about how this work is important at an industry level, right? So that's what I would say. Anybody can really qualify for the EB1A. We just need to highlight your specific contributions.
Right. And what about this last part of the question that she had, that Kavya had? How can I highlight my role and impact within a collaborative setting? Any
Yeah.
tips?
Yeah. So what I do is I always send my clients a worksheet, right? So like we get on a consultation call, I learn a little bit about you. I either say you're ready to move forward or you have more work to do, right? I'm going to be very transparent about that because the last thing I want is a bad customer experience, right? I don't want you to think you qualify for something you very clearly don't, right? And in that worksheet, I extract those details, right? What were your specific contributions? What were your specific technical tasks? What was the organizational outcome that you were trying to achieve? And we draft letters of recommendations around that, right? Letters of recommendations can come from your managers, they can come from members of cross-functional teams, they can come from peers. If you work with end clients, right? So for example, I've had some clients who are management consultants, let's say at one of the big SI firms. You might get a letter from one of your end clients talking about the work that you've done and how it was impactful, right? So that's how we come at it. In addition to that, I find that my clients are very good at leveraging their performance reviews, right? So if we are talking about a specific project that you've worked on, more often than not, your work on that project is also being captured in a performance review. So we can add that as a layer of an exhibit stating, hey, here's this LOR saying what this person specifically did, how they are furthering these organizational or industry-wide outcomes. And oh, by the way, here's a performance review talking about, in addition, like all the stellar work that they did for this project, right? That becomes another objective piece of evidence.
Thank you so much, Prashant, for the detailed explanation for Kavya. And Kavya, I hope you've gotten all your answers. And we have It's My Channel back again saying, perfect. Thank you so much. And we have Dan Nandan saying his explanation is very clear and sounds like a radio personality for sure. I mean, really, Prashant, for sure. Very, very clear in how you explain. And now we have another question from It's My Channel asking, I would like to ask one more question on the memberships. Do you have any suggestions other than the IEEE or BCS?
Yeah. So here's the thing about memberships. If you don't have a research background, in the sense that if you're not doing journal papers, conference papers, you're not doing blog posts, you're not reviewing conference papers or journal publications, IEEE really doesn't make sense, right? And neither does IET. IET is another technology kind of research organization. And both IEEE and IET only make sense for people if they have that research profile. Otherwise, it just looks like a check the box exercise. And when I see that with a client, I tell them, like, I'm not going to use this as a membership. You need to go do some review work, right? You need to go do some authorship. And that way your membership is going to look good, right? In terms of professional organizations, BCS is obviously the one that I see come across my desk most often. There are others, Royal Society of Arts being one of them. There's one called Sigma G or Sigma Chi, right? XI, that I also see my clients leverage. What I'll say is this: memberships is oftentimes one of the most difficult criteria. Membership and awards is two of the most difficult criteria to satisfy, right? So if you're going after it, just make sure that the organization you're going after fits your profile. If you don't have a research profile, don't do IEEE, don't do IET. If you have a professional profile and BCS might be taking too long, go and explore the Sigma Chi, go and explore, for example, Forbes Technology Council or Royal Society of Arts. That those will help you satisfy the membership requirements. And then high level, one of the things I want to say about memberships is USCIS really cares about the organization's bylaws. Okay. Bylaws are extremely important. Don't go and join an organization that has not memorialized their process into some sort of governance document or some form of bylaws that says this is the criteria that you need to satisfy the membership, right? These are the outstanding contributions we require of our members. In addition, take it one step further. Make sure the bylaws also discuss who qualifies to make those decisions about membership, right? That's very important. Some USCIS officers like to see those details. Where in the bylaws does it say this is the selection criteria? Where in the bylaws does it say these are the people that are going to be making those decisions, and these are the qualifications required for the membership committee, so to speak? And then the third one, what are the qualifications of that membership committee, right? So that information also then needs to be publicly available. So you want to be very careful with memberships because there's many pitfalls there, right? It's not just enough to go and get it. You need to be able to support your membership with bylaws and governance documents and all of those different pieces of information.
Thank you so much, Prashant, for taking that up. And we have some more questions. Let's take up Nirvana's question now. This is next on YouTube. Nirvana is asking, when talking of high salary, When talking of high salary criteria, how much we are talking of? Does officers go with what is mentioned in the LCA?
Okay. Level 1 to 4 wage means nothing to me in EB1A, and I think it means nothing to a USCIS officer, right? I have had clients who will try to argue with me that you should, include my salary criteria as criteria number 6 or 7, um, because it's a level 3 or a level 4 wage. It means nothing, right? There's no point of reference, right? And what I mean by that is there is better data out there. Bureau of Labor Statistics specifically talks about what the 90th percentile of software developers, product managers who can be qualified in the SOC code of marketing managers or IT project managers, depending on your role, data scientists, for example, all of the statistics are available on government wage databases, right? So Bureau of Labor Statistics, Career One Stop, ONET. I always start there. If you are not in the 90th percentile in one of those three, salary is a no-go, right? Because on the USCIS policy manual for salary, those are the three that they list right off the bat. Like, this is the starting point, right? In addition to that, we provide commercial wage data. Glassdoor, Indeed, ZipRecruiter, Levels, PayScale, Salary.com, right? Those further substantiate the fact that from a commercial perspective, this person's in the top 10%, right? And they also have those sorts of point of references like top 10%. ZipRecruiter actually takes it a step further and can even get as granular, I think, as like top 3%, which is great. Now, the third layer of exhibits we provide for salary, and this is something I had to learn over the last 5 to 6 months, because I was only doing that level 1 and level 2, which was the government wage data, the commercial wage data. I've now turned it up a notch with the level 3 wage data, in the sense, and I use level 3 very interchangeably here. I don't mean level 3 as like the LCA, but I use level 3 as in a third tier of exhibits that we're providing is related to professional organizations, right? So, for example, there are staffing agencies out there that are well reputed. Robert Half, for example, ranked as a top 5 staffing agency by Forbes. Mondo, ranked as one of the best IT search firms in the country. These organizations, they provide wage data based on their placements, right? So now I've been starting to provide professional organizational wage data as well to further substantiate the salary criteria. I don't care what's on the LCA, right? Like, baseline, you got to start with the government wage database first.
Thank you so
How
much for
much
that,
total?
Prashant. And yeah, and Nirvana is saying one more. I see a lot of PR agencies. Is it lawful to take help from them?
I laugh at this one because don't work with the PR agencies. I apologize to all the PR agencies out there, but the problem is they will get you posted on USA Today. They will get you posted on Tech Times. They'll get you posted on Tech Bullion, right? MSN, Benzinga, et cetera, et cetera. The problem is, after every article or at the beginning of every article, they put a disclaimer that's there that says, this is not the opinion of USA Today. And that's a problem, right? Because all of a sudden, we're arguing on the publications about you criteria, and it automatically gets discredited by the fact that USA Today is saying, hey, I didn't put this out into the world, right? Like somebody else did. You're going to have a world of a problem, very incremental value, right? So do not pay PR agencies to get you posted somewhere, because it will backfire, right? Like, those disclaimers are only going to hurt you, and they're everywhere, right? So save your money, spend your time elsewhere.
Okay. And what about, what he asked earlier? How much total criteria should be enough? Well, that is a question. And does too many of them pose threat of for RFE as well?
Yeah. So, like, here's my best practice, right? I like to go in with a minimum of 4, right? I never go in with just 3. I learned pretty early on going in with just 3 puts you at a disadvantage, because if USCIS RFE is one of them, right, you don't have much background, right? If you go in with at least 4, and let's say 3 of them are very strong, right, and one of them is 50-50 or a little weak, you still have a good chance of approval, right? 4 and above, your chances of approval, from what I've seen, go up significantly, right? In terms of having too many criteria, what I would say is, if you can comfortably argue on 6 or 7 because you qualify for them, do it, right? If you can put forth a reasonable argument for 6 or 7 criteria, that's totally, but don't try to do something underhanded, right? So, for example, don't try to make criteria number 6 or 7 salary when the government wage database clearly says you're not in the 90th percentile, right? Don't try to slip something past an officer from a criteria perspective, which is going to discredit the rest of your application, because then they're going to start thinking, oh, they're trying to convince me of something that, like, very clearly they don't qualify for. What else are they trying to convince me of, right? So I think the most I ever argued on was 7. And I even told the client, like, look, 2 of them are pretty weak, 5 of them are very strong, right? And I think those are the 5 that are going to carry you at the end of the day, right? And they probably did, because he ended up getting the approval. And you don't know which criteria you end up satisfying when it's an approval, but you know, I know pretty early on in terms of, like, which one's actually gonna resonate with USCIS, and which ones are not, right? Argue for as many as you possibly can, as long as it's within reason, right? And as long as you can put forth a good argument.
Mm-hmm. Right. Thank you so much, Prashant. And those were really insightful tips and advices. Also, thank you so much, Nirvana. I hope that you've gotten most of all your questions answered. And if you have any more doubt, you can keep commenting. Well, it's my channel also said that that's a long list, but thank you, Prashant, he says. Anyway, I have a few more questions, Prashant. I think I'll share my screen for now so that we can take them up. I was telling you about some of our Facebook groups, so this will be easier. All right. So let's go with this first one. This is an anonymous participant asking, has anyone here worked with, I'm looking for filing my EB1A petition and would like some thought. Okay, not this, this one. Is the interview backlog different for EB2NIW and EB1A? Does anyone have any idea of which dates are scheduled for EB1A interviews at the Islamabad Embassy or Abu Dhabi Embassy?
Yeah. So what I can say, like, at least speaking from the perspective for individuals within the US, because that tends to be 99% of my clientele, you don't have an interview for the EB1A or the EB2NIW, the EB2 or EB3, right? The only time I've ever seen employment-based petitions get an interview is if, let's say, somebody changes a job, for example, right? And the USCIS officer would like to verify that they are continuing to, let's say, work for that new employer, right? But none of my EB1A or EB2NIW clients have ever gotten an interview from within the US. Now, if you do consular processing and you're doing your interview from abroad, yes, the entire process of consular processing involves a visa interview with a visa officer, right? So it's slightly harder, I would say, when you're doing it from abroad. But in terms of specific timelines for those 2 embassies, would not be able to tell you.
All right. Thank you, Prashant, for taking that up. Now I have this next question. This is, please help on where to publish articles for EB1A, or let me know which journals are eligible. Thanks in advance.
Yeah. So this is dependent on a couple different things. One is just your overall profile, right? Are you a software developer that's working within the Android ecosystem? Are you a data engineer working with AIML, right? Are you a developer working with AR, VR technologies, right? And graphics technologies? Are you a UX designer, right? Because the answer is going to change with each of those profiles, right? I recently had a data engineer who got approved for the EB1A just this week, actually. The articles he came to me with was published in an electrical engineering journal. And when we were working on his analysis and all of his exhibits, he called it out. He said, "Hey, you missed this article." And I was like, "I'm not going to include it. It's an electrical engineering journal, right? It has nothing to do with data engineering and the work you've done, right?" And it breaks the continuity of your story. So what I would suggest is if you go to the IEEE website, right? IEEE has a list of conferences that they sponsor. Research those conferences, right? Type in the conference name, type in the word ranking. Research.com will tell you its ranking if it's ranked. Those are the types of conferences or journals that you want to be publishing in, right? The ones that are known, they're reputable, they have a peer review process, for example, right? That is what I would suggest. Now, let's say you feel the journal writing process, the conference paper writing process is very tedious. I've had clients tell me that. Totally fine. There are other avenues out there to satisfy the authorship criteria. For example, freecodecamp.org. Free Code Camp is a nonprofit organization, right? And they teach people how to code for free. And in order to even qualify to be a blog writer on Free Code Camp, you have to go through a vetting process. I think they only accept 30% of their applications. But the great thing about it is if you go to their LinkedIn page, 60, 70,000 people claim that they learned coding from Free Code Camp. And they will also help promote your blog posts, right? And your technical articles. That is another way to satisfy the authorship criteria, right? Doesn't have to be journals, doesn't have to be conference papers. You can get creative with it. I've had clients from Pinterest, from Meta, from Amazon, where these organizations have channels to publish technical blogs, right? And I've had clients participate in those technical blog process, and they're able to show me that, hey, these blogs are getting viewership, right? They reach out to those marketing teams internally, they find the viewership statistics, and we provide that as an exhibit to show that, hey, this person is authoring scholarly articles. It's just not in the traditional sense, right? But it is for individuals that might be, the intended audience is a data engineer, cybersecurity professional, whatever that might be, right? Another way to think about it is trade publications. So I have had folks in cybersecurity who do co-authorship with the Cloud Security Alliance, for example, right? So there's different ways to think than your traditional, journal papers, conference papers. But if that's the route you go, just be sure that those conference papers, those journals, those conferences and journals are like reputed, they're ranked on like research.com, for example.
Awesome. Thank you so much, Prashant, for, giving us that insight. And now we have Vibhor asking, my company is 1 year old in Washington. Can I apply for L1A visa via road through Canada and I'm a Canadian citizen? I think the answer is yes. Once I get L1A approved, question is, can EB1C be processed quickly by paying money? And can I get green card within a year? Do you want to take this up? It's not EB1A.
I can answer the question totally fine. So with regards to EB1C and the EB1 categories, right? One of the things you want to keep in mind is the priority dates right now, I believe, are in 2022, right? So if you are coming on an L1A, right, as an executive, you can absolutely apply for your EB1C 1 year, let's say, after you enter the country, and you continue to maintain your managerial, executive capacity and executive duties, right? or really whenever your company is ready to apply for it. So as long as in the previous 3 years, for one of those years you were employed abroad, let's say in Canada, you come back as an executive to the US, your company can apply for an EB1C for you. Okay. Now, if your priority date, let's say, is January 1st, 2025, just hypothetically speaking, right? If it's January 1st, 2025, in the EB1 category, you are probably not going to be eligible to get your green card within 1 year because your priority date is not, 2022 and before that, right? Or whatever it might be in the future. Chances are, if you get a priority date that is 2025, for example, you might be waiting 2 or 3 years before you can even apply for your 485 applications and get your green card, right? It's just how the priority dates work. In EB1 category right now, they are not current.
Thank you so much, Prashant, for taking that up. And I have one more question from one of our previous shows with you, EB1A, building a profile to qualify for EB1A category. And we had Arjun asking, saying that it was a very good session. And he had one question. How about the applicant had suitable criteria for EB1A 15 years ago, but now he is into different job sector and current situation is not suitable for the criteria? Can this still be a valid case for EB1A petition?
Yeah. So the thing about it is USCIS wants to see it over a sustained period of time, right? If you did something 15 years ago, let's say a whole lot of research, right? A whole lot of reviewing the work of others, but then there's a 15-year gap. One of the things that some very hardline USCIS officers like to see is that the work you did was over a sustained period of time, right? So critical and leading role over a sustained period of time, judging the work of others over a sustained period of time. If there's a significant gap like that of 15 years, I think that's going to be challenging for an EB1A, right? Unless, your authorship and judging the work of others criteria, which I'm just going to assume happened 15 years ago, right? For purposes of this question, if you have 3 or 4 other strong criteria and those 2 are kind of weak because they happened a decade and a half ago, I think you'll probably be okay. But if you only have 3 or 4 criteria and those are 2 of them, you're going to have a problem, right? I don't think that EB1A application would get approved.
Thank you so much, Prashant, for taking that up. And we had more questions, but I think we're good for now. I think I've taken up most of them. So we'll move back to our questions, Prashant, now. And I have this next question for you. So my next question is, what role does professional networking and peer testimonials play in an EB1A application? And are there any best practices for product managers and software engineers to secure strong endorsements? You've already highlighted some of how these testimonials or recommendations play a very important role. So if you could just tell us more about the endorsement part.
Yeah, absolutely. So I think there's a few different ways, right? So one way that I use endorsements is like sometimes my clients have LinkedIn recommendations, right? 10, 15, 20 LinkedIn recommendations. And I leverage that from a final merits perspective, right? So I'll give you an example. I have had clients who have participated in those thought leadership engagements, right? So they've been invited to speak at conferences, or maybe they've been invited to speak on podcasts. In addition to that, I highlight the fact that, hey, not only are they getting this industry recognition through these speaking engagements, but they're also recognized by their peers. Look at these LinkedIn recommendations accumulated, right? So I would say if you don't already have them, start thinking about, asking people for LinkedIn recommendations, right? Specifically related to the work you've done, specifically related to the capacity in which you interacted with them, right? It can only help you, certainly will not hurt you, okay? Another thing is I would say, folks tend to burn bridges very quickly, right? So you leave a job, you kind of forget about your previous manager, you forget about your previous colleagues, and that's natural. It happens. One of the best individuals, one of my best clients that I've seen really do this well, he built relationships over the last decade. And he was able to go back to his manager, a couple of colleagues from his time when he was an intern at Meta from 2013, when Meta was called Facebook, right? He was able to go back to that time and get letters of recommendations from people from 2013. And it's because his relationship building and maintaining skills were just exceptional, right? So you want to make sure that you are doing that so that when the time is right, when the time comes, people that you have networked with, the people that you have worked with are willing to sign off on those letter of recommendations for you, as opposed to saying, like, why are you coming back to me 10 years later? Right? Build and maintain relationships, right? If there are think tanks, if there are organizations in your industry that attract the type of professional you are, get involved, volunteer, build those relationships, make sure they get to know you and you get to know them, right? Because at the end of the day, if you can build one or two of those relationships like that from renowned experts in the field, right? Those people that have the media publication, the media attention, the people that have the Google Scholar profiles that are very reputable and very much recognized, those become very powerful LORs for you. So build relationships, maintain relationships, at least for individuals that you identify can help you with your EB1A application later on.
For sure. Thank you so much, Prashant. And do you have any success stories or anything along these lines that you would like to share with us before we leave today?
Yeah. So I send out a monthly newsletter, and in that newsletter, I like to highlight. Nowadays, it's basically just all taken up by EB1A. But I like to highlight in those newsletters, some of the success stories that I've been seeing. And of course, it encourages other people, right? They see other people's profiles who are going through the EB1A process and they become encouraged themselves, for example, right? So I will share a couple of those success stories from this month. So this month, we've gotten 3 new approvals. Those have not gone out in my November newsletter because my newsletter goes out at the end of the month. One of them is a data engineer, right? And one of the things that he did in terms of satisfying criteria for awards, he had the Business Mint Awards and the Global Recognition Awards. I don't think that's one of the reasons why he got his EB1A, though. We also argued on critical and leading role. So he had implemented certain projects, for example, in the state of California, as it related to their electric metering system and modernizing that system, right? So not only was that project important for the organization that he worked for and that he was contracted out for, but it was also innovative and influential, right? Because it was impacting millions of customers in California. Mm-hmm. He had judging the work of others, right? So he had done conference paper reviews, journal reviews, in data engineering related conferences and publications. He also had authorship, right? So he had worked on papers that had accumulated over 170 citations over the last couple of years, right? Salary was not one that we argued on for him, right? So based on that profile, he got approved. I had a client from Meta who got approved this month. He is a AI ML engineer, and this individual was very notable in the sense that he had about 10 patents, I believe, 10 or 13 patents that had been cited over 100 times in the industry. He also had a couple of conference papers that kind of memorialized the work he was doing at Meta. And so for him, critical and leading role, yes, right? We were able to prove that the work he was doing was important at an organizational level, right? Because if you think about it, everything within Meta, is the engine behind it is recommendation systems. So the next reel that you see, the next post that you see, it's all recommendation systems. His patents helped with original business contributions. The letters of recommendations that we drafted for him were from professionals in the industry that had over 1,000 citations each, right? And we had 3 or 4 letters like that. He had salary, he had judging the work of others, he had authorship because of those conference papers, and also original scholarly contributions because those conference papers were well cited. So we argued on about 5 criteria for him, and he also went through the process just fine, right? So I think, to kind of like tie a neat little bow on it, you don't have to have a PhD. You don't need to be an academic to get an EB1A, right? And that individual who I just told you the story about, who had like the 10 or 13 patents, in our consultation call, he was like, I don't think I qualify. And I was like, no, I think you do, right? Like, I think you've been told that this is what a certain profile should be for the EB1A. I think you've been told that 100 citations don't qualify, right? But in fact, it does if we, build everything carefully, if we demonstrate your industry impact carefully, we demonstrate your organizational impact carefully, I think you're going to get this. And he did, right? So there's a lot of misconceptions out there about who qualifies for the EB1A, right? And it's really important to know that anyone can build a profile towards an EB1A. Might take you a little bit of time, but you can do it.
Thank you so much, Prashant. That was really very insightful, and thank you for sharing your. On the other hand, it's also your success story. Your client success story is also your success story. So definitely, it was really good to hear about that. So. Yeah, lovely having you, by the way. It's been a while, and it was such a great and insightful discussion today we had on the topic, can product managers and software engineers qualify for EB1A? And it was great having your tips today. Prashant, do you have any end note before we wrap up? I mean, it was already great, but anything else you want to leave our audience with?
Yeah. I would say, my parting thought is, or thoughts. One, Nipasa, I told you we would only get through like 4 of our questions because I take 5 minutes to answer like each of them. But I'm glad we were able to answer more questions from the audience. I think the audience definitely found value from that. So thank you, audience, for asking. Thank you to the higher IT team, right, for hosting me and making this a possibility. And also for anybody out there that's looking to explore the EB1A. I don't care if it's you coming to me or to another attorney, right? But don't be discouraged by the fact that you don't have a certain background or you don't have a PhD or you're not an academic, you're not a researcher, because I would say 50% of my clients are not, and they are still getting the EB1A. It just takes some time. It just takes the appropriate amount of preparation. And that's okay because the EB1A, it's a marathon and it's not a race, right? You are going to save yourself decades of GC processing time if you can qualify yourself for this category.
For sure. Thank you so much, Prashant, really. And we highly recommend getting in touch with a qualified immigration attorney, and why not attorney Prashant Dubey as well. And you've got his email address, and his address is how to subscribe for the newsletter. Is there a URL? It's my channel is asking before we go. Yes.
No, but that gives me an idea. I think I should automate the subscription process because right now I just manually enter everybody's email into the newsletter, and it like builds up my audience. So that gave me a great idea. Just email me, please, right? And yes. I will make sure you get my November newsletter and all my newsletters moving forward.
Perfect. And you can email Prashant Dubey. His email address is info@dubeylawoffice.com. You can check out the spelling on the screen and note it down. Thank you so much, Prashant. Really lovely. And since we couldn't cover up most of our questions, we would really love you to join again. And even if not EB1A, we can have many other topics to discuss. If that'll be fine. I'm hoping to have you visit us regularly again.
Yes, that's the idea. Thank you for having me.
Perfect. Thank you so much. Have a great day. Have a great weekend, Prashant.
All right. See you. Bye.
Bye-bye. Thank you, friends. Thank you so much. And before we close, just a quick reminder that if you found today's episode helpful, please do not forget to like, share, and also subscribe to us. We are Immigration and Jobs Talk Show. We are on YouTube, LinkedIn, Facebook, Twitter. We're also there on Instagram. Check us out, and it'll be really lovely to have you join us. And your support helps us bring more expert discussions like these. So hit that bell icon as well so that whenever we have webinars like these, you are notified and you can join us. And in case you have more questions on this topic, you can keep commenting because we would love to get back to you. And of course, stay tuned to our channel, Immigration and Jobs Talk Show, because we have more webinars coming up today. In fact, in just an hour. And also at 4 p.m., we have Daily Immigration Dose, which I join with my co-host, Samriddhi, and it's going to be a great discussion today as well. We just started yesterday. I hope you enjoyed it, and I hope to see you later. So thank you so much for joining us today. Bye-bye for now. It's Nipasa Pradhan signing off from Immigration and Jobs Talk Show.